Final hearing memos.
Question ಬಂದಲ್ಲ
ಏನೋ ಹಾಕಿದ್ರಂತೆ ಕೊಟಲ್ 5 ಮೆಮೊ ಇದು ಕೊಟಲ್ 7ಗೆ ಅಂತ
ಇಲ್ವಲ್ಲ
ಅಲ್ಲಿ ಬರ್ತಾ ಇತ್ತು ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅವಾಗ್ಲೇ.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ
ಏನಾಯ್ತು?
ಇದ್ರಲ್ಲಿಲ್ಲ ಬಿಡಿ ಸರ್.
ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಹಂಗಂತ ವಿಶ್ವಂಗೆ. ಬಿಡಿ ಇದೆ ನೋಟಿಫಿಕೇಶನ್ ಇರ್ಬೇಕಾದ್ರೆ ಇಟ್ಕೊಂಡು ಮುಂದಕ್ಕೆ ನಾನು ಬರ್ಕೊಂಬಿಟ್ಟಿದ್ದೀನಿ ಎಂತಕ್ಕಾದ್ರೂ ಬೇಕು. ಫೈನಲ್ ಇಯರಿಂಗ್ ಎಲ್ಲ ಲಿಸ್ಟ್ ಆಸ್ ಪರ್ ಸೀನಿಯಾರಿಟಿ ಅಂತ ಹಾಕ್ತಾರೆ. ಮೆಮೋಸ್ ಜಾಸ್ತಿ ಬಂದ್ರೆ ಹಂಗೆ ಕೊಡೋದಿಲ್ಲ ಅಂದ್ರೆ ಜ್ವಾಲಾ ಕುಮಾರ್ ಅಸೋಸಿಯೇಷನ್ ಇಲ್ಲಾಂದ್ರೆ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಕೇಳ್ತೀನಿ.
ಕೊಡಿ. Final hearing matters will be listed even if you move according to their seniority. Yes.
Admission. So.
Adjournments, page wise. Page 1, seal number 1 to 3. Page 2, seal number 4 to 7. Page 3, seal number 8 to 11. Page 4, seal number 12 to 16. Page 5, seal number 17 to 20. Page 6, seal number 21 to 26. Page 7, seal number 27 to 32. Page 8, seal number 33. Page 9, seal number 34 to 36. Page 10.
36. Non-filing of ವಕಾಲತ್ by ಸಂತೋಷ್ ಗೋಗಿ. For whom? ಯಾರಿಗೆ ವಕಾಲತ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು? ಸಂತೋಷ್ ಗೋಗಿ ಅವರು. You represent ಸಂತೋಷ್ ಗೋಗಿ. ಯಾರಿಗೆ? For whom you are going to appear? Non-filing of acknowledgement for having served the counsel for the appellant. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ವಾ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? Connected. Awaiting non-filing of acknowledgement for having served the copies on appellant's counsel. Raw subject. MFA then. Which copies they have to serve? Raw subsection. MFA. That is different. I mean, notice to R1. Non-filing copies appellant's counsel. ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ತಗೊಳಕಾದ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ 36.2 ನಲ್ಲಿ ನೋಡೋಣ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಬಹುದು.
Lordships.
ಯಾರು ಮಿಸ್ಟೇಕ್ ಆಗ್ತಿದೆ ಅದಕ್ಕೆ ಸೊ ವಿ ಕ್ಯಾನ್ ಡೈರೆಕ್ಟ್ ಹಿಮ್ ಟು ಟೇಕ್ ನೋಟಿಸ್.
Lordships kindly. Serial number 35, my lord, sir.
Yes, 35.
IAP for the respondent only. May be taken up next week, my lords. I'll go through the LCR records, lordship. Last occasion only the LCR has come.
Anybody? Renuka?
I'll inform to the appellate counsel, Renuka madam.
Renuka,
Requested by counsel for respond about 2 now.
Please, Your Honor. Date may be given.
List on later 2018.
16. 16 one.
For the next 15th or 17th, lordship.
17.
Please, Your Honor.
Page 10, seal number 37 to 39.
I appear for the appellant.
ಹ್ಮ್
And the accommodation.
ಏನು ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಇದೆ ಅಲ್ಲ.
ಅಲ್ಲ, ಮಾಡಿದ್ದೆ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೊಡೋದು ಮಾಡಿದ್ದೀನಿ, ನಾವು ಹಾಕಿರ್ತೇವೆ. ಹಾಗೆ.
ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಅವ್ರದ್ದು ಯಾವ್ದು ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇಲ್ವಾ ಫಾರ್ ಪೇಮೆಂಟ್ ಎಟ್ಸಿಟ್ರಾ ಹ್ಯಾವ್ ಯು ಇನ್ಫಾರ್ಮ್ಡ್ ಹಿಮ್ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ ಎಡ್ಜರ್ಮೆಂಟ್ ಹ್ಯಾವ್ ಯು ಇನ್ಫಾರ್ಮ್ಡ್ ಹಿಮ್ ರೆಸ್ಪಾನ್ಸ್
I will inform, I have some inquiries for the day.
Respondent, my lord.
ಹಾ ಎಡ್ಜರ್ಮೆಂಟ್ ಕೇಳ್ತಾರೆ ಯಾರು ಗೋವಿಂದರಾಜ್ ಜೋಯಿಸ್ ಆಗ್ಬೋದಾ
ತೊಂದರೆ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಪರೆನ್ಸ್ ಕೌನ್ಸಿಲ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 1 week
Please.
ಆದ್ಮೇಲೆ ಯಾವ್ದಾದ್ರು ಕೊಡಿ.
ಆಫ್ಟರ್ 1 week ಅಂತ
Page 11, cell number 40 to 42. Page 12, cell number 43 to 48. Page 13, cell number 49 to 51.
Lord, serial number 49, my lord, appearing for the appellant. Was placed for 2 weeks time, my lord.
you appear for the appellate
Appellant.
2020 ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ ಏನಾದ್ರು
Yes,
ಎನಿ
sir.
ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಇಂಟೀರಿಯಂ ಮೇಂಟೆನೆನ್ಸ್ ಎಟ್ಸೆಟ್ರಾ ಪೆಂಡಿಂಗ್
My lord, I have to, my senior has informed the opposite.
you are not aware of okay as requested by the appellant's counsel list after 1 week yes
Much better.
For orders, cell number 1, Gopal Krishnayan, B. Pradeep for R2.
What is current credit dispensation? Very memo to dispense to this.
R1
Oh.
Pradeep has taken notice for R2
Here is included. The entire incident is admitted.
ನೋಡ್ಕೊಳ್ತೀನಿ. ಮಾಡಿ first check.
respondent to insurance company. Now consider the appellant submits memo for dispensation of notice to respondent number 1. Record show that under the include award liability is fastened to respondent number 2, the insurer. Therefore, notice to respondent number 1 is dispensed with as preferred. 33 days delay in it.
And a month.
Case of
ನಾಳೆದೆಲ್ಲ
death
Death matter.
minus. How much is awarded?
Total 30,54,000.
Hmm.
And 50% contributory attributed to the deceased. Even though the parents are sick against the offending the driver.
Orders on number 1 of 2018. We heard accepting the reasons assigned to explain the delay. Delay of 33 days in filing the appeal is condoned in the interest of justice. I 1 of 2018 is disposed of accordingly. Records ಬೇಕಾಗುತ್ತಲ್ಲ ಹಾಗಿದ್ರೆ
Baker.
admit call for TCRs. List of the rest of TCRs.
Cell number 2, SPP.
I appear for respondent number 1, my lord.
But
Bail
the appellant
application,
statement.
bail application also filed, my lord. He is arrested.
You were on record earlier or not?
Please, my lord.
You were on record earlier or?
No, my lord. Memo has been filed. Memo of appearance has been filed. Yesterday I filed, my lord.
Oh, sir. Registry e ಕಳಿಸಿದ್ರ
Yes.
registry was placed the report of
And 439 and section 70 plus 2 of
SIF Karnataka police station regarding arrest of the first respondent. First respondent refused in execution of the warrant and that he is remanded to judicial custody. Another memo of appearance 72 will survive agate. Now he is arrested and
439 also filed, my lord.
so you do not press this application 72
Please, ma'am. I will press it.
registry has also placed. Memo of appearance filed by Shri S.R. Hemant Kumar. ಇದ್ರಲ್ಲಿ ಹೆಸರು ಬಂದಿಲ್ವಾ ಅವ್ರದ್ದು ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ?
ಇಲ್ಲ ಬಂದಿಲ್ಲ.
For respondent number 1. Party ಮಾಡಬೇಕಾದ್ರೆ. You have not made the victim party.
My lord, I'll make and that during the course of the day, we'll file the appeal memorandum, my lord.
We'll direct you amend it.
Please, my lord.
ಅಂತ ಮೊದಲು ಬರ್ಕೊಡ್ತೀನಿ. The record that the matter involves the offences under the POCSO Act. In view of section 40 of the POCSO Act and the judgment of the Supreme Court in open successor. Victim / informant. ಯಾರು ಇದ್ರಲ್ಲಿ informant? Informant ಯಾರು? Victim herself is informant or?
PW2, my lord, is CW1. That is Manju Nayak, is the father of the victim.
What was the age of the victim? 9th standard ಅಂತ ಇದೆ. Victim / informant has the right of hearing. The records show that PW1 victim was minor and PW2, her father had filed the complaint. Where do we find that PW2 was the complainant? Okay. Name of the complainant, PW2. Okay. Therefore, learned SCP is directed to implead PW2 as respond number 2 in the appeal. Appeal memo shall be amended and amended appeal memo shall be furnished accordingly. ಅದಾದ್ಮೇಲೆ execution of warrant ಅಂತ ಹೇಳ್ತೀವಲ್ಲ ಅದಾದ್ಮೇಲೆ ತಗೊಳ್ಳಿ. Registry has also filed memo of appearance filed by Shri S.R. Hemant Kumar Learned Counsel for the respondent. Respond number 1 ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ.
Respondent 1.
Respond number 1 ಅಲ್ಲಿ implead ಅಂತ ಹೇಳಿದ್ನಲ್ಲ ಅಲ್ಲಿ as respond number 2 ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ. Applications under IA number ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ
439.
IA 1 of 2025 and IA number 2 of 2025 filed by him under section 70 CRPC 70 ಮಾಡಿದ್ದೀರಾ ಈಗ ಅದೇನು ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಇಲ್ವಾ?
Recall
and section 439 CRPC ಇನ್ನು ಹಳೆ ಕೇಸಲ್ಲಿ ಹಾಕ್ತಾ ಇದ್ದೀರಾ? Since the appellant since respond number 1 is already arrested, IA number 1 and of 2025 to recall the warrant does not survive and disposed of accordingly. Yes, ಏನು ಹೇಳ್ತೀರಾ?
My lord, during trial he was on bail, my lord, strict condition may be imposed as and when required.
He was on bail.
No, bail.
Date of
Lordship may
Was in bail.
date of release is 22/4/2015.
judgment.
Judgment is in 2019. No?
Please, my
The records ಏನಿದೆ ಕೇಸ್ ಆಫ್ eloping or
yes, my lord, it is.
eloping?
Same residence.
The records show orders on IA number 2 of 2025 heard. The records show that this is an appeal against the order of acquittal. Since the respond number 1 failed to appear before the court despite service of notice, in execution of the warrant issued by this court, he is arrested and remanded to judicial custody. Records show that he was on bail during the trial. Considering the aforesaid facts and circumstances, respond number 1 is granted bail in the above matter, subject to the following conditions. He shall execute personal bond in a sum of rupees 50,000 and furnish 2 sureties in the like sum to the satisfaction of the trial court. He shall appear before the court whenever required.
Yes.
IA 2 of 2025 disposed of accordingly. Communicate a copy of this order to the concerned trial court and the concerned prisoner.
Lord, there is a delay.
Comply ಮಾಡಿ.
There is a delay of 127.
ಅದೇನು ಆರ್ಡರ್ ಮಾಡಲಿಲ್ವಲ್ಲ ನಾವು ಇವರೆಲ್ಲ ಅದನ್ನ ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು We have to issue notice.
I'll
List in the-
make necessary
Notice
amendments, my lord.
executed,
Notice may be ordered, my lord. I'll make necessary.
ಮಾಡಿದ್ಮೇಲೆ ಮಾಡ್ತೀವಿ ನಾವು ಅದನ್ನ.
Please, my lord, I'll kindly
Please
pass
call.
over.
Wait.
17. 17-1. Seal number 3,
Chobli.
Nagendra Kumar K, Rakshita R.
Yes, I'm appearing for respondent.
Where for appellant?
ಮಲೋಜ್ ಇದರಲ್ಲಿ ಚೆನ್ನೈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿತ್ತು ಮಲೋಜ್ ಇಂಟ್ರಿಮ್ ಮೇಂಟೆನೆನ್ಸ್ ಪೇ ಮಾಡಬೇಕು ಅಂತ ದ ಪೆಟಿಷನ್ ದ ಅಪೆಲೆಂಟ್ ಇಸ್ ನಾಟ್ ಪೇಯಿಂಗ್ ದ ಮೇಂಟೆನೆನ್ಸ್ ಆಲ್ಸೋ ಟು ದ ವೈಫ್ ಮಲೋಜ್ ಹಿಯರ್ ದ
Correct. What is this? TCRs were called for.
ಎಸ್ ಮಲೋಜ್ ಆಕ್ಚುಲಿ ಇದರಲ್ಲಿ
ಯಾವ ಕೋರ್ಟ್ ಅದು? Call for TCR.
Bangalore, madam.
ಬ್ಯಾಂಗ್ಳೂರ್ ಓನ್ಲಿ
Bangalore.
Into-
the respondent had preferred a restitution of conjugal rights petition malods. The same was decreed ex parte malods as the appellant did not appear before the court. The same is
Sorry.
challenged before this court malods.
Was there any order to pay the interim maintenance in the?
Malods, that is in Chennai court malods. It was ordered there.
You recover there if he has not paid.
He
File
has not been
execution.
appearing there also malods.
Then you serve him here. ಅಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಂಡ್ ಬನ್ನಿ ಟು ಸರ್ವ್ ಥ್ರೂ ದ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಹಿಮ್. ಅದೇ ಯಾಕೆ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಿಲ್ವಂತಲ್ಲ ನೀವು?
Seek instruction, madam.
ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ಬಂದ್ಮೇಲೆ
Malods, a date may be fixed malods or else it will be
What is that, interim order or?
it's an interim order.
Interim element. What is the case pending there? ಅಲ್ಲಿ ಏನ್
I'll
case
seek
pending?
I'll clarify.
Then how did you say that there is a case pending and interim order is passed?
Malods, I had the order copy malods. So
You have the order copy?
yes malods.
Then
An
you-
IA was filed and the same was ordered.
Correct. What is the case filed before the Chennai court?
I'll seek instruction.
You check that and produce that
Kindly
order. if
pass
that
over
is-
my lords. I'll
if that is the case, produce that order. This is of
Please, my lord.
2022, na?
22 my lords.
We'll call, then direct the trial court to submit the record. In the meantime, you can produce that order copy.
Please.
So advocate on record bandra.
Yes my lords.
And what is the case before the Chennai court?
He had filed for divorce. That is dismissed for my lord non.
He had filed
He had filed
before Chennai court.
before my lord the family court at Madras.
Huh.
That has been dismissed for non-compliance of orders. The family court had directed to deposit some amount.
Interim element.
Interim manner,
Hmm.
towards the maintenance of the
How much
child.
had accrued?
Around 5 lakhs. Man.
Then you produce a copy of that order. We'll see.
On the last occasion, in fact, my lord, the order is here. If I
Produce
may-
it. In the meantime, let the TCS come.
Please, please. Now, my lord, on the other hand, is enjoying my lord an interim order by this court. And the wife,
To produce that.
please, I will do
order,
that.
so you can consider your prayer.
Please, please.
Counsel for respondent submits that the appellant has suffered an order of interim alimony in the matrimonial, in the divorce case filed by him before the Chennai court. And he has not complied that order. He seeks time to produce the said order. ಮಾಡ್ಬಾರ್ದಲ್ಲ ನಿಮ್ಮವರು ಹಾಗಿದ್ರೆ. He should not do like that.
I seek instruction, madam.
Registry shall secure the TCS and telephonic requisition from the trial court. List on
22-1.
Grateful. Keep looking.
Seal number 4, Ravi Kumar GH, B Pradeep, A N Venkatesh. I'm appearing for respondent number 4, my lord.
R1 to R3.
Last
Non-filing saw the copy on the council for R4.
copy, sir. One-
You represent Mr. A. Venkatesh.
Yes, my lord.
Receive the copies. Now council for the appellant serves the copies on the council for respondent number 4. Office obstruction. In that regard should comply. Advocate for R4 ನೀವು ಒಕ್ಕಲತ್ ಹಾಕ್ಬೇಕಲ್ವಾ?
File ಮಾಡಿದೆ.
You have to pay the process for R1 to 3.
Yes, well, last hearing date, the Samal Court has directed the registry to verify the postal track. Whether it was served or not.
Not claimed. There R1 not claimed ಅಂತಿದೆ. R2 and 3 ಪಾರ್ಟಿ ಊರಿನಲ್ಲಿ ವಾಸವಿಲ್ಲದ ಕಾರಣ they are not residing ಅಂತ. R1 is not claimed and that we can hold.
Before the trial court for same address it was served.
This is a claimant's appeal.
Yes, ma'am.
I think not claimed. R1 we can hold it sufficient. As per the postal endorsement, respondent number 1 has not claimed the notice. Therefore, service on respondent number 1 is held sufficient. ಊರಿನಲ್ಲಿ ವಾಸವಿಲ್ಲದ ಕಾರಣ ಅಂತ ಬಂದಿದೆ. Who are response 2 and 3?
Respond number, owner of the vehicle. Respond number 3 is the owner of the motorcycle.
What respond number 1 ಯಾರು ಹಾಗಿದ್ರೆ?
2 is the rider.
ಇಬ್ರು. ಅಲ್ಲ ಈಗ 1 not claimed ಆಯ್ತು. Whether 2 and 3 are necessary. 2 is rider of motorcycle, 3 owner of motorcycle. Dismiss ಆಗಿದ್ರೆ ಬೇಕಾದ್ರೆ. 2 weeks time is granted to the needful in respect of response 2 and 3.
Much.
Seal number 5. Krishna Kishores.
Second. Restored, returned, refused ಅಂತ ಬಂದಿದೆ.
R1 and R2 R3 1 week time may be granted, my lord.
R4 and 5 refused ಅಂತ ಬಂದಿದೆ.
Lord, it has come up with share of refused.
Who are R4 and 5? Regional manager, United India Insurance, United India General Insurance Company. ಹೀಗಿದೆಯಾ?
ಆ ಥರನೇ ಇದೆ sir.
ಆ ಥರನೇ ಇದೆಯಾ? ಇವರು ಭಾರತಿ ಎಕ್ಸಸ್ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರೆ?
ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು.
ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು ಇದಾರೇನಲ್ಲ? ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. ನೀವು ಇದ್ದೀರಾ? ಅವರೆಲ್ಲ ಇದ್ರೆ ರೆಫ್ಯೂಸ್ಡ್ ಅಂತ ಬಂದಿದೆ, ಅದಕ್ಕೆ ನಿಮಗೆ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ಶ್ರೀ ಎನ್ ಕೃಷ್ಣಸ್ವಾಮಿ, ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಲ್ಲ ಹೀಗೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಸ್ ಪರ್ ದ ಪೋಸ್ಟಲ್ endorsement, respondents 4 and 5 have refused the notice. Therefore, service on them is held sufficient. T.N. Krishnaswamy, Standing Counsel for respondent number 4, is requested to accept notice for respondent number 4. What about Uldar? Postal track, but idರಲ್ಲಿ ಏನು ಬಂದಿಲ್ಲ, ಇನ್ನೂ ಬಂದಿಲ್ಲ. R3 ಅಂತ ಹೇಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಇದರಲ್ಲಿ? R3 ಅಂತ ಹೇಗೆ ಗೊತ್ತಾಯ್ತು? ಅಲ್ಲ ಇದೆ ಇವ್ರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಅಂತ ಹೇಗೆ ಗೊತ್ತಾಗುತ್ತೆ? ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ದಿದೆ. ಅಲ್ಲ ಒಬ್ಬರಿಗೆ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ಲಲ್ಲ. 4 and 5 held sufficient. No permission. ಅದು ಹಿಂದೆ. R1 and 2 no such person. R4 and 5 refused. R3 unclaimed. Service as per the postal track record, R4 and 5 has refused the notice and R3 has not claimed. Therefore, service on them is held sufficient. Shri A.N. Krishnaswamy, Standing Counsel for respondent number 4 is requested to accept notice for respondent number 4. ಅದು ಇದೆಲ್ಲ ಹಾಕೊಂಡು ಆಯ್ತಾ ಎಲ್ಲರದು ಈಗ?
ಅಲ್ಲ 1 and 2 ನಾನು ತಗೊಳ್ತೀನಿ sir.
1 and 2 ಗೆ no such person.
No such person ಅಂತ ಬಂದಿದೆ. At request 2 weeks time is granted to the full in respect of respondent number 1 and 2. Too many parties.
Seal number 6, Gopal Krishnamurthy. A. Ravishankar.
Plaintiff be permitted to grant 1 week time, my lord. On 21/11/24 I have taken the steps, but it has.
Previous case ಎಲ್ಲ ಜುಡಿಷಿಯಲ್ ರಿಪೋರ್ಟ್ ಅಂತ ಇದೆ ನಮ್ಮ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. 25 ಆರ್ಡರ್ ಆದ್ರೆ 16/11 ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಎಸ್ ನಿಮ್ದ್ರಲ್ಲಿ ಏನು?
6, cell number 6.
Two sets to issue notice to R1 and R2, non-filing of acknowledgement for having served the copy on Ravi Shankar ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ ಅವ್ರು ಸಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ಟ್ರೈ ಮಾಡಿದ್ದೀನಿ. ಟುಡೇ ಇಟ್ ಸೆಲ್ಫ್ ಐಲ್ ಸರ್ ಮಲ.
ಎ ರವಿಶಂಕರ್
ಅವ್ರು ಐಟ್ ಇದಾರಲ್ಲ ಅವ್ರು, ನಾನು ಈ CR ರವಿಶಂಕರ್ ಅಂದ್ಕೊಂಡಿದ್ವಿ, ಬಟ್ ಐ ವಿಲ್.
ಇನ್ನೊಬ್ರು
ಇನ್ನೊಬ್ರು ಐಟ್ ಇದಾರಲ್ಲ ಸರ್,
Awesome.
ದಟ್ ಐ ವಿಲ್ ಪೇ.
ಆಯ್ತು ಮಾಡಿ.
Please.
2 weeks time is granted to the name.
Great.
Cell number 7, SPP.
My lord, for the offense punishable under section 6 of POCSO Act, my lord. With section 504 and 506 of IPC.
The office objection? The name ತೋರಿಸಿಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. Okay, respond number 2, name not shown in the cost title in the POCSO case. How you victim or victims?
Victim,
Victim herself is made party.
please, my lord. She herself was the complainant before the trial court. Now she is major, my lord. On the date of filing this appeal, she is 20 years. Then she has been made party to the said proceedings.
Her parents were also examined.
Parents, the father is the accused, my lord, in the present case.
Mother?
Mother was examined as PW2, ma'am.
Husband of CW3. CW3 is, that is PW3. She is examined
Yes,
as
ma'am.
PW. She had supported.
Please, my lord. She has
CW1
supported.
and 3 both supported.
Yes, my lord, she has supported.
We ask you as much as possible to make the parents part.
In such
Right.
case, mother has to be made as a party.
See, generally after some incident, they get married, they get settled. Why again to drag them into it? Mother and party madam.
Please, my lord.
What was her age at the time of the incident?
17 and half, my lord.
Hmm?
17 years, 7 months.
17 years.
10 years, 7 months.
Accepting the council submission, office objection overall. Legal service authority.
I'll make mother as-
As much as possible, you avoid making the
Please,
victims
ma'am.
party. Yaar or parents ಅನ್ನ ಮಾಡಿ.
I'll make mother as a party to this.
ಇದ್ರಲ್ಲೂ ಮಾಡ್ತೀರಾ?
Martin, I'll carry out the necessary changes.
ಹಂಗಂದ್ರೆ ಹೀಗೆ ಬರ್ತದೆ. Heard CP, an office objection. It is true that respondent to victim was not a part, not shown in the constitution of the trial court's order. The name of victim, respondent is not shown in the constitution of the trial court's judgment. Record show that respondent number 2 was minor at the time, was minor. Therefore, the learned CP shall implead PW3, the mother of the victim, as respondent number 2 in the place of
Please, my lord.
the victim, and amend the constitution of the appeal memo accordingly. Appeal memo and furnish the copy of the amended appeal memo. ಈಗ ಉಳಿದವ್ರ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ಇಬ್ಬರಿಗೂ?
Notice ಹೋಗಿದೆ, my lord.
Both are
For
served.
R1 notice is served.
ಹೋತಾರ ಸರ್.
Both are served, ma'am.
ಈಗ ಅವ್ರನ್ನ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಆಯ್ತು. If records show that respond number 1, the accused though served is represented. In his absence, the matter cannot be heard, as this is an appeal against the order of acquittal. Therefore, issue non-available warrant against respond number 1. If he is arrested in execution of the warrant, he shall be produced for the trial court, and trial court shall remand him to the judicial custody till further orders of this court. on doing the needful, issue notice to the substituted respondent number 2. List on
4 weeks. 5-2.
ಏನು migrants are?
5-2.
These are migrant parties, sir?
No, my lord,
Migrant
not,
laborers from the-
not migrants, my lord. They are the
Not migrant.
residents of Mangalore.
List on
5-2. Cell number 8, Nayak Krishna Venkatraman, HC Vrishpendraya, R2.
R3. Who is
R3 is the owner of the vehicle, my lord.
Hmm.
Auto owner of the vehicle. Kindly 2 weeks time may be granted, my lord.
Okay, and what is the order? Why R3 owner is necessary party?
Yes, my lord.
Respondent number 2 being the insurer of the lorry is direct
The insurance company also filed the appeal, my lord, challenging the liability.
percentage respondent number 3.
Yes, my lord.
I request 2 weeks time is granted to do.
My lord, kindly post along with connected matter, my lord, another connected.
ಏನದು ಕನೆಕ್ಟೆಡ್ ಯಾವ್ದು ಈಗಾಗಲೇ ಒಂದು ಕನೆಕ್ಟ್
1560/2024, my lord.
ಹೌ ದಟ್ ಇಸ್ ಕನೆಕ್ಟೆಡ್?
My lord, the same arising out of accident, my lord. The matter is on a different court judgment, my lord. I have filed the another.
ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಆದ್ರೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನೋಡೋಣ. ದಿಸ್ ಇಸ್ ಓನ್ಲಿ ಒನ್ ಜಜ್ಮೆಂಟ್.
Please,
ಏನ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಬಂದಿದೆ?
single judgment is,
ಅದ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ನೋಡೋಣ.
please.
Cell number 9, Puneet C.
Here for the appellant. Take first steps with regard to respondent number 3, my lord. A week's time may be granted. 3, my lord. He was the rider of the vehicle.
Address cannot be located ಅಂತ.
ಯಾರು ಸರ್ಡ್ ಇದರಲ್ಲಿ ಏನು ಇನ್ಶೂರೆನ್ಸೇ ಇಲ್ವಾ?
Insurance.
At request 2 weeks time is granted to do.
Cell number 10, Beena PK, MD Alavandar.
I'm for the respondent.
Your lordship, in the cause list, there is a reference of memo for withdrawal.
Who is filed? We have to see. We are not seeing. Who wants to withdraw? Petitioner anta ಬರೀತಾರೆ. Who is that?
I'm for the petition.
Filed by council. This is appeal, not petition.
Yes, your lordship, actually, we haven't filed any memo like that.
You are not filed.
I have not filed. When we checked in the morning, in the file also, it is, the signature is not mine.
ಯಾರ presentation for Beena PK ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
Yes, your lordship, that is not the one.
Filed it.
It is not filed at all.
To be very honest, I too was surprised, my lord, when I saw this in the cause list.
Okay. 2984 of 2024. ಅದನ್ನೇನು 30 to 34 ಅಂತ ಫಸ್ಟ್ ಬರ್ದಿದ್ದಾರೆ. First it was mentioned as 30 to 34.
Yes, your lordship.
Then whitener is put and it is changed as 2984.
We are not aware of this. When we checked it in the file in the morning only, we came to know that such a memo is in existence. That is not
Submit,
filed
sir.
by me.
ಇದು ಅಲ್ಲಿ ನಮ್ಮ ಫೈಲಿಂಗ್ ಕೌಂಟರ್ ಅಲ್ಲಿ CCTV ಇರುತ್ತೇನೋ ಅಲ್ಲ, ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಚೆಕ್
I
ಮಾಡಿಸ್ಬೇಕಷ್ಟೇ.
was surprised.
No, he may not, he know, but we were also in the discussion of settlement, in the middle of settlement. So, but I don't know, surprisingly it has come.
ನೋಡಿ ಇದ್ರ ಮೇಲೆ earlier some other name is written and they have ಇಸ್ಕೊಂಡು ಚೆಕ್ ಮಾಡಿ ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಪಾಸಿಬಲ್ ಯಾವ್ದೋ numbers. They wanted to file it in some case and have filed in this case, that's also possible.
I cross-checked with the client also, you know, but the client is also not aware of any of those.
Party's name same ಇದೆ ಅಂತ ಹಾಗಿದ್ರೆ that's not possible ಅಲ್ವಾ? Daniel, correct, Daniel, yeah, no. And
I think
Prashant Banerjee. Now consider the appellant submits that.
That is closed.
She has not filed the memo. Now counsel for respond submits that he too has not filed such memo. Therefore, the memo is rejected. However, Registrar Judicial is requested to examine the matter and submit the report. ಏನಾಗ್ಬೇಕಿದ್ರಲ್ಲಿ next? And cease. What was the stage here? One of 24 for direction.
Yes, Your
Two of
Lordship.
24 for stay and CD in filing 71 days.
One IA is for not to remove the children from the custody of the mother.
What is delay condonation?
Yes, Your-
My lord,
Delay condonation. What do you say for delay condonation?
there is.
there is a delay and this delay is a deliberate delay, my lords.
Oh, you are opposing that?
Yes, my lord.
7 days delay. What is the reason they have said?
Your Lordship, there is a small difficulty because the petitioner is a Mexican lady. So it is too difficult to communicate with her, even she is not so fluent in English. So, some time we have taken for filing this appeal. She came to India in search of her children. Then we filed a habeas corpus before Your Lordship. And on the habeas corpus, the children were only 4 years old. They were produced before Your Lordship. And after that, we have filed a petition before the family court for the custody of the children. So this 71 days is not deliberate, Your Lordship. The communication to the client is a bit difficult. Because of that, it takes some time and she had to arrange money for meeting the expenses and all those things.
She had contested the matter here.
What is it?
On what ground custody is granted to him?
Your Lordship, the joint custody is granted.
Petition by
And in the
counsel.
order, it is mentioned that,
Petition
Ma-
is dismissed.
Yes, my lords.
She had filed the petition.
yes, Your Lordship, the mother is unemployed.
Joint parenting, the respondent.
Joint parenting with the respondent and also entitled for proper visitation right. Father is entitled for visitation right.
Children were born
In
Chil-
India.
In India.
In India.
in India.
In
In
India. The parents met from Mexico. She came to India. She married him. And after that, the children were born in India. They went back to Mexico. From Mexico, he has taken the children, in fact, abducted the children without informing her, saying that I'm taking the children to the garden and park. And then he came to India. So she came to India in search of her children, filed a habeas corpus. The children were produced.
The affidavit. What does
My lord,
it
all
say?
this was in the trial court, everything was subjected to evidence. And the allegation that the respondent kidnapped the children is a false allegation, which was not proved before the trial court. I have produced material before the trial court to say on what circumstances the respondent had to come back to India with the children.
All
And
we'll condone the delay. We are satisfied. Okay.
but
What is the nine number? 3 of 2024. On both sides. The record show that the appellant is a foreign national. She has pleaded her difficulty in communication and the litigations between the parties as a ground for the delay. Considering the same, delay of 71 days in filing the appeal is condoned in the interest of I have 3 of 2024 is disclosed of academic. Right, other two applications?
One for a direction note.
For objection ಆಗ್ತಿದ್ರೆ ಹಾಕ್ಲೇಬೇಕು. You want to file objection?
yes, my lords, I want to.
Then you file it. Why you have
I
not
will, my
filed?
lords.
Copies are served on you.
Yes, I have received the copy. Yes,
File it.
I will file.
A short date, Your Lordship.
File counter to IA 1 and 2 of 2024. Admission ಗೆ ಬಂದ್ರೆ ಅವಾಗ್ಲೇ consider ಮಾಡ್ಬೋದು. If the matter comes for admission, We can consider IAs.
Your lordship, the IA number 2 and IA number 3 may be considered, your lordship. That is what.
No,
It
if
has-
it comes only for IA, comes in the IA list, admission and IA both can be considered together.
Yes, your lordship.
In the meantime, records are also, it's from Bangalore court only, records
Yes,
also
ma'am.
can be secured.
Yes, yeah.
Okay, list the matter for admission on
27-1.
27. In the meantime, the record, registration secure the TCS.
Your lordship, one reference about,
27-1.
sorry.
27-1.
No, your lordship, one reference about that withdrawal memo. It is not filed by us.
That I have already passed. We have passed order.
Yes.
And we have also asked the Registrar Judicial to hold an inquiry in the matter.
Yes, yeah.
Cell number 11, N. Krishnaswamy.
Based on 5 sets of issues to be copies and proof of deposit.
Cell number 12, R.V. Shivanand Reddy. Malti TN.
Pardon? And 2 weeks time is granted to the benefit. Same.
Cell number 13, N. Krishnaswamy.
Same 2 weeks time is granted.
Cell number 14, Ashok N. Patil.
R1 to R3, Ashok. Okay. Process fee ಕೊಡ್ಬೇಕು. Insufficient. 2 weeks time is granted to the benefit.
Hearing on IA. Cell number 15, Balraj AC, B. A. Ramakrishna.
Appear for the appellant, my lords. My lords, this honorable court, wide order dated 7/8/2012. Was
Going to release it.
please, grateful.
But your affidavit is as if third person ಅನ್ನೋ ತರ ಹಾಕಿದಿರಲ್ಲ. Fourth respondent has filed this application.
It's only with regard to the fourth appellant, my lords. Release of amount only with respect to the fourth appellant.
Release 75,000 for fourth appellant.
Only with respect to.
So that is the same lady, applicant only. Yeah. And the record show that this appeal was disposed on a copy of affidavit on 7/8/2012. Partly allowing the appeal. At that time, appellant number 4 was minor. Her share of compensation was ordered to be deposited in FD for a period of, she attains the age of 30 years. Now the same is sought to be released on the ground that for her marriage, the appellant, first appellant has incurred some loans and she also wants to construct a house. Considering the aforesaid facts and circumstances, the registry is hereby release the amount in the fixed deposit. ಎರಡು FD ಇದೆಯಾ? There are 2 FDRs.
2 FDs, my lords. Appellant 3 and 4.
ನೀವು ಕೇಳಿರೋದು 4th one.
Only with respect to fourth appellant.
ನೀವು ಕೇಳಿರೋ, you have mentioned 2 FD receipts.
2 FD receipts, my lords. This is only with
For 4.
fourth appellant.
Is the amount in deposit, release the FDR. FDR is in your name.
Please.
And facilitate the release of the amount in FDR to appellant number 4.
Great.
I number 1 of 2024 is disposed of. Education, marriage.
Cell number 16, Chandrasekharaya B. B. Pradeep.
Respondent appear for appellant Millet. Case of injury, head injury Millet.
This
But-
application has to be heard along with the main matter.
Yes, my lord.
ಆಗಿದ್ರೂನು ಮತ್ತೆ ಇದನ್ನ
ಅದೇ ಮೇನ್ ಮ್ಯಾಟರ್ ಮೇಲೆ ಮಾಡ್ಬೋದು.
ಇದ್ರೂನು ಮತ್ತೆ ಲಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕಂತಾನೆ.
ಅದೇ ಅವರು ಅದರ್ ಸೈಡ್ ಇಸ್ ನಾಟ್ ಕಮಿಂಗ್ ಟುಡೇ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆದ್ರೆ ಆಗ್ಬೋದು ಸರ್, ಫೈನಲ್ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೋದು.
IA1 of 2024 was ordered to be heard along with the main matter. Despite that, again, the matter is listed for hearing on IA1 of 2024. Registrar judicial shall seek the explanation of the concern in the matter. ಇದು ಅಡ್ಮಿಟ್ ಆಗಿತ್ತಾ?
ಅಲ್ಲ, ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ. ಅದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ರೆ ಬೇಗ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ. ಅದು ಹೆಡ್ ಇಂಜುರಿ 2018 ಮ್ಯಾಟರ್. ಆಕ್ಸಿಡೆಂಟ್ ಈಸ್ ಆಫ್ ದ ಇಯರ್ 2000.
ಇದೆಯಾ?
ರೆಕಾರ್ಡ್ ಬಂದಿದೆ ಸರ್. ಹೆಡ್
ಇದು ರೆಗ್ಯುಲರ್ ಕೋರ್ಸ್ ಅಲ್ಲೇ ಬಂದ್ಬಿಡುತ್ತೆ 2018 ಮ್ಯಾಟರ್.
ಬರ್ತದೆ, ಡಿಲೇ ಆಗುತ್ತೆ. ನಾನು
This for final hearing on date here.
23/1.
Please.
Seal number 17, SPP, K. Ravishankar,
26. Ravishankar for R1. This
For the offense punishable under section 376, my lord, and 417, my lord. For the offense punishable under section 417, he has
say
been,
why two appeals?
why two appeals? My lord, the learned SPP addressed his arguments because, my lord, one appeal is, my lord, for enhancement of the sentence that
Why?
is filed under section 377 of CRPC. The grounds,
The provisions in the same appeal memo.
my lord, here the office raises an objection, my lord, if under two provisions,
Not the office.
please, my lord.
Office objection ಇಲ್ಲ. Last time ಕೇಳಿದ್ವಿ ನಾವು ಅವ್ರನ್ನ. ಇದರಲ್ಲಿ some of them are acquitted. 235 is convicted for the offense under section 417 and acquitted for the major offense. ಆಮೇಲೆ 417 ಕಡಿಮೆ ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎರಡು ಸೇರಿ ಒಂದೇ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಬಹುದು.
ಇನ್ಅಡಕ್ವಿಟ್ ಸೆಂಟೆನ್ಸ್, ಇನ್ನೊಂದು ಅಕ್ವಿಟಲ್ಗೆ ಎರಡೆರಡು ಅಪೀಲ್ ಬೇರೆ ಬೇರೆ.
Acquittal.
ಅವ್ರೇನು
That is
ಜಜ್ಮೆಂಟ್ ಇದೆ ಅದಕ್ಕೆ ಬರೋದಿಲ್ಲ ಏನು ಸಮಥಿಂಗ್ ಹಿ ಸೆಡ್ ಲಾಸ್ಟ್ ಟೈಮ್, ಅದಕ್ಕೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಇದೇ ರೀತಿ ಆಗ್ತಾ ಹೋಗುತ್ತೆ. ಇಟ್ ಇಸ್ ಅನ್ನೆಸೆಸರಿ ಡಿಪ್ಲಿಕೇಶನ್ ಆಫ್ ವರ್ಕ್.
ಸ್ಟೇಟ್ ಹ್ಯಾಸ್ ಟು ಸೇ.
Next week, my lord, I'll take instructions and make my submission.
If really there is any legal impediment, we also have to accept it.
Please, my lord.
If there is nothing, ಈಗ ಎರಡಕ್ಕೂ ಅಪೀಲ್ ಪ್ರೊವಿಷನ್ ಬೇರೆ ಇದ್ರೆ
Only,
we can quote both the provisions in the same appeal memo and file one appeal.
yes, my lord. Next week, my lord, will convince with respect to.
ಅಲ್ಲ ಅವ್ರೇನು ತಂದು ಕೊಡ್ತೀವಿ ನೋಡ್ತೀವಿ ಹೇಳ್ತೀವಿ ಅಂತ
Yeah.
ಹೇಳಿದ್ರು.
He's on his legs, my lord, in the other court. I spoke to him.
ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ, ಯಾಕೆ ತಿರ್ಗಿ ಇಲ್ಲಾಂದ್ರೆ then registry will also not raise any objection. We can pass an order that in these kinds
Yes,
of
230, my lord. Inform him to.
sufficient ಅಂತ ಹೇಳ್ಬೋದು ನಾವು.
Please.
It keeps repeating. ಇದನ್ನು ಇವ್ರು ನೀವು ರಿಜಿಸ್ಟ್ರಿ ಕೇಳಿದ್ವಿ ಏನೋ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ನೀವು. ಅವರನ್ನು ಕರೆಸಿ ಯಾಕೆ ask him to come at 2:30.
Please, my lord.
ಕನ್ಸರ್ನ್ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ ಬರೋದಕ್ಕೆ ಹೇಳಿ.
Seal number 18, A. N. Krishnaswamy, K. T. Gurudev Prasad,
For the respondents 1 to 4.
My learned friend also has filed an appeal.
Which best do one of them? ಅದು next ಏನ್ ಬರುತ್ತಲ್ಲ?
ನೋಟಿಸ್ ಆಗಿದೆ.
167, yes. 146 days delay and non-filing of proof of deposit. Deposit ಮಾಡಿದಾರಾ?
ಇದು ಮಾಡಿದೆ.
I'll produce document to that.
Hmm?
I'll produce it in a
ನೀವು
week.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋವರೆಗೂ ನಾವು ಡಿಲೇ ಕಂಡನ್ ಮಾಡಕ್ ಆಗಲ್ವಲ್ಲ? ಅವ್ರದ್ರಲ್ಲೂ ಡಿಲೇ ಇದೆಯಾ?
ಅವ್ರದ್ರಲ್ಲಿ
ನೀವು ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಅವ್ರದ್ರಲ್ಲಿ ಅಷ್ಟೇ. ವಿಲ್ ಆಸ್ಕ್ ಯು ಟು ಟೇಕ್. ಇದನ್ನ ಕೊಡಿ ಮ್ಯಾಟರ್. In your matter, service is completed. ನಿಮ್ದ್ರಲ್ಲಿ have to take notice to the other parties.
ಅವರಿಬ್ರೆ ಇದ್ರಲ್ಲಿ ನಮ್ಮದ್ರಲ್ಲಿ ಮಾತ್ರ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಕೃಷ್ಣಸ್ವಾಮಿ
Correct, ಅವ್ರು ತಗೊಳ್ತಾರೆ. What about second respondent?
Second respondent dispense, not dispense.
Their appeal is on what ground?
Quantum.
Only in point. Shri N. Krishna Swami, Lawyer Standing Counsel for respondent number 1 is requested to accept notice for respondent number 1.
These appeals.
Now counsel for the appellant submits memo for dispensation of notice to respondent number 2.
It could be referred to Lok Adalat also.
Copies are ಕೊಟ್ಬಿಡು.
Impugned award, liability to pay the compensation is passed to respondent number 1 and insurer. Both counsel submit that appeals are on the point of quantum only. Therefore, notice to respondent number 2 is dispensed with as paid for. Delay condone ಮಾಡಿ ಲೋಕದಲ್ಲಿ case of death or injury.
ಈ case of death.
ಲೋಕದಲ್ಲಿ ಹೋಗ್ಬೋದಾ?
Third copy also in
ಎರಡು
my.
ಕೇಸಲ್ಲೂ ಕಾಮನ್ ಆಗಿ ತಗೊಂಡ್ರಿ.
ಓಹೋ.
ಅವ್ರದ್ದು 378 days ಡಿಲೇ ಇದೆ.
ಹೌದು.
ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ?
Interest
Minus
deny,
ಇದ್ದಾರೆ.
interest deny.
Orders and I one of
ಲೋಕದಲ್ಲಿ
23 and one of 54. Case number ಹಾಕಿದ್ದಾರೆ. Considering the reasons assigned to explain the delay of 146 days and 378 days in the above appeals respectively is condoned in the interest of justice. I 1 of 2023 and 1 of 2024 in the above appeals are disposed of accordingly. As requested by both sides, the matters are referred to Lok Adalat.
Cell number 19, Nayak Krishna Venkatraman, D. Vijay Kumar for R2.
My lord, I am for the appellant in the connected matter, my lord.
Case of death, my lord. 205 days delay in filing the appeal, my lord.
Delay of 205 days.
Yes, my lord.
What do you say? Is it?
Without interest in case if they are entitled for any compensation.
Minors ಇದಾರಾ?
ಇಲ್ಲ,
38,
parents claimants.
Stage ಏನ್ ಹೇಳಿದ್ದಾರೆ?
My lord, claim petition is allowed, my lord. Claim petition is allowed.
After receiving notice in their appeal, you have filed this.
Yes,
appeal?
yes, my lord. The insurance company filed the appeal challenging the negligence and quantum.
First matter, 19 and considering the reasons assigned to explain the delay of 205 days in filing the appeal is condoned with a condition that if the appellants succeed, they cannot be entitled to interest on the enhanced compensation for the delayed period of 205 days. I 1 of 2024 is disposed of accordingly. ಒಂದೇ ಅಡ್ಮಿಟ್ ಆಗಿದೆ
ಹೌದು. Connected matter already admitted, my lord.
ಅದೇ ಬಂದಿದೆ. ಇದೇನ್ ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗೋ ಚಾನ್ಸ್ ಇಲ್ಲ.
ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
ಏನಿದೆ?
ಆಗೋದಿಲ್ಲ sir.
What is the ground of challenge?
We have denied the very involvement of the vehicle in the accident.
Charge sheet
Records may be called for. Records may be called.
records ಬಂದ್ಬಿಟ್ಟಿದೆ ಆಲ್ರೆಡಿ.
Then a date may be fixed for final hearing.
You have not examined any person on your behalf.
Not examine the any person, not produce any documents, my lord.
No document ಹಾಕಿಲ್ಲ. Disputing the
Lord,
involvement.
already deposited 50% award amount. This honorable court orders there 50% of 50% release.
The connected matter is.
That is subject to result of the appeal.
Therefore, this matter is also admitted for hearing. List for final hearing on
4 weeks. 5-2.
5.
5-2.
Much.
Cell number 20, SPP.
Much obliged. My lord, stay may be continued.
Till further orders ಅಂತ ಇರ್ಲಿಲ್ಲ. Interim order. Admit ಮಾಡಿದ್ರೆ till further orders ಅಂತ ಮಾಡಿರ್ತೀವಿ ನಾವು.
Please, my lord.
My lord, for the offense punishable under 498A 304B, my lord, and
Delay.
section 3 and 4. There is a delay of 176, my lord. Notice has to go on the delay.
The next one. On the previous case, interim order granted earlier is extended till further orders implemented. ಇದರಲ್ಲಿ support ಮಾಡಿರ್ಲಿಲ್ವಾ? Why?
My lord, on one ground, my lord, my lordship may get a ting page number 26, my lord.
75.
That is the internal page number 16 of the judgment. Paragraph number 27 is the findings of it. The main defense of the accused is that the victim was suffering from several stomach pain. Though PW1 and 2 has denied the same, PW4 has admitted in the cross-examination that prior to 15 to 20 minutes of the death, the deceased made phone call to his sister and she was been suffering from stomach pain. IO has further admitted that sister of the deceased informed PW1 that her daughter is suffering from several abdomen pain. It appears that due to some other reason, the daughter of PW1 and 2 committed suicide. There is-
So, it is a suicide, that is, that fact is accepted, but not in connection with dowry harassment.
Dowry harassment, that is the finding of it.
Issue notice to the respondent. Please come.
5-2.
Fred, there is only one response. Age 55. Delay. Issue notice.
5-2.
Five. ಏನಿದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ ಏಜ್ 55 ಅಂತ ತೋರಿಸಿದೀರಾ, ಐಎ ನಲ್ಲಿ 45 ಅಂತ ತೋರಿಸಿದೀರಾ. in 2014.
Still number 21.
ತಪ್ಪಾಗಿದೆ.
SPP.
ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಮಾಡ್ತೀನಿ.
Still number 21.
And served unrepresented. What is this offense?
My lord, this is for the offense punishable under section 302, my lord.
Not to read with section 34.
Section 34 of IPC.
ಅದು ತಂದಿಲ್ಲ, ಲಿಸ್ಟೇ ಮಾಡಿಲ್ಲ, ನಾನು ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ. ಅದು ಸರ್ವ್ ಆಗ. Why non-bailable warrant was ordered on 4/12/2024.
Yes, my lord.
NBW issued against R123 through SP Kodagu, returnable by so and so. Eli, nim report illide. Police report received stating that response 1 to 3 has been remanded to judicial custody till further orders. ಏನ್ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ವಲ್ಲ, ಫ್ರೀ ಲೀಗಲ್. ಆರೋಪಿ 1, 2, 3. ಈಗೇನ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಮಾಡೋದು?
ಮಾಡ್ಬೇಕು. From legal service authority.
The records show that due to the lapse of respondent number 1 to 3 / accused 1 to 3, non-bailable warrants were issued against them. They are arrested and remanded to judicial custody. None represents them. Legal service. ಯಾರಿದ್ದಾರೆ?
ಸಂಪಂಗಿರಾಮಯ್ಯ. ಇನ್ನೆಕ್ಸ್ಟ್ ಸಂಪಂಗಿರಾಮಯ್ಯ.
ಲೇಡೀಸ್ ಯಾರು? ಅರ್ಚನಾ ನೋಡೋಣ.
ಸುಹಾನಿ ನೋಡೋಣ.
ಶ್ರೀಮತಿ ಅರ್ಚನಾ ಏನಾದ್ರು?
ಅರ್ಚನಾ
KM.
Archana KM, learned counsel is appointed, none of the representative. Therefore, Srimati Archana KM, learned counsel is appointed as amicus curiae to assist the court on behalf of response 1 to 3. 1 to, okay. And SPP copy serve ಮಾಡಿರ್ರಿ.
I'll serve a copy.
SCP shall serve the copies on her. Her name shall be shown in the copies accordingly. List on the 4 weeks ಬಿಟ್ಟು ಹಾಕೋ. ಅಥವಾ ಕಸ್ಟಡಿ ಇಲ್ಲ 2 weeks ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ ಸರ್. List on
28. 28-1. Cell number 22, SPP.
My lord, even in this, my lord, notice is duly served.
serve and represent.
The NBW was issued, my lord.
ಏನಾಗಿದೆ? ಅಲ್ಲ ಪಾರ್ಟಿನವರೆಲ್ಲ ಸೇರಿಸಿ ಆಗಿದೆ ಎಜುಕೇಶನ್ ಅವರಂತೆ ಅದೇ ಬಂದಿಲ್ಲ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ 31 years. This is from which court?
For the offense 302, my lord.
Karkala. 302, no?
Okay.
Previous case. Since respondent accused failed to appear before the court, in execution of the warrant, as per the police report, he is remanded to judicial custody. None represents the respondent. Due to his incarceration, free legal aid has to be given to him. Therefore, our name is Sohani Helana. Sohani Helana Learned Counsel is appointed as amicus curiae to assist the court on behalf of the respondent. Learned SCP shall serve the copies on her. Her name shall be shown in the copies accordingly. List on
28-9. 28-1. 28-1. Cell number 23, SPP.
My lord, for the offense punishable under section 307, my lord, 326. Notice has to go, my lord. There is a delay of 269 days in file.
Yes, sir. Victim had supported.
Victim has supported, my lord.
Why then his evidence was dispelled? Civil cases ಇದೆ ಅಂತ.
There was other connected civil matters
Yes.
between the parties.
Alcoholic ಅಂತ ಅವೆಲ್ಲ. Okay, issue notice to respondent. List on
4 weeks. 5-2.
Please, my lord.
right.
For admission, cell number 24, D. Nagaraj Reddy, Akash Kumar Gowda, MS Sriram, Ashok N. Patil.
I appear for the appellant in 9806, my lords. I
Hmm.
pray for time of 1 week, my lords. My lords,
Connected matter.
connected matter, my lords. ಅದು
dispose
claim
ಆಗಿದೆ.
petition ಅದು ನೋಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. I have received instructions that they have not paid any amount in the other claim petition, my lords. I'll have to verify the judgment of the other claim petition. ನನ್ನ ಹತ್ರ ಅದು copy ಇಲ್ಲ. I have to receive it from the opposite advocate.
Petitioner is entitled to compensation of 2,15,000. Liable to pay compensation amount for restitution of deposit. 30 days. Respondent number 1 was Mahadev. Respondent number 2 was branch manager. Avreಲ್ಲ last time petition against the insurer is dismissed. ಆ ಕೇಸಲ್ಲೂ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಲ್ಲ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಲೆ.
My lords,
But that case claim petition.
I do not have a copy of the judgment, my lords. I'll receive it from the council.
Council for
ಫೈಲ್ ಆಗಿದಾನ ಬಂದಿದಾನ
ಮಾಡಿದ್ವಿ
File ಮಾಡ್ಬೇಕು.
locate for appellant in 9806.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಮಲಾಡ್ಶಿಪ್ ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ಹೇಳಿದ್ರೆ ಮಾಡಿದ್ದೀನಿ
ಅದೇ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
Even in that case, insurance appeal against insurance company, claim petition against insurance company was dismissed.
ಎಸ್ ಮಲಾಡ್ಶಿಪ್
ಅದೇ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ.
ಕೊಡ್ತೀನಿ
ಇಬ್ರು ಕೂಡ ಹೇಳಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್. The matter is taken
ಕೊಡ್ತೀನಿ
to attention, Learned Counsel for respondent number 2 submits 9806. MS Sriram,
ಎಸ್ ಎಸ್ ಮಲಾಡ್ಶಿಪ್
you are for the insurance company.
ಎಸ್ ಎಸ್ ಮಲಾಡ್ಶಿಪ್
The case was partly passing live to present appellant. ಇದರಲ್ಲಿ ಒಂದು ಓನರ್ ಅಪೀಲು ಒಂದು ಇವ್ರ that
ಅದರಲ್ಲಿ
has attained
ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಇದೆ ಅಂತ ಕೊಡ್ತೀನಿ ಸ್ವಲ್ಪ ಕಾಪಿ ಕೊಡ್ತೀನಿ
that has attained finality, that order. ಇದನ್ನ ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ? ಈ
ಇಲ್ಲ ಇಲ್ಲ ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ madam.
881
ಇಲ್ಲ ಇಲ್ಲ
ಅವರು ಚಾಲೆಂಜ್
ಕಾಪಿ
my lords,
ಅವ್ರಿಗೆ ಓನರ್ಗೆ ಅವರೇ ಪೇರ್ ಆಗ್ತಾರೆ 881
ಯಾರು ಮಹಾದೇವ. ನೀವು ಪಾರ್ಟಿ ಇದ್ರಿ ಅದರಲ್ಲಿ, ಯು ಆರ್ ರೆಪ್ರೆಸೆಂಟೆಡ್ ಥ್ರೂ an advocate also.
And then, my lords, I do not have the copy of the
ಒಂದು copy
judgment.
ಕೊಡಿ.
Please.
I'll examine it. Your lordship may have it
Register,
next week, my
please.
lords.
Memo filed by counsel for appellant to the 9806. ಅಲ್ಲ advocate for appellant ಅಂತ ನೀವ್ ಹಾಕಿದ್ದಲ್ಲ, advocate for appellant ಅಂತ ಇದೆ. ನೀವ್ ಯಾರನ್ನ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು?
In 9806, I'm for the appellant, my lords.
ಅದು
In
ನೀವೇ ಹಾಕಿದ್ದು ಅಂತ ಇದೆ ಅಲ್ಲ.
ಸಾರಿ ಮಿಲಾಕ್ಷಿಪ್, ನಾನು ಅವರ ಮಿಸ್ಟೇಕ್ ಮಾಡಿ ನಮ್ಮ ಕಲಿಗೆ ಮಾಡಿದೆ ಸರ್. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋ ನಾನು ಸರ್, ತಮ್ಗೆ ಹೇಳಿದ್ರಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಇದು
ರೆಸ್ಪಾಂಡೆಂಟ್ ಅನ್ನೋದು
ತಿಪ್ಪೇಸ್ವಾಮಿ advocate ಅಂತ ಬರ್ದಿದ್ದಾರೆ ಅದ್ರ ಮೇಲೆ.
ಸಾರಿ ಮಿಲಾಕ್ಷಿಪ್, ನಮ್ಮ ಸೀನಿಯರ್ ಹತ್ರ ಆಕ್ಚುಲಿ ಶ್ರೀರಾಮ್ ಸರ್ದು ಹಾಕ್ಬೇಕು, ನಾನು ಕಲೀಗ್ ನಾನು
ಹೌದಾ?
ಮಿಸ್ಟೇಕ್ ಮಾಡಿ ನಮ್ದು ಹಾಕಿದ್ದಾರೆ ಸರ್.
ಸರಿಯಾಗಿ ಮಾಡಿ ಕೊಡಿ ಹಾಗಾದ್ರೆ. Counsel for respondent number 2 na?
Yes.
Respondent number 2. Lawyer counsel for the appellant submits the along with copy of the judgment in MEC number 881 of 2007. Lawyer counsel for the appellant submits that she has copy is not served on her. Counsel for respondent number 2 shall serve the copies on her. List all oldest matter in the
your lordship may have it any day, my lords. I'll just have a look at the judgment.
Next Monday, 13-1.
13.
Please.
Number 25, Arvind Reddy H.
Case for the respondent, my lord. This case, my lordship, my mediation. In the mediation.
My apology, Arvind Reddy is not well, therefore kindly.
In the
Position ಮಗುನ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮಗುನ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೂಡ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. The child is not ready to go with the mother.
Allah, the family
That
court
is the
is not
problem.
ready to.
Before the court only.
Allah, now we have made expenditures of 20,000 to get the JDR to arrest before the trial court.
ಹೋಯ್ತದು.
Arrest ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ರು ಕೂಡ the trial court is not ready to direct the husband to hand over the child. Because the appeal is pending. There is no, the stay application is dismissed from this honorable courts. ಇದೆಲ್ಲ ಹೇಳಿದ್ರು ಕೂಡ the trial court is not ready to direct the husband.
Why are you alleging the trial?
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾನು I brought the order sheet copy also.
ಲಾರ್ಡ್ಶಿಪ್ ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಸಾಹೇಬ್ರನ್ನೇ ಮಗುನ ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾರೆ.
Executing this order.
Yes, madam.
ಮಗು ತಾಯಿನ ಐಡೆಂಟಿಫೈ ಮಾಡಲ್ಲ ಅಂತ ಕೋರ್ಟ್ನವ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಕೋರ್ಟ್ ಕೂಡ ಪ್ರಯತ್ನ ಮಾಡಿದೆ ಕಳಿಸ್ಲಿಕ್ಕೆ.
ಒಂದ್ ವರ್ಷ
That is the problem.
ಒಂದ್ ವರ್ಷ ಈಗ 3 ವರ್ಷ 1 ವರ್ಷ ಮಗು ಇದ್ದ ಕಿತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದಾರ ಅವ್ರು. ಹೆಂಡ್ತಿನ ಹೊರ ಹಾಕ್ಬಿಟ್ರಿ ಇವರು ಬಡದು.
See, when the child
My
is
lordship, my
somebody
ಗೊತ್ತಾಯ್ತು ನನಗೆ. I can understand.
that some sessions have.
I am not denying the relationship or the feelings of the mother also. Arvind Reddy is not well today. Kindly have it on another one. Arrest.
ಮಗು ತಂದೆ ಹತ್ರ ಇದೆ.
Arrest ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
The father has been brought arrested and directed the husband, the father, to produce the child before the court on the next day. Next day order sheet ನಲ್ಲಿ ಇದೆ. The child has been brought before the courts in the trial courts. Mediation ಅಲ್ಲಿ ಮಗುನ ಹತ್ರಕ್ಕೆ ಬಿಡ್ಲಿಲ್ಲ, ಮಗು ನೋಡ್ಲಿಕ್ಕೆ ಮಾತಾಡ್ಸ್ಲಿಕ್ಕೆ. To brought arrest the husband, my client has made expenditure of 20,000 more.
Appeal pending ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಅಷ್ಟಕ್ಕೇನೆ ಮಗು ಕೊಡಬಾರ್ದು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
ಈ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಕೊಡಬಾರ್ದು ಅಂತ ಬರ್ದಿಲ್ಲ.
ಸೆಟ್ ಅಪ್ ಮಾಡಿದ
Free ಅಂತ ಮಾಡಿ.
set at liberty and not directed the father to hand over the child.
ಇದು ಕೋರ್ಟ್ ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಅನ್ನೋದಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ. ಸ್ಟೇ ಇಲ್ಲ ಅಂದ್ರೂ ಕೂಡ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ is rejected.
Stay application is rejected.
Rejected.
Yes, on the first hearing of the this case.
21/3/2024.
Yes, madam.
Child is a girl aged below 5 years. He has undergone 2 marriages. Those marriages were broken. ಇದೆಲ್ಲ detailed order.
My client is the third.
ಅಲ್ಲ ಈ ಆರ್ಡರ್ ಕಾಪಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ತೋರಿಸ್ಲಿಲ್ವಾ ನೀವು?
Courses. My client is the third wife, suppressing the earlier 2 marriages. Again, he is going for the 4th marriage. ಈಗ ಬಿಟ್ರೆ ಇನ್ನೊಂದು 4ನೇ ಮದುವೆ ಆಗ್ತದೆ.
We have to take a serious.
ನಾನು ಹೇಳ್ತೀನಿ ಅದನ್ನ.
Serious.
I informed to Arvind Reddy, who was on record advocate. Next week ಅಲ್ಲಿ ಅವ್ನು ಕರೆಸ್ತೀನಮ್ಮ. 1 week ಅಷ್ಟೇ.
ದಾವಣಗೆರೆ.
Only 1 week. 1 week. Next ನಾನು ಅರವಿಂದ್ ರೆಡ್ಡಿ ಹೇಳ್ತೀನಿ ಅಪೇರ್ ಆಗಿ.
ಇಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದ್ರೆ ಟ್ರಯಲ್
ಅದನ್ನ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ.
There I produced the copy also before the trial court, man.
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಮಾಡಿ ಅವರೇ ಮಾಡಿದ್ದಾರೆ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲಿ ನಮ್ಮ
Yes, I will produce it.
ಈಗ ಯಾವ ಸ್ಟೇಜ್ಗೆ ಇತ್ತು ಇವತ್ತಿಗಳಿದು admission? How can we admit it when you have not complied the order?
ನನಗೆ ಕೇಸ್ ಬಗ್ಗೆ ನನಗೆ ಸರಿ ಗೊತ್ತಿಲ್ಲ, ಡೀಟೇಲ್ ಐ ಡು ನಾಟ್ ನೋ ದಿ ಡೀಟೇಲ್ಸ್. ಜಸ್ಟ್ ಐ ಗಾಟ್ ದಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಥ್ರೂ ಮೈ ಬ್ರದರ್. He is on the colleague of Mr. Arvind Reddy, therefore.
Lord counsel for the respondent submits memo along with copies of the order in execution. Petition number 15 of 2023 pending before the trial court. And the record show that ಅವರೇ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಮತ್ತು the husband has preferred this challenging the trial court judgment granting custody of the minor child who is shown as il appellant ಅಂತ ತೋರಿಸಿದ್ದೀರಾ as appellant number 2 in the present appeal to the respondent. This court by order dated 21/3/2024 has rejected the application of the first appellant for interim stay, noting that child is aged below 5 years. Appellant is a girl child aged below appellant number 2 is a girl child aged below 5 years, and appellant number 1 has undergone 2 marriages and they were also broken. Therefore, interest of the child suffers if the child is with him. The order sheet, copy of the order sheet produced by the counsel for respondent shows that despite such order, the trial court, the executing court has not taken steps for restoration of the custody of the child to the decree holder, only in the guise that this appeal is pending. The order trial court dated 2/7/2024 further shows that though the first appellant was arrested in execution of the decree, he was set free. The said order in the guise of In fact, such orders run contrary to the spirit of the order passed by this court on 21/3/2024. ಇವಾಗ ಯಾವಾಗ 9/8/2024 ಆದ್ಮೇಲೆ ಯಾವತ್ತಿಗಿದೆ ಈಗ ಕೇಸ್ ನೆಕ್ಸ್ಟ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರ?
It is pending, madam.
ಯಾವತ್ತಿಗಿದೆ
ಅದು next 15th January.
15 January.
Yes, madam.
Communicate the copy of this order to the trial court. ಈಗ ನಾವು ಅಡ್ಮಿಟ್ ಮಾಡೋದಿಲ್ಲ, ನಿಮ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಹೇಗಿದ್ರೆ.
Matter is
Keep the child and mother, let the parties appear before us. ಇಲ್ಲ ಮಕ್ಕಳು ಸಹಜವಾಗಿ ಯಾರ ಹತ್ರ ಇರ್ತಾರ ಅವ್ರ ಹತ್ರ ಅವಾಗ ಅವ್ರಿಗೆ ಅಕಸ್ಟಮ್ಡ್ ಆಗಿರ್ತಾರೆ, ಸ್ವಲ್ಪ ಹೋಗ್ಬೇಕು, ಫೆಸಿಲಿಟೇಟ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ.
Though we much convinced to the trial court, madam, there is no stay order, but the trial court is not ready to hear the submissions.
ಇಲ್ಲ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ರೆಫರ್ ಮಾಡಿ.
ಅಲ್ಲಿ ಕೂಡ ಮಗು ಕೊಡ್ಲೇ ಇಲ್ಲ. There the husband, the father has not brought the child and handed over the child.
3/4/2024 ಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
Yes, ma'am.
ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್
ಅಲ್ಲಿ ಒಂದು 4 ಸಾರಿ ಹೋಗಿ ಬಂದಿದೆ. ಇವ್ರು ಬರ್ಲೇ ಇಲ್ಲ, 2 ಸಾರಿ ಬರ್ಲೇ, 3 ಸಾರಿ ಬರ್ಲೇ ಇಲ್ಲ ಇವರು. ಇಲ್ಲ ಚೈಲ್ಡ್ ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅದಾದ್ಮೇಲೆ 18/7 ನೀವು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಕೋರ್ಟ್.
ನಾವು 3 ಸಾರಿ ಅಪಿಯರ್ ಆಗಿದೆ.
ಇವ್ರು ಬರ್ಲೇ ಇಲ್ಲ, ಫಾದರ್ ಬರ್ಲೇ ಇಲ್ಲ.
ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಇನ್ ದ ಪ್ರಿಮೈಸಸ್ ಆಫ್ ದ ಕೌನ್ಸಿಲ್ ರೆಕಾರ್ಡ್. ಅಲ್ಲ ಅದು ರಿಪೋರ್ಟ್ ಬಂದಿದೆಯಾ ಇಲ್ಲಿಗೆ?
ಬಂದಿದೆ.
ನೋಡೋಣ. ಅಲ್ಲ ಅವ್ರು ಒಂದೊಂದ್ಸರಿ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ. ಆಗಿದ್ರೆ ನಾಟ್ ಅಪಿಯರ್ಡ್ ಅಂತ ತೋರಿಸಿರ್ತಾರೆ. ಇಲ್ಲಿದೆ, ಇಲ್ಲೊಂದಿದೆ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸಮಟೈಮ್ಸ್ ಅಪಿಯರ್ ಫೇಲ್ಯೂರ್ ಇಷ್ಟೇ. ಫರ್ದರ್ ಪಾರ್ಟೀಸ್ ಆರ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಅಪಿಯರ್ ಇಲ್ಲಿ 12:6. ನಾನು ಇದನ್ನ ನೋಡುವಾಗ ನಂಗೆ ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಸಿಗ್ಲೇ ಇಲ್ಲ, ಬರೀ ಆರ್ಡರ್ ಕಾಪೀಸ್. ಇದು ಇಷ್ಟೇ ಬಂತು. ಅಲ್ಲ ಅದು ಮೀಡಿಯೇಷನ್ ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. ನಾನು ಇದ್ರಲ್ಲಿ ನೋಡೋದು ಅದೇ ಅವ್ರಿಗೆ ಕಳ್ಸಿದ್ದಷ್ಟೇ ಇತ್ತು. ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟ್ ಇದ್ರಲ್ಲಿ ನಂಗೆ ಕಾಣ್ಲಿಲ್ಲ ನೋಡಿ. ಅದ್ರಲ್ಲಿ ಅಲ್ಲ ಅವ್ರು ಅದು ಕಳಿಸ್ಬೇಕಲ್ಲ. ಫಾರ್ಮ್ ನಂಬರ್ 4 there were photocopy of the record sent to the Karnataka Mediation and mediation report in form are enclosed. ಇದರಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಬರ್ದಿಲ್ವಲ್ಲ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ. he did not appear ಅಂತ ಬರ್ದಿಲ್ಲ.
The mother has appeared before the mediation, my lord, for 3 to 4 times, my lord. Very mediate itself is absence.
ಫಾರ್ಮ್ ನಂಬರ್ 4 ಇದಲ್ಲ, ಅಲ್ಲಿ ಫಾರ್ಮ್ ನಂಬರ್ 4 ಅಂದ್ರಲ್ಲ ಏನೋ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಇದು. This is the case information. ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಕಾಣ್ತಾನೆ ಇಲ್ಲ ಇದನ್ನ. ಅಲ್ಲ ಇದರಲ್ಲಿ could not reach agreement, return to the file, parties appearance. ನಾನು ಅದೊಂದೇನು ಫಾರ್ಮ್ ಇಟ್ಟಿರ್ತಾರಲ್ಲ ಅಪಿಯರೆನ್ಸ್. ಯು ಸೇ he did not appear, ಬಟ್ ಇದ್ರಾಗ ಕಳ್ಸಿಲ್ಲ ಅದು ನಮ್ಗೆ. You what do you say? He had appeared?
No.
He has not appeared there. ಬರ್ದಿಲ್ಲಲ್ಲ, ಯಾಕೆ ಫೇಲ್ ಆಯ್ತು ಅಂತ.
Only once they have appeared.
once appear ಆಗಿದ್ದಾರೆ ಅಂತ.
ಅದು ಆಮೇಲಿಂದ ಎಲ್ಲೂ appear ಆಗಿಲ್ಲ.
appear ಆಗಿಲ್ಲ.
The respondent herein
confidentiality, whatever is disclosed ಅದನ್ನ ಮಾಡಬಾರ್ದು. whether they appeared or not appeared or not.
My lord, the respondent herein in this appeal, he has appeared for 3 times, my lord. The very mediate was appointed, he has absent for the 2 times, my lord. You are regular to the mediation center.
Subject that the mediation failed because of the failure of the appellant to appear before the mediation center. However, the report of the mediation center is silent who appeared before the center and who failed to appear. Therefore, call for the further report. ಅದೇನು ಕಳಿಸ್ತಾರೆ, ನಾನು ಬೇರೆ mediation report ಗಳಲ್ಲಿ ನೋಡಿದ್ದೀನಿ. ಯಾರು ಅಪಿಯರೆನ್ಸ್ ಆಗಲಿ. ಅದೇ ಅವ್ರು ಹೇಳಿದ್ರು 3 ಸಾರಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ.
ಇವ್ರು ಬರದೇ ಇರೋದಕ್ಕೆ ನಮಗೆ ಮತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆನೆ ಹೋಗ್ತೇವೆ ಅಂತ we have been submitted.
ಡೇಟ್ಸ್ ಏನಾದ್ರು ಇತ್ತಾ ನಿಮ್ಮ ಹತ್ರ?
4 ಸಾರಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಮೀಡಿಯೇಟ್ ಚೇಂಜ್ ಆದ್ರು ಅವರು.
It's that appellant did not appear thrice. ನಿಮ್ ಪ್ರಕಾರ 3 ಸಾರಿ ಅಪಿಯರ್.
ನಾವು 3 ಸಾರಿ ಹೋಗಿದ್ವಿ.
ಅಲ್ಲ ಅವರು
3 ಸರಿ ಹೋಗಿದ್ರಾ?
ನಾವು we were regular to the mediation. ನಾವು ಹೋಗ್ತಾ ಇದ್ದೀವಿ.
Client ಕೂಡ
is present now.
he is present before this.
He was regular to the mediation center along with the child. Along with the child also.
ಅವ್ರು 4 ಮದುವೆ ಆಗ್ತವೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಗೊತ್ತಾಗದೆ ಕಷ್ಟ ಇದೆ. ಈ ತರ ಅಲಿಗೇಷನ್ ಮಾಡೋದು ಏನ್ ಮಾಡ್ತಾರೆ?
ಆಗಿದ್ದೀರಿ ಅಂತ ಎವಿಡೆನ್ಸ್ ಇದೆ ಅಲ್ಲ?
ಏನ್ ಮಾಡ್ತಾರೆ?
ಎವಿಡೆನ್ಸ್ ಇದೆ ಅಲ್ಲ? ಓ ಯುವರ್ ಪಾರ್ಟಿ ಇಸ್
ಕೋರ್ಟ್ ಮುಂದೆನೆ
brought the child.
ಕೋರ್ಟ್ ಮುಂದೆನೆ ಮಗು ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾ ಸಾಹೇಬರನ್ನ ವಾಪಸ್ ಕಳಿಸಿದ್ದಾರೆ. ಬೇಡ ಮಗು.
We have also worked, we have
ಏನ್ ಮಾಡಕ?
ಅದು ಮಕ್ಕಳಿಗೆ ಅವಾಗ ಹೇಗೆ
ಗೊತ್ತಿರೋದಿಲ್ಲ ಅದಕ್ಕೆ. I can understand the feelings. ಅದಕ್ಕೆ ಮುಂಚೆನೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. I can understand the feelings of the both parties. Including mother in law.
ಮಗು ಬರ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಮಗು 5 ವರ್ಷ ಕಂಟಿನ್ಯೂಸ್ ಅವ್ರ ಹತ್ರ
ಸಾಹೇಬ್ರು ಅದಕ್ಕೇನೆ ನಿಮ್ಮ ಐಡೆಂಟಿಫೈ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ, ಮಗು ನಿಮ್ ಕೈಲಿ ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತ ಸಾಹೇಬ್ ವಾಪಸ್ ಕಳಿಸಿದ್ದಾರೆ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ನಮಗೊಂದು ತಿಂಗಳು ಕೊಡೋಣ ಆಗ್ಲಿ ನಮಗೆ. ನಾವು ಆಮೇಲೆ ನೀವು ವಾಪಸ್ ತಗೊಳ್ಳಿದೀವಿ ಯಾರು ಬೇಡ ಅಂತ.
cannot handed over the child to the
ಸೆಷನ್ ಗಳನ್ನ ಫಿಕ್ಸ್ ಈಗೆಲ್ಲ ನೋಡಿದ್ಮೇಲೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು ಕಸ್ಟಡಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅವಾಗ ಅಟ್ ದಟ್ ಟೈಮ್
ವಿಷಯ ಮಾಡೋದು ಕಷ್ಟ ಆಗ್ತದೆ. ಅರವಿಂದ್ ರೆಡ್ಡಿ ಸೀಕಿಂಗ್ ಡೇಟ್ ಅಂತ ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ ಆರ್ಡರ್ ಬಂದ್ಬಿಟ್ಟು ನಾ ಕ್ಲೋಸ್ ಮಾಡ್ಸೋಣ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
Sir, Constable Appellant submits that appellant appeared before the mediation center. Mediation center shall submit the records of the proceedings by next hearing date. On next hearing date, both parties shall be present before the court
Yes.
with the ward list on
15th,
at one
20.
20th
at
onwards
1:30
ಆಗ್ತಾರೆ.
PM ಅಂತ.
Party sir. 20th onwards any one of the dates, my lordship.
List on
15th may kind.
ಯಾವ್ದ್ರ ಒಂದು date?
21.
21.
20. Oblige, my lordship.
21-1. Till number 26.
ಅದೇ 1:30 ಅಂತ ಹೇಳಿ. You appear before 1:30. At about 1 o'clock ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಇಲ್ಲಿ. 1:30ಗೆ ನಾವು ಲಂಚ್ ಟೈಮ್ ಅಲ್ಲಿ ಇದ್ದೀವಿ.
Yes.
Till number 26. Santosh R. Nilkudri, Gopal Krishnamurthy.
This matter for the respondent.
Yes, 8802, non-filing of petitions and deposited amount for family court. Yes, what was the order?
My lord, this honorable court on 30th January, my lord,
4,000,
stay was granted subject to condition, my lord. For
6,000.
month 6,000 was directed by this honorable court to pay to the plaintiff respondent. Now, my lord, this order has been partly complied in an execution proceeding which is posted on 7th February, my lord. My lord,
you represent the appellants,
please, my lord, they are the defendants in the family court.
right?
The
But
suit
we have to produce the proof of money if I have deposited somewhere.
They are
will
due.
produce- There is a due, my lord. Out of 1,60,000, my lord, partly he has
How much
paid-
is due?
out of 1,60,000.
1,40,000 due is there, my lord. Because from the date of suit, my lord, 6,000 was ordered.
ಅಲ್ಲದೇನೋ ಕರೆಕ್ಷನ್ ಹಾಕೊಂಡ್ರು ಅದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
Reject ಆಯ್ತು.
ಅದೆಲ್ಲ
ಅದಕ್ಕೆ. From the date of the suit, my
is
lord,
there
6
any stay here? No.
stay subject
Stay
to.
subject to
Yes,
deposit
my
of-
lord, yes, my lord.
If they are not, last time I think we have
On
given it, but
31/2024, my lord, the conditional order was passed.
correct, if we have executed that, no? If they are not deposited.
Lord, they are paying, but
Paying in a
5,000 per
quantity,
month
my
they
lord.
are paying, my lord.
But he is a retired person, my lord. Age
ಏನ್
was-
ಹಾಗಿದ್ರೆ ಏನಾರು ಮಾಡಿ ಸೆಟಲ್ ಮಾಡ್ಕೋಬೇಕಲ್ಲ.
that what I was, my friend has discussed, both have discussed, my lord. We are-
ಮಾಡ್ಸಿ.
So kindly refer the matter to the Davangere Mediation Center.
They are also aged now.
Yes, my lord.
ಏನೋ ಒಂದು partition document ಇದೆ, he has given partition, he has admitted in the
Correct.
evidence that if son was, if he was alive, he was also getting a share ಅಂತ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
But anyhow, in the pleadings, there is a silent, my lord, but the court has framed the issues without the pleading.
The court says that you have admitted that had the son alive, he was also getting a share.
Yes,
So
madam, but
that is an
in their
estate.
pleadings, my lord, there is no any single pleadings regarding any property also. my lord.
ಹಾಗಾದ್ರೆ
But we are ready to,
ಅಂತ ಹೇಳ್ತೀವಿ ಅವ್ರಿಗೆ.
no, my lord, but we are ready to settle, my lord. There are, after that,
ಸೆಟ್ಲ್ ಮಾಡೋದು 2020
there are several litigations also between the father-in-law and
ಇದೆ ಅಂತ ಬಂದಿದೆ.
even DV Act is also pending, my lord. That is also stayed by this honorable.
Yes, my lord. Davangere Mediation,
Settle
Davangere Mediation Center, it may be referred. ma'am.
refer ಮಾಡಿ.
Yes, ma'am.
Please.
Both counsel submit that there is a chance of settlement by mediation. Seek reference of the matter to Davangere Mediation
Please,
Center. In view of the submissions, the matter is referred to Davangere Mediation Center, Davangere, for mediation. The parties shall appear before the said mediation center on ಯಾವತ್ತು date?
16 or 17, my lord, this month.
17.
17 at ಎಷ್ಟೊತ್ತಿಗೆ ತಗೊಂತಾರೆ ಅಲ್ಲಿ mediation?
3 after 3:30.
3 o'clock. ma'am.
ಅಲ್ಲ ಅವ್ರು 2 ಗಂಟೆಗೆ ಅಪಿಯರ್ ಅಂದ್ರೆ 2 ಗಂಟೆಗೆ ಅಪಿಯರ್ ಆದ್ರೆ ಮತ್ತೆ ಲಂಚ್
ಆಗ್ಬೋದು. 2 PM, 2 PM.
at At 3 PM appear first.
Agu, please.
At 3 PM without any further notice.
Kindly fix a date, my lord, before this honorable,
ಅದನ್ನೇ ಮಾಡ್ತೀನಿ.
please.
You know, 3 PM. On their appearance, the center shall make all endeavors to settle the matter,
Yes.
endeavors of mediation and submit the report to this court. Okay. Communicate the copy of this order to the Davangere Mediation Center, list on 3-2.
Please, great.
Cell number 27, Somnath H, Manjunath S.
I'm appearing on behalf of the appellant in this case. My lord, the office note shows that the objections have not been filed. I have been served with a copy, my
It was
lord.
filed on 31st December 2025, my lord.
Non-filing of objections. 18th one. These objections on the 31st December file ಮಾಡಿದ್ದೀರಾ?
ಹೌದು.
In the register's place, statement of objection filed by general counsel for ಯಾರಿಗೆ ಹಾಕಿರೋದು?
Respondent.
IA number,
2 of 2024.
2, my. IA 2 of 24.
copies of the documents. ಇದರಲ್ಲಿ ನಾವು IA 2 of 2024 is for
Direction, my lord. We have filed an IA under section 151, seeking this court to direct the respondent to pay a sum of rupees 50 lakhs in furtherance of the payments that have already been made by the appellant for the educational expenses of the son born out of the wedlock between the appellant and the respondent, my lord.
see here, the interpretation of order is required.
Please, my lords, if I may invite my lord's attention to page 12 of my IA, my lord.
The hearing of the main matter itself. 121. Page?
Page 12 of my IA number 2 of 24, my lord.
Where is that memorandum of settlement?
Please, my lords.
This is the memorandum of
That is the memorandum of settlement.
Page?
It starts at page 10, my lord. The contentious clause is in page number 12, my lord.
Page initiation ಏನಂತ ಹೇಳ್ತಾರೆ? 83, ನಿಮ್ದ್ರಲ್ಲಿ 85, ನಮ್ದ್ರಲ್ಲಿ
Internal page 3, my lord.
internal page 3. Hello.
Are my lords there? If I may be permitted to read. My lord, clause 8. The first petitioner has agreed to give rupees 2,20,000. My lord, first petitioner is respondent herein, my lord. The first petitioner has agreed to give rupees 2,20,00,000 to the second petitioner towards maintenance to his minor son, which shall be paid by disposing first petitioner's immovable properties, which are stated as detailed hereunder. The first petitioner agreed to pay 50 lakh towards part of rupees 2,20,00,000 on or before 31/12/2015. The second installment of rupees 50 lakhs on or before 36/2016. The third installment amount of rupees 50 lakhs on or before 31/12/2016. And the remaining balance of 70 lakhs agreed to pay on or before 36/2017. Next clause, Miller. That the first petitioner has agreed to pay 20% of his annual income, inclusive of monthly salary, bonus, stock option, and other forms of income received from the employer after deduction of statutory dues as maintenance amount to his minor son. This will be paid by him to the second petitioner for spending the same by her towards education, maintenance, and other expenses of the minor son. Next clause, my lord. The first petitioner agreed to pay rupees 2 crore towards maintenance of the minor son as stated in clause 8, out of which first petitioner agreed to pay rupees 1 crore on or before 36/2016. After the payment of rupees 1 crore, the first petitioner need not pay any further amount towards maintenance and also agreed to settle the balance of rupees 1,20,00,000 on or before 36/2017. My lord, essentially, there has been a misinterpretation of clause 10 by the trial court in order to invalidate the very clause 9, my lord. if I may invite my lord's attention to the impugned order, if I may invite my lord's attention to,
Yeah.
please, my lords.
Seems like that, no? First, there was some arrangement that he should pay 2 crores.
20 lakhs,
No,
please. So the 20% in terms of clause 9, it should be in force till he makes.
installments were fixed. First installment 31/12/2015, second installment 36/2016, and third installments of 50 lakhs on 31/12/2016, and remaining balance 36/2017.
70. Please. Notwithstanding that, there is clause 9, my lord.
The first petitioner has agreed to pay 20% of his annual income, increase of monthly salary, bonus, etc. as maintenance.
That clause 9 is exclusive of clause 10, my lord. Merely because clause 10 mentions after a payment of 1 crore, he need not pay any further amount.
Maintenance to the minor son.
Minor son itself, my lord. My lord, one submission at the outset, my lord.
So even 20 lakhs was also to his minor son.
Correct. It is
Please.
a full and final settlement, my lord. So 2 crore 20 lakhs was the full and final settlement. So in terms of clause 9,
Second petitioner. Towards maintenance of his minor son, which shall be paid by disposing of
in the following manner.
ಅದನ್ನ ಪೇಮೆಂಟ್ ಶೆಡ್ಯೂಲ್ ಹೀಗಿತ್ತು. ಅದು ಏನಿಲ್ಲ ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋವರೆಗೂ he has to pay other maintenance. Once that is settled, he is not liable to pay.
So clause 10 clearly says that 1 crore, that 20% of the annual salary, it should be paid till he makes the first installment of 1 crore, that is on or before 36/2016, my lord. So as soon as
If
he
I may
pays
invite
1
my
crore,
lords.
the 20% of paying of 20% of his annual salary.
For the maintenance of the minor son. or-
Minor son. My lord, at the outset, I would like to place one submission on record, my lord. Please.
Please clarify to us.
Please, my lords.
13A(B), whether any amount was agreed to be paid to the wife?
Nothing, my lord. Absolutely nothing.
It has-
Only for the minor. Even today, the appellant wife is not claiming a single rupee from the respondent. She was gainfully employed. That is also recorded in the 13B agreement, my lord. Son is 18 years of age, my lord.
16 years completed.
He's 18 years of age, my lord. He correctly 18 years of age.
In her
He's a major, my lord. He does not come under the minor category. He's a major.
The liability to pay was only up till he attains majority.
Uh,
This amount plus after that he has no liability to pay for the minor son.
My lord, I believe that was not the interpretation.
Once again,
Please,
clause 8, 9, 10.
please.
Once again you read it.
Even considering that, my lord, this particular, assuming that only up until he turned 18, clause 9 was operative, the respondent has never honored clause 9. It is not their case also that he has actually paid 20% of his salary, including bonus, up until he turned 18 also, my lord.
Interconnected. Clause 8, 9 and 10. Clause
That's read
8
together.
says he has to pay 2 crores 20 lakhs. And out of that, what is the payment schedule? 50 lakhs 31/12/2015, before 31/12/2015. Whether this was paid 50 lakhs
It's paid.
and ಅವ್ರನ್ನ ಕೇಳೋಣ.
It is
And
paid.
next 50 lakhs was before 36/2016.
There was a little bit of delay, but they have paid the 2 crore 20 lakhs, ma'am.
And since there was a 2 months delay, for that also we have paid the amount.
Installment of 50 lakhs is 31/12/2016 and balance of 70 lakhs 36/2017. Now this amount is paid before 36/2007. So clause 9 was, because this was pending, it appears till the payment 20% he had to go on paying for maintenance of the child.
Until he pays 1 crore, that is the first and second installment on or before 36/2016, my lord.
He to pay 20% of his annual income, inclusive of monthly salary, bonus, stock options and other forms of income received from the employer after deduction of statutory dues as maintenance amount to his minor son. This will be paid by him to the second petitioner for spending the same by her towards the education, maintenance and other expense of the minor son.
If I may invite my lord's attention.
These payments were pending due. This year. Third,
Even during that point of time, madam.
agreed to pay 2 crores towards the maintenance of the minor son as stated in clause 8, of which first petitioner agreed to pay 1 crore on or before 36/2016. After payment of 1 crore,
This is
first
very,
petitioner need not pay any further amount towards the maintenance.
except 1 crore 20 lakhs.
So, ಹಿಂಗ್ ಅರ್ಥ ಆಗುತ್ತೆ. Why is it?
So that is
My lord,
liability of paying
if I may
20%.
invite my lord's attention to their own. If I may invite my lord's attention to their own objections, my lord. During the
See, this was for the maintenance of the child only.
child, my lord.
Both of them are well placed.
My lord, if I may place reliance on my interim application, my lord, the son admittedly is extremely bright, brilliant. He is studying in one of the best universities in the college, in the country. He has also offered admission from few of the best universities in England, but he could not take the admission due to the paucity of the amounts that were that could not be arranged by the appellant mother, my lord. Right now, admittedly, he's studying in NIT Surathkal, which is one of the best colleges for engineering in the entire country, my lord. He also has a lot of hopes to pursue masters and also PhD, my lord. And for all of these, the expenses will be a lot of expenses will be incurred, my lord. Even in their objections, they do not dispute the fact that this the son has been offered.
It's all correct, but it should be legally recoverable.
Correct.
Otherwise, they have to talk to each other and
Fine.
get that.
If that is, we are ready for that as well, my lord. If they're
The respondent is married once again. He has 2 children, minor children, who is currently aged about 3 years and 1 year to 7 months old.
He is doing now?
So he is working in Accenture, my lord.
What?
Accenture.
Accenture.
So he has few years of service, hardly like 3 or 4 years.
Yes,
And he is also underwent like heart surgery also. And he is drawing only like minimum amount, and for that, after spending all those, is left like minimum amount, my lord. And the other thing is
When did he marry?
2018,
2018.
subsequent to the mutual divorce petition, also in compliance with the settlement agreement. So he was supposed to pay.
ಅಲ್ಲ ನಿಮಗೇನೋ ಇಷ್ಟು ಹಾರ್ಟ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಕಡಿಮೆ ಸಂಬಳ ಬರುತ್ತೆ ಎಲ್ಲ ಹೇಳಿದ್ರಿ, ಹೇಳಿ ಮತ್ತೆ ಮದುವೆ ಆಗಿ 2 ಮಕ್ಕಳನ್ನ ಬೇರೆ ಪಡ್ಕೊಂಡಿದ್ದೀರಾ?
2018 ಅಲ್ಲಿ ಮದುವೆ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ದು because this execution petition was disposed on.
This liability was there even before that.
No. Till 2017, he cleared all the liabilities.
13 ನಲ್ಲಿ ಇದು ಆರ್ಡರ್ ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ, 2015 ಅಲ್ಲ. ಹೌದು. 2 crore 20 lakhs was supposed to pay on or before 30th December 2017.
17 you paid.
So he cleared all the dues. Yes.
If I may invite my lord's attention to one small aspect, my lord. If I may invite my lord's attention to page 52 of my IA, my lord. Page 52, document number 4.
IA number?
IA number 2 of 24, my lord.
Ink page, internal page, ಅದರಲ್ಲಿ 2 page.
My lord, ink page, my lord, ink page. Ink page number 52, document number.
Page number ಎಷ್ಟು ಅಂತ ಶುರು ಆಗುತ್ತೆ? Page number 74, ink page number 74, 75 ಇಂದ ಶುರು ಆಗುತ್ತೆ. ಇಂದ್ರೆಲ್ಲ ಹಾಗೆ ಇದೆ.
My lord, if I may invite my lord's attention.
ಇಲ್ಲ.
The income tax return.
ಆಯ್ತು ಅದು ಗೊತ್ತಿಲ್ಲ. ಅದು income
I apologize, my lord. There seems to be some kind of inconsistency in the page number.
income tax returns for.
For the assessment year 2016-17, my lord. My lord, this is the income tax return of the respondent for the year 2016-17. He was drawing a gross total income of 2 crore 55 lakhs back in the year 16-17 itself. And even after deduction, he was drawing a sum of 1 crore 69 lakhs 55,694 in the year 16-17 itself, my lord. And even considering their argument that 20% was only meant for the interregnum period, he has not honored that as well, my lord. It is not their case that they have paid 20% of the bonus, salary, or anything at any point of time, my lord. And their contention.
2020, my lord.
We filed the execution petition.
Why did you not file execution petition then only?
Execution petition was filed after the lapse of more than 6.5 years.
My lords,
They had not, according to this 20% clause was not satisfied.
please.
Then why did you not file the execution petition
My
immediately?
lords, admittedly, they had paid 2 crore 20 lakhs as agreed between the parties with respect to clause 10, not with respect to clause 9, my lord. All the expenses that the appellant was looking after with respect to the minor child, she was trying to bring it.
He is doing now.
She is right now unemployed, my lord. She was working in a company called Triance as a HR manager. At the moment, she's unemployed, my lord.
So in 2015 itself, she was drawing a 4,50,000 per month salary.
All of those are admitted, my lord.
Yes.
Those are matters of record.
In application, they said that
Sir, this resolution of marriage, he has remarried, legally was entitled. Married, he has
Mm.
kids also out of that marriage. Look at their this thing also.
I agree, my lord, but it is the question of the
Present education you are claiming or any future education you are claiming?
present education itself, my lord. If I may invite my lord's attention,
What did you do with that?
my lord,
moreover, there is no, please, ma'am.
if I may invite my lord's attention to page 15, my lords, of my IA.
So what exactly I wanted to point out, my lord.
ಇಲ್ಲ ಎಜುಕೇಶನ್ ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವ್ರ ಗ್ರೌಂಡ್ ಎವಿಡೆನ್ಸ್
And in all together, it is not 2 crore 20 lakhs which I have paid. I have paid 2 crores, more than 2 crore 53 lakhs. Because even before separation, from the date of separation till the filing of the mutual divorce petition, I was voluntarily paying 60,000 every month.
That is the maintenance that is referred to in clause 9, my lord.
They are saying that 20% ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. So na 20% ಕೊಡ್ತಾ ಇದೆ. Since there was a 2 months delay, even I paid 1,20,000 extra to it.
My lord, how is
Before the dissolution of marriage, whatever you have paid, that is as a responsibility.
Please,
You
no.
seek a set off for that.
The submission made by learned counsel saying that I was not paying 20%
20%
of the annual salary. Correct.
Settlement.
Correct.
it is not their contention that they have paid 20% as well, my lord. My lord, notwithstanding any of this, I'm if I may be allowed to make one
In addition
respectful
to
submission.
20 lakhs, I also paid 20% of my annual salary.
We can hear one of.
Please,
not,
If I may make one respect,
here,
please,
not
sorry.
yes.
Please.
please, if I may make one respectful submission, my lord. My lord, as I mentioned earlier, it is only in the interest of the son, my lord. So at least if the matter is referred to mediation, we can work towards a solution which is feasible for both of us, my lords. So I request my lords to at least refer the matter to mediation.
Get instruction from my client, because anyway, we have filed the statement of objection, that too along with the affidavit. So he is earning euro,
Who is earning?
that the respondent. So he is left, after spending all the expenses, he's left over only like some home loan.
What you did with that 2 crores 20 lakhs?
My lord, I have spent it on the upbringing of the child itself, my lord. If I may invite my lord's attention to page 15 of my IA, my lord. I've mentioned a detailed account of all the things I've spent the money on. Page 15 of my IA, my lord. It's a table, my lord. It looks like this.
ಅದೆಲ್ಲ ಪೂರ್ತಿ ಮಗುಗೆ ಮಾಡಿರೋದಿಲ್ವಲ್ರಿ? ಸೊಸೈಟಿ
ಇದರಲ್ಲಿ
ಮೇಂಟೆನೆನ್ಸ್ ಎಲ್ಲ
ತಾವು ಸೀರಿಯಲ್ ಆಟೋ ಮತ್ತೆ ಕ್ಲಾಸ್ ಚಾರ್ಜಸ್ ಇದೆ, ಆಮೇಲೆ ಪೆಟ್ ಫುಡ್ ಲಿಟರ್ ವ್ಯಾಕ್ಸಿನೇಷನ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಅಂತೂ ಹಾಕಿದ್ದಾರೆ, ಸೈಕಲ್ಸ್ ಅಂತೆಲ್ಲ ಹಾಕಿದ್ದಾರೆ. ಸೊ ಟೋಟಲಿ ಫ್ರಮ್ 2015 2020 they need to establish saying that they have incurred 2,68,55,510. In total they are mentioning.
2 crores.
ಇದ್ರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. ಬಟ್
The
if you
pet
look
belongs
into
to the child itself.
if you look into the particulars, ಆ ಪೆಟ್ ವ್ಯಾಕ್ಸಿನೇಷನ್ ಗಂತೆ ಅದಕ್ಕೆಲ್ಲ ಸ್ಪೆಂಡ್ ಮಾಡಿರೋದು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ದಾರೆ.
My lord, all of those are expenses. The pet belongs to the child itself. They are not disputing the fact that
Child not to his pet. This is too much.
And moreover, she was working and she was earning handsome salary.
ಅದು ಬಿಟ್ಬಿಡಿ ಅವ್ರದ್ದು.
ಅಲ್ಲ,
ಆರ್ಡರ್ ಇಸ್
ಕರೆಕ್ಟ್. ಅವ್ರ ಸ್ಯಾಲರಿ ಅಟ್ಲೀಸ್ಟ್ ಅವ್ರ ಮಗು ಏನ್ ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ ನೋವೇರ್ ಮೆನ್ಷನ್ಸ್ ಇನ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ ಇನ್ ದಿ ಪಟಿಷನ್.
she is the one who has been taking care of the child ever since,
She was
my
not
lord.
working and she was drawing handsome salary. And ಈಗ ನಾನು 2,53 lakhs ಕೊಟ್ಟಿದ್ದೆ, ವೆದರ್ it was kept in FD ಅದ್ರ ಬಗ್ಗೆನೂ ಏನು ಹೇಳಲ್ಲ.
ಕ್ರಿಕೆಟ್ ಬ್ಯಾಟಿಂಗ್ 2-3 sets. ಆಮೇಲೆ ಕ್ರಿಕೆಟ್ ಫಿಸಿಯೋ ಜಿಮ್, ಆಮೇಲೆ ಸ್ಪೈಕ್ ಶೂ ಫಾರ್ ಬೌಲಿಂಗ್, ಎಲ್ಲದಕ್ಕೂ ಒಂದೊಂದು ತರ ಶೂನ.
He was actively involved in a lot of extracurricular activities, my lord. They're not disputing that, my lord.
100 years of ವಾಲ್ಡಾರ್ಫ್ ಸೆಲೆಬ್ರೇಷನ್ ಏನಿದಂಗಂದ್ರೆ ನಮ್ಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. ಇದು
Yeah, my lord.
ಅದನ್ನ ಮುಂದಿನ ನೋಡಿ ಇದನ್ನ ಅಲ್ಲಿ ಇದೇನೇನು ವಾಟ್ ಇಸ್ ದಿಸ್ ಮೀನಿಂಗ್ ಆಫ್ ದಿಸ್ ಟ್ರಾವೆಲ್ ಫಾರ್ 100 years of ವಾಲ್ಡಾರ್ಫ್ ಸೆಲೆಬ್ರೇಷನ್?
My lord, that is a particular location where he had been to a tourist destination, my lord.
ಇದೆಲ್ಲ ಹೇಗ್ ಬರುತ್ತೆ? Tomorrow you will not be able to maintain your child also if you make the child used to this kind of lavish life.
My lord, that is the kind of life that the child was used to even before there was any kind of turbulence between the.
See, we do not, it's very difficult to accept all these kinds of submissions. Now, he has 2 children. What about the fate of those two children?
My lord, that is absolutely not under dispute. My only submission is that this particular child, who's admittedly bright,
Promote cultural, 3 lakhs, 3,50,000, 3 lakh. ಏನಿದು ಯಾವ ಕಲ್ಚರ್ ಇದು? 3 lakhs ಡಿಮ್ಯಾಂಡ್ ಮಾಡೋದು?
no, that is for 3 years, my lord, for 15, 16 and 17.
New clothes as you outgrows.
ಇವನ್ ಸೊಸೈಟಿ ಮೇಂಟೆನೆನ್ಸ್ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅದ್ರೂನುವೆ.
ಮತ್ತೆ ಇಲ್ಲೊಂದು ಕ್ರಾಕ್ಸ್ ಅಂತ ಶೂಸ್, ಅದು ಬರೀ ಶೂಸ್ಗೆ ಖರ್ಚು ಮಾಡೋದೆಲ್ಲಾನು ಬಾಸ್ಕೆಟ್ಬಾಲ್ ಶೂಸ್.
My lord, he was very active in sports, my lord. Even in their objections, they have mentioned about.
PT Usha was also very active in the sports. She brought Olympic to the country. ಇದು ಈ ತರ ಮಾಡಿನ.
My lord,
You should advise them.
please, my lords, that is precisely why I'm seeking for this matter to be referred to mediation, my lord. Like I mentioned at the outset, my lord.
Birthday party 30,000. ಇದೆಲ್ಲ ಏನ್ರಿ ಇದು?
My lord, admittedly, they were living a kind of lifestyle which can be considered elite.
Not 24 pitchen or 26 pitchen, 25 pitchen.
My lord.
They were used to that lifestyle ಅಂದ್ರೆ ಮಕ್ಕಳಿಗೆ ಕೊಡೋದಿದು.
And moreover,
Some difficult for the mother also to.
And in addition to 2,53 lakhs which I have paid, I have also given property which is located in a prime area, JP Nagar.
My lord, it is not as if he gave the property. They've also produced the other documents.
The income certificate which currently stands in her name.
Of this class, we submit all that things.
My lord, just one submission, my lord. As far as those interpretation of the clauses concerned, I will do some research and I will come back before this honorable. One date may kindly be given.
Now you took half an hour and again you want to come back.
my lord.
It is there only order. You please tell us what is your interpretation and let him tell what is his interpretation, then we'll decide.
My lord, I will mention the interpretation in order to support that with a few citations. If I may be given a short date also, that is sufficient, my lord.
The clause is very clear. In the section, like clause 9 will be enforced till I makes a payment of 1 crore, my lord.
ಸರಿ, ನೀವು ಹಾಗೆ ಮಾಡ್ತೀರಾ. ಇಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆ ಪಾರ್ಟೀಸ್ಗಿಂತ ಅಡ್ವೊಕೇಟ್ಸ್ ರೋಲ್ ತಗೊಂಡ್ ಬಿಡ್ತೀರಾ.
ಇಲ್ಲ.
ನಾವು ಯಾರು ಕಮ್ ಪ್ರಿಪೇರ್ಡ್ ಮಾಡಿದ್ದೀರಾ, ಅದ್ ಏನಿದೆ ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇನೆ. ಮತ್ತೆ ವೈ ಇನ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಫಾರ್ ದಟ್, ವೈ ಮೇಡಮ್ ಇಸ್ ಆಲ್ಸೋ ದೇರ್ ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಓಕೆ.
Whether the agreement entered into between the parties and the contracts entered into or not. Only thing is whether how that interpretation has to be read, whether there should be a full stop on to 20
That's
should be extended beyond that. That's all
the question is whether he was liable to pay the compensation at 20% of income even after the satisfaction of 2 crore 20 lakhs
or not.
or
That's all they have to before this honorable.
on satisfaction of that liability seized.
Correct.
So ishta irodu.
Question irodu ashte. What part they have spent, where they have spent, all those may not be available. But if the matter.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರು ಅಂತ ನಾವು ಕೇಳಿದ್ವಿ, ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಕೇಳ್ತಿರ್ಲಿಲ್ಲ. You read a lot. We know that you asked them to read Thomas Alva Edison and many such people, Marie Curie. How did they come up in the life?
If the matter is referred to mediation, whether they can consider about taking responsibility of educational expenses in a given manner for a limited period is one thing that can be considered. If that is not, then ultimately this court may have to consider and then pass an order, my lords, as to whether that interpretation would fall under first category and there is a full stop, or the second clause will also have to be construed, because those otherwise there was no need for them to write the second clause at all. That's what your lordships will have to interpret, and it's a mediation settlement.
Mediation, if he agrees, we can send it, because mediation, both the parties have to agree to for
Correct.
to the mediation. Yes, what do you say? Mediation kalsi anta ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
I need to get the instruction from client, Your Honor, because anyway, like as per the settlement agreement, I have paid all the monies. There is no outstanding. Please.
They are saying send it to the mediation.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದ್ರ ಪ್ರಕಾರನೇ ಕೊಟ್ಟಿದ್ದೀವಿ, because that is what my client instructed, saying that I also paid additional like 20% ಅಂತ. So I'll get the instructions. Suppose.
Otherwise, next date, we will just place 5 minutes of our argument and close. Otherwise, if he is not agreeable for mediation minutes, next date, we will just make 5 to 6 minutes of our submissions and.
121 ಅಲ್ಲ. After arguing the matter for some time, Timothy Sushila, Leonard Senior Counsel, appearing for advocate on record for the appellant, submits that the matter may be referred to the mediation. The counsel for the respondent seek time, take instruction from the respondent for regarding
Please.
mediation. List on nimge, if you are not, if at all you want to go for mediation, you not spend the time of this court like this. So 2 weeks ಅಲ್ಲ, ಒಂದು ವಾರ ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ, ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ.
20th.
20.
Cell number 28, Sunil Kumar S, SPP.
Appearing for the applying matter.
How many times you seek adjournment? ಬೇಡ ಅಂತಂದ್ರೆ ನಾವು
Last time minutes.
not last time.
Annual money, so money.
Previous roster allo.
ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇಲ್ಲ ಅಂದ್ರೆ ವಿತ್ಡ್ರಾ ಮಾಡಿ, ಇಲ್ಲ ಬೇಡ ಒಂದ್ ವರ್ಷ ಬಿಟ್ಟು ಹಾಕಿ ಅಂದ್ರೆ ಒಂದ್ ವರ್ಷ. ಈಗ ಹೋದ ವರ್ಷ ಇತ್ತಿದ್ದು ಮೆನಿ ಟೈಮ್ಸ್ ವಿ ರೆಡ್ ದ ಫೈಲ್. We are being punished by this.
No, it's in the next statement.
We'll impose cost.
Kindly give us the last answer.
No, we'll impose. ನೀವೇನಾ ಸುನೀಲ್ ಕುಮಾರ್ ಇವ್ರೇನಾ?
Our colleague.
ಅಲ್ಲ ಇನ್ನೊಬ್ರು ಯಾರೋ ಬರ್ತಿದ್ರು. ಎಷ್ಟ್ ಸರಿ ನಮ್ಮ ಮುಂದೆ ಎಷ್ಟ್ ಸರಿ ಆಗಿದೆ ನೋಡಿ ಇದು. Every time we have to come, read and come, and you go on seeking the adjournment.
Second speaking and one branch. Next date of hearing is.
21 alone ಬಂದಿತ್ತು. ಮೊದಲ ಸರಿ ಓದಿಸಿದ್ದಾರೆ ಬಂದಪ್ಪ, I remember many times ಹೆವಿ ಇರುತ್ತೆ, ಏನಾರ ಇರೋದಿಲ್ಲ. ಎಷ್ಟು ದೊಡ್ಡದಿದೆ ಕುಡಿಯೋದು ಅದ್ರದ್ದು ಚಾರ್ಜ್ ಶೀಟು ಅಷ್ಟೇ ನಾವು ನೋಡ್ಕೊಂಡು ಬರ್ಬೇಕು. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಹೇಳೋದು ಮತ್ತೆ ವಿಲ್ ಇಂಪೋಸ್ ಕಾಸ್ಟ್. ಎಷ್ಟನೇ ಸರಿ ಕೇಳ್ತಾ ಇದ್ದೀರಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್? We have to go through the records and come here, and you very casually come and seek adjournment.
Kindly notes. The last answer, next time.
Now counsel for the appellant seeks adjournment. The records show that though the matter is listed for several times, the adjournment is being sought. By such conduct, the court's time is here diverted. However, to grant a final chance, custody ನಿಮ್ಗೆ ಅನುಕೂಲ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಯಾರ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ ಅಡ್ವೊಕೇಟ್ ಎಂಗೇಜ್ ಮಾಡ್ತೀವಿ. If you find it inconvenient to argue the matter,
The next date will be.
as a final chance, list on
2 weeks again.
20th. 2 weeks.
ಅಂಡರ್ಲೈನ್ ಮಾಡಿ ಇದೆಲ್ಲ ಮಡಿಚಿ ಹಾಕಿ
T1. Number 29, government advocate.
Madam, third respondent appeal, madam. Case of injury, they have produced the receipt of having deposited the 50% of the amount before the MSCT court, madam.
Oh, KCI.
Please.
You have deposited
Please, madam. We have produced the memo on 23/11.
memo for having deposited amount. Yes. Yes. Contest ಮಾಡಿಲ್ಲ. ಇವರು contest ಮಾಡಿಲ್ಲ.
Please.
You had not contested, no?
No, madam. Expert order has been passed and also the
ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ, ಎಕ್ಸ್ಪರ್ಟ್ ಎಲ್ಲ ಅಪಿಯರ್ ಆಗಿ ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ.
appear ಆಗಿರೋದು my lord, only respondent number 1, 2 and
AGP
4, 5. Please, madam.
Oh.
But 3 KGAD has been placed ex parte, madam.
ಕರೆಕ್ಟ್. ಆದ್ರೆ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅವರಾದ್ರೂ ಕಾಂಟೆಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ. And they were all part of the same.
These vehicle involved in this accident, no valid
ಡೈರೆಕ್ಟ್
insurance.
KGID and 5 ಡ್ರೈವರ್.
Please,
ಅವರಿಬ್ರು ಎಕ್ಸ್ಪರ್ಟ್.
please.
ಉಳಿದವ್ರಿಗೆಲ್ಲ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
But cross
ಪ್ರೈವೇಟ್
even
ಪರ್ಸನ್.
no cross has been cross examination.
ಯು ಆರ್ ನಾಟ್ ಎ ಪ್ರೈವೇಟ್ ಪರ್ಸನ್. ನೀವೇ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆಯವ್ರು ವಾಟ್ ಅಬೌಟ್ ದ ಅದರ್ ಕಾಮನ್ ಪೀಪಲ್?
Apart from this, madam, there is no valid insurance in respect of the vehicle.
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದು. The order was to deposit before the court, alva?
Please, madam. Court will
But
be-
where is the proof of deposit before the court?
We have produced, it, madam,
ಇವತ್ತು
regarding TD and on 23,
ಲಾಸ್ಟ್ ಟೈಮ್ ನಮ್ಗೆ ತೋರಿಸಿದ್ರಿ.
23/11/2024, we have deposited. Was office.
ಇವತ್ತು
23/11/2024, we have produced it before this honorable court.
ಕೋರ್ಟ್ ನಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಲ್ಲ ಇದು. ಏನೋ
TD
ನಿಮ್ದು
is there, madam, on 3/10/2024, madam, before the MSCT court.
ತೋರಿಸಿದ್ರಿ.
May I produce, it, please.
MACT ಸೀಲ್ ಎಲ್ಲಿದೆ ಅದರಲ್ಲಿ?
Pandapura, please.
ಅದೇ ಇಲ್ಲಿರೋದು. ಇದ್ರಲ್ಲಿ MACT ಸೀಲ್ ಎಲ್ಲಿದೆ?
Like, we have produced the DD before the MSCT court, deposited that DD, madam.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಆಗಿದೆ. ಅದು ತೋರಿಸಿ ನೋಡೋಣ ಆರ್ಡರ್ ಶೀಟ್.
But we have not obtained order sheet.
This we can't accept as proof of deposit.
TCR ಇದೆ.
ECR ಅಲ್ಲ, ECR ಮೊದಲೇ ಬಂದಿತ್ತು ಸರ್. ಆಮೇಲೆ ತರಿಸಿದ್ವಾ? ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ, ಈ ಡೇಟಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಿದೆ ಏನೋ ನೋಡಿ. 10/11/2024 ಇದು ದೃಢೀಕರಿಸಿದೆ
In the
ಅಂತ.
challan it is clear.
ಯಾವ ಡೇಟಲ್ಲಿ ಮಾಡಿ? 3/10/2024.
Please madam, 310.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ 3/10/2024 ಏನಾದ್ರು
In MEC number 211 ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ madam. MEC number 211 they have deposited on 3/10/2024 in the.
ಕರೆಕ್ಟ್ ಹೀಗಿರುತ್ತಿಲ್ಲ ರೀ, ಅದು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಅವ್ರದ್ದು ಕೋರ್ಟ್ ಸೀಲ್ ಇರುತ್ತೆ ಅದರಲ್ಲಿ.
Please madam, I will get it.
ಫೋಟೋ ಸರ್ ಬಂದಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. 3/10/2024 ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ when this award was passed?
Award was passed on
18th October 2023.
24.
18th October 2023 ಆದ್ಮೇಲೆ ಏನಾದ್ರು ಬರ್ದಿದಾರ ಇಲ್ಲ ಅಂತ? ಇದು ಹಳೆ ಸಬ್ಮಿಟ್ ಅಂತ ಇದು ಪ್ರಕರಣವನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ನಮೂದು ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದು ಕಡತವನ್ನು ಇದು ಬರೀ ನಂಬರಿಂಗ್ ಇಲ್ಲಿ 12/12/2024 ಇದೆ 310 ಅಂತ ಹೇಳ್ತಾರೆ. ಆದೇಶವಾಗಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಿ ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ ಯಾವುದೇ ಎಂಟ್ರಿ ಇಲ್ಲ.
Kindly have it and next week I will get the details. Sometime dummy order sheet ಅಲ್ಲಿ deposit ಮಾಡಿರ್ತಾರೆ.
ಡಮ್ಮಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲ, ಇದು ಕೋರ್ಟ್ ನಮಗೆ ರೆಕಾರ್ಡ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೇನೆ. ದೇ ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್ ಇಟ್ ಆಫ್ಟರ್ 12/12/2024. 12/12/2024 ಇಸ್ ದ ಲಾಸ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ನೋಟೆಡ್. ನೀವು 310 ಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತೀರಿ. 310 ಗೆ ಯಾವ್ದು ನೋಟ್ ಇಲ್ಲ ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಕ್ಕೆ.
Kindly have it and next week I will get the details.
ಅಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟೇ ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡೋ ಆಗಿಲ್ಲ. ವಿಲ್ ನಾಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ದ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್. This is not the proof of the deposit. Admit ಮಾಡೋದಕ್ಕೆ ಅವ್ರಿಗೆ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು. ಇಲ್ಲೇನೋ ಬರ್ದಿದ್ದಾರಲ್ಲ, ಇದು ಬರೀ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ. No proof of the deposit of the amount in compliance the interim order of this court is produced. 50 to 35.
Cell number 29.
Counsel for the Leonard AG.
Yeah, please ma'am.
ಏನ್ರಿ ಇದು ಹೀಗೆ ಮಾಡಿದ್ರೆ ನೀವೆಷ್ಟು ತೊಂದರೆ ಕೊಟ್ರೆ ಬೇರೆಯವ್ರದ್ದು ಹೇಗೆ?
Please.
Leonard AG seeks time to produce the proof of the deposit before the tribunal.
Tribunal ma'am.
Deposit of the amount before the tribunal as a final chance list on
Next week.
ಕಂಪ್ಲೈ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಅಡ್ಮಿಟ್ ಮಾಡಬಾರ್ದು.
23/1.
Budget.
Cell number 30. Hitesh Gowda BJ, Rajita TO.
May it please. My lords, in view of the peculiar circumstances of this case, we had moved this matter before the vacation judge also. It's a case, my lords, where the child was in the custody of the grandparents ever since it was 1 year, 7 months old. It had completed 1 year, 7 months, 1 year, 8 months old. The child was with the custody of the grandparents. The grandparents had also, and there was an aunt who is a spinster who were taking care of the child. They filed the JNWC 4 of 2020 before the Honorable Court. The daughter, who is the mother of the child, was elsewhere working in Singapore and elsewhere, my lords. So during that period, the child was completely with the grandparents. Then we filed a petition when the parents wanted to take back the child. We filed a petition in JNWC 4 of 2020. And they also filed a petition in JNWC 9 of 2020. Both the cases were dealt with by the family court. And at the end, the family court passes an order stating that, but for the, I would have given the, handed over the custody of the permanent custody of the child to the grandparents, but for the fact that they are old is what the court has said. That's one thing. And PW6 evidence is forthcoming on record before this honorable court also. I have made it that you can. PW6 is a, my lords, para 91 of the judgment will clearly indicate what transpired. Page, internal page, sorry, ink page 102, page 64.
Yes. Yes. Yes.
If I am not disturbing your lordship, I would like to read this paragraph.
Yes.
91. One Debasmita Sinha is examined as RW6 and she has stated in her chief evidence by way of update that she is a clinical psychologist and she has treated the ward from 3 years. The respondent 1 had consulted her in 2018 to help the child from separation anxiety as she was considering starting school for him. In 2019, he came for 2 observations, complete sessions. Support was provided to him through aunt and maternal grandparents from 20 to 2022. That's the appellants before your lordship. Support continued through aunt and grandparents. She made home visits to Mysore and child's observation and assessment. His support and treatment to the child was through video call from 2022 onwards. Rian started his course of prescription psychotropic drugs in 2023. She made home visit and continue with regular online sessions. Rian is experiencing anxiety when separated from primary caregivers, when facing change or being introduced to someone or something. His social skills and enunciation were delayed when compared to age norms. His linguistic, logical thinking and creative skills were adequately developed when compared to age norms. He has undergone adverse childhood experiences, emotional neglect, and apt abandonment by both parents. The police raid at his residence, approximately 10 court visits and 80 mandated visitations, of which several were forced, including some under observation by court officials, his caregivers being threatened by his biological mother and other authority figures, had a profound impact on his mental health. He began to experience panic, anxiety, acute emotional dysregulation, and intense aggressive episodes. He has been in therapy and under medication since May 2022. The goals of therapy have been to help him understand his own volatile emotional experience as an outcome of his life experience and not innate, empower him to regulate his emotions, hold and express his thoughts and emotions appropriately without shame, address, etc., help fear of being split from his family. But his biological mother instilled hope and agency, enhance the quality and diversity in his social interactions to improve his social skills and establish a sense of safety in the world and people and family, etc. in a short period. We are therefore inclined to allow the appeal, whatever it is, my lords. Now, your lordship may kindly see, my lords. Coming to this, my lords, the court at the end, one sentence I would like to read, my lords. The court has said, my lords, the court says, my lords, the grandparents are aged, hence I do not want to leave the child with the custody of the grandparents. Now, the situation today, as on today, is like this, my lords. Post this, the operative portion of the order clearly says, my lords, we have the petitioner number, if your lordships were to see 138, 158, my lords, page 158.
Yes. Yes.
The petitioner number 1 so and so, second paragraph I am reading, are hereby given custody of dash. Respondent's third paragraph are directed to hand over the custody of child within 1 week from the expiry of appeal period, failing which the petitioners are at liberty to obtain custody of the child by due process of law. This was the order passed, my lords. We filed an appeal and we moved the vacation bench also, my lords. In between, they had filed an execution petition before that 1 week plus all. And then, my lords, in between what happened was, my lords, on the order was passed by the family court on 12/11/2024.
What is that?
Judgment, trial court judgment. Family court judgment is 12/11/24.
Oh, this is 12. Yes.
The certified copy of the judgment was ready on 21/11. We filed, we obtained on 23/11. We filed MFA on 16/12, my lords. Now, my lords, they filed an execution petition on 2012. So ideally, when they had filed an execution petition, they should have taken the custody through the court because that's what the operative portion. Suddenly, my lords, on 22/12, they come there, talk to the child. While interacting, they take away the child and a police complaint is also filed. Until this day, they are not here. And an order has been passed by the vacation court. Then we requested, we are very anxious about the welfare of the child. We requested the vacation court on the last occasion passed an order that they should be present before the family court for visitation at least. The child is with them. The court felt that.
Vacation court order? 3012. 3012.
ಹೌದು. Mediation center ನಲ್ಲಿ they can visit ಅಂತ ಮಾಡಿದ್ರು. We were waiting there from 10:30 to 1:30 and the child was not produced there. None of them appeared and we started sending several messages and we a request to the council also. Council was also requested. Council said that they would be coming and then later even the council got disconnected from us for, I'm not here to blame on the council. I'm only requesting that they are not cooperating. The parents are not cooperating. Now the situation is.
This 30/12/2024 order, both were heard while passing this order?
Yes. The counsel for the other side was appearing through online and they submitted that the child is with the parents and they have taken the child to Mumbai. That's where the court said, fix on a date and time so that the visitation can be facilitated.
Bangalore mediation.
Please, ma'am. On 25, on that day, my lords, we were waiting in the center. They did not come. And because the council was there on record on the earlier date of hearing, my lords, this was also known to her and this party. Now, my lords, 2 applications are pending before your lordship. One we have filed, my lords, for stay of the operation of the trial court order. In between, one more strange thing has happened is, they have withdrawn their execution petition itself. Execution petition al namge notice bantu. The vacation bench asked the same question. How could you have filed the execution petition before the time gap was over? They filed the execution petition earlier. And in between, they took the law into their own hands and took away the child. Now they have withdrawn the execution petition also. Now, to be on the safer side, I request your lordships to kindly pass an order staying the operation of this. And we have also filed an application now that the child is taken away by them.
Now what is to be stayed now?
Pardon, my lords?
What is to be stayed now? You say that they have already taken the child.
They have taken the child. Should the
Now your visitation rights will also be stayed.
No. Operation of the impugned order, asking me to, that's an independent order which your lordships may kindly pass. Impugned order says hand over the custody immediately.
My submission, my lord. May I make a submission, my
Your
lord?
lordships.
Hearing
Your
for the
lordships.
respondents.
Your lordship's question is right, my lords. The trial court ordered us to hand over the custody. We have not handed over the custody. They have taken away the custody, snatched the child from us. That wouldn't amount. So it has to be status quo ante position has to be restored. A contempt has to be initiated against them. I don't say that we would go to that extent of punishing them. All that I'm looking at is allow now this matter has to be heard.
Very strange. Parents, daughter, and
Very, very strange, my lords. The mechanism is very strange. 7.5 years.
you are fighting, both of you are fighting over the child like property.
That's where I told them, my lords. The question here is the parenting. The parents, biological parents are one aspect. The impugned order also says, my lords, if your lordships were to see 159, they said hand over the custody and in between I should be given access to the child through video calls, etc. was there. Even we were cut off from the child. My respectful submission would be two here, my lords. One is on an interim measure and another one is, my lords, at the earliest on merits this matter may kindly be disposed of so that there is finality in the life of the child. The child should know whether I should be here or there. That finality has to be, that's where I'm requesting this honorable court. This is a special case, my lords.
Most of them were interested really in the welfare of the child. They were settling it.
This is
amicably, not in this way.
in a way,
My lord, three or four times it was sent for mediation. The grandparents were never agreeable for a settlement. We were actually agreed for a settlement, and we moved forward for seeking the benefit of the child. The child, being 10 years old, is not sent to any school till date. And they are saying that psychological problem. Last 2 weeks, we are having counseling for the.
At that age, some medicines were given. That RW6 was that her evidence shows that
RW6 is a psychologist, my lord. He was actually in a report was given by NIMHANS stating that the child is normal. They are relying upon a psychologist report, which is their witness. And your lordship may come to point number.
Recommended for continuation of medication also.
Not only now the child is not under any medication for the last 2 weeks. I may be allowed to produce the documents from NIMHANS, my lord. The child is going for counseling to get into some school because 10 years he's not been sent to school by grandparents being overprotective. They are not sending him to any school. Anything was not done, and they were not having allowing any kind of interactions with the parents. We had filed 2 contempt petitions to allow interactions with the parents when visitation was allowed to the parents. Only after that, after 3 years, they permitted visitation. So the child actually, not only because of the age, their visitation was not granted. Here, the learned trial judge has actually said that grandparents were unable even to look after the health of the child, and also not to was unable to provide proper education. So the welfare of the child is not taken into consideration. That is the reason.
Which paragraph of the judgment?
114.
104.
114. It is pertinent to note that the respondents have left Pune in the year December 2019 until 2030.
So respondent's reference here, response means grandparents or
The grandparents, my lords.
grandparents?
Yes, ma'am.
No, please read that 114.
It is pertinent to note that the respondents have left Pune in the year December 2019 until 2023. There is no attempts being made to get the award admitted to any outside school. Only when there is direction from the Honorable High Court of Karnataka to admit the child to school, attempts were made to get the child admitted to school. Though COVID was in the year 2020, thereafter the same had subsided. In spite of the same, the child is not sent either to special school or regular school. In the guise of COVID-19, the child is not made to send to any school. Thereafter, admittedly, the difference of opinion between the petitioners and respondent to 0 down to 1 school did not pave way to get the ward admitted to any school. When the ward moved to Srirangapatna, the ward was aged about 4 years. As such, an academic year school was not mandate. The child could have been sent to a play home, babysitting, etc. No such attempts have been made by the respondent to join the child to school from December 2019 to March 2020. Till the commencement of pandemic period, even after the COVID-19 subsided, the respondents have failed to provide education for the minor child. The respondents are providing home teacher for the reason best known to them. When after COVID, the children of the age group of the ward in question were going to school, RW3 states that one Mrs. Meline Brasher is said to have taken 5 hours class to Rian at home, during which she covers the curriculum of grade 3 recommended by 21K school. The report suggests that the ward is unable to read and write anything. The child is said to have attended online school during COVID. There is no school receipts produced. The question is why thereafter the child is sent to online school. The child is not sent to any outside school when the RW 4 to 6 state child can go to school. This reflects that respondents are unable to provide proper education to the child, my lords.
Then paragraph 119, my lord. 115, the respondents claim that the child has anxiety issues and mental issues. In exhibit R 26, page 34, it is stated that the respondents are given referral letter to facilitate consultations with the mental health professionals at Mysore Medical College. The last visit was on 25/4/2023. There was no consultation being made as per the advice.
These medicines were given.
Yes, without any prescriptions, they have administered medicines, my lord. And after that, they went and got prescription, and then they said that my medicines were continued. So that is the reason we are saying that the child, these are the reasons that trial court judge actually refused custody to the, and there is no reasoning for grant of visitation. I have filed my MFA cross objections, and both of them, both the MFA and this may be heard on detail, my lord, before.
From the previous psychiatrist. ಹೀಗ್ ಮಾಡಿದ್ರೆ it may have to go to this child welfare committee ಹೀಗೆಲ್ಲ ಆದ್ರೆ.
Yes, my lord, we have not done that because it's the child's grandparents. Actually, that is the reason we have not gone for that.
One more thing, my lords.
You are not proved the prescription of any psychiatrist, but the child was administered, what are these antidepressants? Some medicine name they have written.
My lords,
Let us
there has been a committee of the doctors.
That is 0.5 mg.
My lords, those are all administered based, no doctor.
Whom did you examine in proof of this prescription of?
My lords, there were several committees formed. Your lordship may kindly see here.
Tell us which witness speaks about this, about prescribing this medicine.
Exhibit R5 is a psychological evaluation report and recommendation report is there. And then
Correct. Which doctor prescribed this medicine?
R26, 27 is there. Medical reports are there.
We are asking you one question.
Please,
We
madam.
have examined RW 4 to 6 doctors. Which of these doctors prescribed these medicines?
RW4
First
is Dr.
prescribed, my
Isha
lord.
Sharma.
No, my
Dr.
lord,
Isha
no, my
Sharma
lord.
From NIMHANS.
They are
From
making a false statement. They are making a first prescribed by some other doctor, and they said the grandfather said that he is under medication of the same medicine. So the doctor continued the medicine because the grandfather had told them. That is clearly stated in the evidence.
Have you produced that prescription issued by this doctor? Now it was being prompted to you that RW4 has prescribed that medicine.
I am given to understand, my lords, they have been produced here. Your lordships will get it at 26 and 27.
Because it's a very delicate matter.
Yes, yes, it's a very
kinds of drugs to a
Yep.
child.
If it is.
My lord, I will specifically bring a report.
This is a
NIMHANS
serious
has now
matter.
stopped the medicine. No,
This is a
NIMHANS
serious
has now
matter.
stopped the medicine. This is a serious matter. NIMHANS has stopped the
This
medicine.
is a serious matter where whether any acts done by the grandparents in the capacity of parenting can be found fault with is one thing. Another one is whether they did all that they could do and still the child is being taken away from them because of their old age, because that's what this last paragraph says. 116, the court says that because they are of age and the father is aged and the mother has.
Any vested legal rights to claim the custody of the child?
There are two aspects. My lords, there are n number of citations where the courts have held that.
Governed by which law?
Hindu law only.
Hindu.
Guardians and Wards Act, and now the courts have, I have to bow down to this honorable court that now the law is completely different as far as child is concerned. The court need not have to look into the personal laws at all. It is only the interest of the child that will be looked into. So ultimately your lordships may say the child can be with A, B, C or with X also. That is with the court.
We'll send it to the Child Welfare Committee.
Child Welfare Committee nalli, I have a lot of respect. Child Welfare Committee nalli.
There was a story, you might have heard it. Probably.
Solomon's child.
I'll split it, I'll give it to 50% ಇಬ್ಬರಿಗೂ ಕೊಡ್ತೀನಿ ಅಂದಾಗ.
I was suggesting, my lords. I was suggesting they are all connected to each other. I was suggesting the child should get the safety. So I was suggesting,
Unfortunate thing is that this is parents and daughter.
there is a special attachment. There is a special attachment of the aunt towards the child, which may not be appreciated by the original mother. I do not want my child to be completely attached to my sister is one aspect that's there. These are all,
Really, in all families, maternal uncle, maternal aunts, they're getting close to the children. Mothers also relish that. It is your experience, our experience.
some cases they may not, but I thought of this, my lords.
Possessiveness ಅವ್ರ ಹತ್ರ ಬಂದಿದೆ ಅಂದ್ರೆ they may not relish it.
Now, my lords, my respectful submission would be this, my lords. I thought whether we can give complete safety, emotional safety and physical safety to the child so that the child doesn't see them as their enemies. For one group of persons are not seen as.
How much child gets confused in this?
Very, very true, my lords, very true. That's where, my lords, I am requesting this honorable court. Records may kindly be called for and then finally disposal ಆದ್ರೆ ಅವ್ರಿಗೆ ಒಂದು ಹಣೆನಲ್ಲಿ ತಮ್ಮ ಹಣೆನಲ್ಲಿ ಏನ್ ಬರ್ದಿದೆ ಅನ್ನೋದು ಗೊತ್ತಾಗುತ್ತೆ. ಇಲ್ಲದಿದ್ರೆ ಮಗು ನಮ್ಮ ಹತ್ರನೇ ಇರಬೇಕು, ಅವ್ರು ಬಂದು ಎಷ್ಟಾದ್ರೂ ವಿಸಿಟೇಷನ್ ಮಾಡ್ಲಿ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ ನಮ್ಮ ಹತ್ರ ಮಗು ಇರ್ಲಿ ವಿಸಿಟೇಷನ್ ಮಾಡ್ಲಿ ಅಂತ.
Parents also at certain point of time, all of us have to part from this world.
Very true.
On protection ಬೇಕು. And of course, similarly, grandparents company is the best company for the children at the formative age. But both of them have to understand.
Whether it could be a joint parenting structure that they can work all of them together is.
Parenting.
It's a parenting structure that we are putting. Parenting is not by biological parenting persons only. The parenting in a general. Taking care of the child, giving the best emotional quotient.
Development of the child.
ಹೌದು, overall development of the child. ನಾವೆಲ್ಲ ಸೇರಿ ಏನ್ ಮಾಡ್ಬೋದು ಅನ್ನೋದನ್ನ ಯೋಚನೆ ಮಾಡಕ್ಕಾಗತ್ತಾ ಅಂತ ನಾನು ಯೋಚನೆ ಮಾಡಿ. I am not trying to exclude mother and father from the child. No, the answer is clear no. Whether there can be an inclusive family for the child so that the child will get all the emotional quotients.
Parents can say that mother is not able to take care of the natural mother, guardian.
ಅಲ್ಲ, they cannot ಅನ್ನೋದಲ್ಲ. It has been with.
They are saying that mother is not fit person to take care of her child. Is it their contention?
ಅಲ್ಲ,
Their contention was this, he was not, yes. No. Their contention was specifically that.
Please, madam, just,
Yes, ma'am.
you might have gone through the pleadings. Is it their case that mother is not fit to take care of the child?
That's one thing. At 1 year, 8 months, when the child was 1 year, 8 months old, the mother had to abandon the child and she walked away for various reasons. There was no connect. At that point of time, these people gave everything. Now, moving away this, again, it will cause emotional.
Abandoning, going for some professional reason somewhere and keeping the child with the parents. This is in our society, it is common. Is it your case that she has willfully deserted, abandoned? Abandoned gives another meaning.
At one point of time, she said, no, and you take care of the children, you deal with the child as though it's your own child. We agreed. Even to this day, we do not want the mother to be excluded, father to be excluded from the life of the child. Our only request is, let not the grandparents and the aunt be excluded from the child, because if your lordships were to see the anxiety factor.
They have not challenged. Visitation rights is given to the parents.
They have challenged. Now they have filed cross objections also. I'm given to
That
understand.
is because they were interfering into everything they were interfering into. That is the reason we have challenged it. Because they are clearly creating problems in the life of the child, not sending to school. Every time the parents last time.
May I request, my lords? Ultimately, I'm looking at. I'm standing
4.5 years we
only
fought
for the
this
child,
case, my
not
lord.
for the
Let the
parents
child
or
get
grandparents.
admitted to some school, my lord.
Wait, let her complete this.
All my submissions would be child focused only. It's not either in favor of the grandparents or. Now the question here is, with whom the custody has to be and how. At one point of time, the child had anxiety issues because it was separated from the parents at an initial stage. Now again, the child will go through another trauma. Let us not do this. Let us do it. Even if custody has to be handed over from A to B, my lords, your lordships have.
And grandparents reside in Mysore.
Now they have taken.
Correct. Where do they live?
They were living in Bangalore. Now during vacations, they took away and they did not even follow the court order.
Station.
Bangalore.
Ordinary residence is Bangalore.
Bangalore. We are ordinary residents of Srirangpattan. We can make any arrangements for the sake of the child and have. If your lordships were to hear it and dispose it of finally, my lords, taking it as a special case, we'll be really grateful.
Not to the child, parties. ಏನೋ ಯಾವುದೋ ಒಂದು ಟೈಮ್ ನಲ್ಲಿ ಸ್ವಲ್ಪ ಎನ್ಲೈಟನ್ಮೆಂಟ್ ಆದ್ರೆ ಆಗ್ಲಿ ಅಂತ. So now we want us to call for the records. Hear it.
And may I request, my lords, two submissions. One is that your lordships may kindly call for records and fix a date for final hearing, because that status of the child will be finally decided. That's one thing. And second thing is, my lords, during the interim,
Decided, we understand from the records that it will not end here. It goes.
definitely, that's where, my lords, ultimately ಏನಾದ್ರೂ ಆಗ್ಲಿ ಅವ್ರು ಎಲ್ಲಿಗೆ ತಗೊಂಡು ಹೋಗ್ತಾರೋ ಅವ್ರ ಇಷ್ಟ. ಬಟ್ ಮೈ ರಿಕ್ವೆಸ್ಟ್ ಈಸ್,
ಇಬ್ರು ಹೋಗ್ತಾರೆ, ಅವ್ರು ಬಿಟ್ರೆ ಇವ್ರು ಹೋಗ್ತಾರೆ, ಇವ್ರು ಬಿಟ್ರೆ ಅವರು.
ಅದೇ ಅವರು ಅಂದ್ರೆ ನಾನು ಇಬ್ಬರನ್ನು ಸೇರಿಸ್ಕೊಂಡು ultimately there has to be some finality somewhere, so that the child should not, this should not be.
Parents, grandparents, what is the
IIT Kanpur, ಅವ್ರದೆಲ್ಲ ಎಜುಕೇಶನಲ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ highest level, runs into two lines.
grandfather is IIT, no?
IIT. Grandmother is a principal, former principal of a very, very highly reputed.
Educational institution ಅಲ್ಲಿ ಇದ್ದೆ ಹೀಗೆನಾ?
ಎಲ್ಲ sister with whom the child had been there, that aunt with whom, aunt ne mother ಅಂತ ಕರೆಯೋದು ಅಂತೆಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ. That aunt is highly qualified. Her educational qualification runs into several.
ಅಲ್ಲ ಯಾವ ಫೀಲ್ಡ್? Which field?
ಕಂಟೆಂಟ್ಸ್ ಇದರಲ್ಲಿ ಮ್ಯಾನೇಜ್, ಇವಾಗ ಕಂಟೆಂಟ್ಸ್ ಸೈಡ್ ಹೋಗಿದ್ದಾರೆ. BA ಆಗಿದೆ. Authoring, she has authored several books, she is authoring several books, and all these people can understand up to certain level. There is some animosity which has to be moved.
Qualifications are not education.
Education should culminate in action. That doesn't happen.
So they have filed cross objection that is not listed here.
Mm.
And where is the
We
child?
have-
You
we
also
have
have to tell us where is the child?
Child is with the, I have filed the.
Which place? The
Child is in Bangalore. Child is in Bangalore. He is
Bangalore.
attending counseling in, yes, he is attending counseling in Niman,
Visitation
and
rights
also
will be-
he's having 8th, 9th and 10th counseling in school, so that he can get admitted in school.
Oh, Appellate counsel. Why you have produced all these documents?
We have produced the affidavit that on the last occasion, they did not adhere ಅದನ್ನೇನ್ ತಾವು ಅಷ್ಟೊಂದು last time ಅವರು.
I have also produced the compliance. I have produced the compliance affidavit, my lord, and the photographs of the child with the parents.
Compliance. It is third on you. That is.
Affidavit served.
Copy has been solved.
Now interim,
Explains affidavit.
my lords, operative portion ಅಲ್ಲಿ
Has placed the
Operative portion.
ಫಸ್ಟ್ ಹೆಟ್ಟಿಗೆ ಅಷ್ಟೇ ಹಾಕಿದ್ದಾರೆ.
My lords, operative portion 161, page 161, interim arrangement was also suggested by the court.
This has placed the memo. The affidavit of subjection 68 years. Appellant number 1. And copies and some documents. Yes, these are served on you?
Yes,
Whatever is filed today?
we have served, you have served,
Served
we
on
have
this
served.
one.
ಅದನ್ನ ಅಲ್ಲಿ mark ಇದೆ ನೋಡಿ.
Yes, what is that she is giving? You file it in the registry.
The compliance affidavit, my lords,
Compliance, what is that compliance?
regarding the last visitation they were asking.
You have complied.
We have not complied, we are stating that same.
You have not
have
complied
tried.
ಅಂತ they have stated ಅಂತೆ. ಕೊಡಿ madam, ನಮಗೂ ಒಂದು copy.
We have not stated, we
tried.
have not complied. We were there at the visitation center and we tried calling the appellant number 2. She did not pick up the call. There was a video call every day to appellant number 2. She has not picked up the call.
It is clarified that interaction through video calls in terms of the order may be permitted till next date of hearing, as ordered by the trial court. Learned counsel for response submits that child and parents are in Mumbai and necessary arrangement would be made as regards making the child available for visitation. Right, so taking note of such submission. Child is brought to Bangalore and made available for visitation on 4/1/2025 between 10:30 AM and 1:30 PM. This is not complied.
Not
We-
complied minutes.
We tried calling them, video calls also, my lords, and on the calls. also.
the council, my lord.
We,
ಬಿಟ್ಬಿಡಿ ಬಿಟ್ಬಿಡಿ ಅದು ಕೋರ್ಟ್ ಅವ್ರು ಮಾಡ್ತಾರೆ.
Now, the responsibility of all four of is more. Parties ಅಂತೂ ಹಾಗಾಗಿರ್ತಾರೆ. ನೀವು ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. Very unfortunate.
Very.
FR number. Compliance, you have mentioned it as compliance affidavit?
Yes, my lord, we were at the visitation center down waiting and calling and they have not picked up the call.
we have submitted the printouts of the calls also, my lords.
An affidavit of is respond number 2, na? Respond number 2. Along with the copies of some communications. Okay. ಇದಕ್ಕೇನು ಅಬ್ಜೆಕ್ಷನ್ ಏನಾರ ಹಾಕೋದಿದ್ರೆ ಹಾಕಿ. On hearing the parties at length.
This may kindly be formally admitted, my lords. This petition may kindly be admitted. Records may also be.
It is brought to the notice of the court that response of filed cross objection. We are not complied, it seems, cross objection still FR stage, that's what.
We'll comply, my lords.
The
We
compliance.
have filed it yesterday, my lord.
We have filed it.
Cross objection shall be complied within 1 week. On such compliance, list the said cross objection, then FR number along with these appeals. Visitation, right? What are you going to do about that?
My lord, we have filed a stay application also for visitation rights because they have been administering medicines
Madam, still
without prescription.
your cross objection is in FR stage. You have not complied the
Yes,
office
yes.
objection. No, you said
We shall comply.
your party made an attempt, but they did not receive the call. At least video call you can try.
ವಿಡಿಯೋ ಕಾಲ್ ಅಲ್ಲ, ಇನ್ ಪರ್ಸನ್ ವಿ ವಾಂಟ್ ಟು ಸಿ ದಿ ಚೆಕ್. ನಾವು ಮಾಡಿರೋದಕ್ಕೆಲ್ಲ ಅಷ್ಟೊಂದಿದೆ.
The present
ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ಗೆ 10 to 1 ಅಂತ ಕೊಟ್ಟಿರ್ತಾವ.
mindset, I think.
ನೋಡು ಒಂದ್ಸಲ ನೋಡ್ಲಿ ಅಂತ ಅಷ್ಟೇ.
Let them
ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್.
video call.
Let them also, that is also part of this.
If that is the case, only after next hearing date, we'll consider that.
159 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. The coordinate bench of this court ordered that. They have.
That
Or
is
we'll
only
do
an
one thing.
interim
We'll
arrangement.
do one thing.
Yes,
Now
yes,
it is
madam.
1:13. Both of you,
Yes.
I mean, keep your phones on. You have a video call with each other. And after lunch hour, we'll pass the orders.
With the child?
Yes,
If
you
the child could be.
facilitate a video call with a,
Yes, ma'am.
during now this lunch hour. Parties are
Yes,
here,
madam.
only, it seems.
They can use the chamber.
You can call it appears grandparents are here, you can call them. Now if they reject, we'll see. If the call is rejected, let the child talk to them.
Please, madam. Grateful. Madam.
Yes, madam. Yes, madam. Yeah, good.
It's, you couldn't do anything, advocates couldn't do anything in the matter. You are the best mediator in our center.
3 times it went for mediation, my lord, in the contempt
No, not
proceedings in the
mediation.
High Court.
Madam, we are not saying that. You
Yes.
advocates
Yes.
could not do anything in this matter.
We are not equipped
we
that way.
were-
Because I'm requesting that there is a parenting pattern. There is a community therapy which is given in such cases, not to the child per se, but to all others.
Please, that's what
All
I'm
others,
saying,
so
brother,
that
first these
we
people get
should
counseling.
get trained as a mother or as a grandmother or as an aunt or as a mother and father, and then they will prepare our mindset to see what the child's world will be. This is an age where the child cannot be made to choose between A or B persons. That's where it
Right.
brings a lot of turmoil to the
First,
child.
counseling and education is required, the parties to this case. That child.
In all such cases, in all child custody matters, the parents and the community members will have to be given proper counseling. Until then, the system will not be in place.
You
No,
can
but-
try this during lunch
That is
time. Yes.
Grateful.
Fast over. For final hearing, seal number 31, Mahesh Kiran Shetty, yes. Sridhar DS.
Yes.
Claimant's appeal seeking enhancement of compensation.
It answered the NSP accident. 2007 accident.
Yes, my lord.
Hmm.
My lord, it's a case of permanent disability to the extent of 100%. For that reason, my lord, he is represented by his next friend, guardian wife. My lord, the compensation totally awarded is 29 lakhs.
Who is
50.
for the other side here?
Mr.
Sridhar
Sridhar,
DS.
yes.
Sridhar DS. Oh, they. ಏನೋ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ. ಎನಿ ಆಫ್ ಯು ಕ್ಯಾನ್ ಟೇಕ್ ನೋಟಿಸ್ ಬಿಕಾಸ್ 2007 ಇಸ್ವಿದು ಆಕ್ಸಿಡೆಂಟ್. ಯಾವುದು ನ್ಯೂ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ
New India.
ನೀವು ಇದ್ದೀರಾ ಇದರಲ್ಲಿ ಅವ್ರು ಈಗ ಅವರು ಎಲ್ಲ ರಿಟರ್ನ್ ಮಾಡಿಬಿಟ್ಟಿದಾರ ಫೈಲ್. ಅದೇನು ಡೆಮೆನ್ಷಿಯಾ ಥರ ಆಗ್ತಾ ಇದೆ ಅಂತ ಸಣ್ಣವರಿದ್ದಾರೆ ಹೆಂಗ್ ಹೀಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಅದು ಹೇಳಿದ್ರು ಡಿಮೆನ್ಷಿಯಾ You will take notice or see the records argue on his behalf or his name is there. ಯಾರೋ ಒಬ್ರು ಜೂನಿಯರ್ ಕೊಲೀಗ ಅಂತ ಬರ್ತಿದ್ರಲ್ಲ ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ಹೋಗೋರು ಬಟ್ ಅವ್ರ ಹೆಸರೇನು ಅಲ್ಲ ಬಂದ್ ಮೇಡಮ್ ಹೌದಾ ಹೇಳಿದ್ ಅವ್ರು ಬರೋದಿಲ್ಲ ನಾವೇ ಮಾಡ್ತೀವಿ ಅಂತ ಒಂದ್ಸರಿ ಯಾರೋ ಕೃಷ್ಣಸ್ವಾಮಿ ಅವ್ರು ಮಾಡಿದ್ರು ಅಂತ ಕಾಣಿಸುತ್ತೆ ಅವ್ರ ಕೇಸಲ್ಲಿ ಕೃಷ್ಣಸ್ವಾಮಿ ಹೌದು ಹೇಳಿದ್ರು ಪ್ರಾಬ್ಲಮ್ ಆಫ್ ದ ಕೌನ್ಸಿಲ್ ಮಾಡ್ತೀನಿ ಮತ್ತೆ ಹಾಗೆ ಸಿ ದಿಸ್ ಇಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ 2013 2008 ಒರಿಜಿನಲ್ ನೀವು ಹೇಳಿ ನೀವು 2 ವಾರ ಬಿಟ್ಟು ಡೈರೆಕ್ಷನ್ಸ್ ತಗೊಂಡು ಅಲ್ಲ ಎನಿಬಡಿ ಕ್ಯಾನ್ ಹೆಲ್ಪ್ ಅಸ್ ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಅವ್ರನ್ನ ಅಷ್ಟೇ ಹೇರ್ ಮಾಡ್ತೀವಿ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ತೀವಿ ಬರೀತೀವಿ ಅಷ್ಟೇ. ವಿ ಅಂಡರ್ಸ್ಟುಡ್ ನೋ ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಯುವರ್ ಎಂಬರಾಸ್ಮೆಂಟ್ ಆಲ್ಸೋ. ಇಲ್ಲ ಅಂದ್ರೆ ಜನರಲಿ ವಿ ಗೋ ಬೈ ದ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ತೀವಿ ಬರೀತೀವಿ ಅಷ್ಟೇನೆ. ನೀವು ಬೇಕಾದ್ರೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಅವರನ್ನ. ಯಾರೆಲ್ಲ ಅಲ್ಲ ಈ we can't share anything that is not ready for that. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ನಾವು ಸ್ವಲ್ಪ ನಮ್ಗೆ ಸರಿ ಇಲ್ಲ ಅಂತ we can't record them. ನಾವು ಒಂದ್ ಕೆಲಸ ಮಾಡ್ತೀವಿ ಇವ್ರದ್ದು ಮಾಡಿ ಪಾಠಾಡ್ ಅಂತ ಮಾಡ್ತೀವಿ. ಏನಾರ ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಮಾಡಿದ್ರೆ ಮಾಡಿ ನೀವು you have that information he is not well ಅಂತ
That's what I came to know now, my lord. I'm sorry.
you
It's not
serve the copies on him.
right now I'll serve one.
We have seen in this case also ಅವರೇನೋ 100% disability ಅಂತ ಹೇಳ್ತಾರೆ. You will argue the matter then?
Please.
Or you will serve the copy and ಸುಮ್ನೆ ಪಾಠ ಅಂತ ತಗೊಂಡು ಅದು ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, anything is.
I had not taken LCRs ತಗೊಂಡು ಹೋಗಿರ್ಲಿಲ್ಲ TCRs. Then you do one thing, you serve the copies on him.
Please.
We list it day after tomorrow. ಅವ್ರೇನು ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳೋಣ. ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ
Tuesday. Monday.
ಇಲ್ಲ ಏನಂತ ಹಾಕೋದು, ಅವ್ರ ಟೈಮ್ ಕೇಳ್ತಾ ಇಲ್ವಲ್ಲ. ಇಲ್ಲ ಹೀಗೆ ಮಾಡಿ, heard the appellant's counsel in part. Okay. No representation for counsel for respondent number 2. List on for further hearing list on. Ravi Shankar or copies, it is out of record understanding ಇದು.
15:1.
15.
Appellate.
ಎಲ್ಲ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇರುತ್ತೆ. ಅದೇನು ಪರ್ಸೆಂಟೇಜ್ ಆಫ್ ಡಿಸಬಿಲಿಟಿ, ಫಂಕ್ಷನಲ್ ಡಿಸಬಿಲಿಟಿ ನೋಡೋದು ಅಷ್ಟೇ. ನೋಡಿ ಮಾಡಕ್ಕಾದ್ರೆ ಇಲ್ಲ.
Even this matter was pending before the Lok Adalat for nearly 5 years. The reason why it was not settled is the quantum of compensation is higher and they require approval from the zonal officer. For that reason, my lord, it could not be settled before the Lok Adalat. ಅಲ್ಲಿ ಒಂದು 5 ವರ್ಷ ಇತ್ತು.
ಈ ಸರ್ ದ ಕಾಪೀಸ್
Please, please.
ಲೆಟ್ ಹಿಮ್ ಟೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
Please.
ಇಲ್ಲ ಅಂದ್ರೆ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತ ಬರ್ಕೊಂಡು ಯು ಆರ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಅಂತ ಮಾಡಬೇಕು ನಾವು. ಶಾಲ್ ವಿ ಡೂ ದಟ್? ಹಾಗೆ ಮಾಡೋಣ. ಇಲ್ಲ ಅಂದ್ರೆ ಯಾಕಂದ್ರೆ ವಿ ಹ್ಯಾವ್ ಟು ಕ್ಯಾಶ್ ಹೋಲ್ಡ್ ಆಫ್ ಒನ್ ಆಫ್ ಯು. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ 2 ಹಾಗೆ ಬರ್ಕೊಳ್ಳಿ. ದಿಸ್ ಇಸ್ matter of 2013. The records show that the accident in question had taken place in the year 2007 and the claim petition was filed in 2008. Considering the aforesaid facts, Shri C.R. Ravi Shankar, who is the standing counsel for respondent 2, is directed to take notice and assist the court. Appellant's counsel shall serve the copies on him. List on
15:1.
Appellate.
Syllabus 32. Vijay Kumar.
My lord, I am for the appellant, my lord. I am for the appellant.
Yes.
Shall I start at 2:30, my lord? There are totally 5 connected matters.
ಜನಾರ್ದನ್ ರೆಡ್ಡಿ ಅವ್ರು ಶುರು ಮಾಡ್ತಾರಂತಿಲ್ಲ.
ಇದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಕೇಸಸ್ ಓ ಮಹೇಶ್ ಅಪೀಲ್ ಹಾಕಿದ, ಅದಕ್ಕೆ ನಿಮ್ಗೆ NOC ಕೊಟ್ಟಿದ್ದೀನಿ ಪೇಪರ್ಸ್ ಅಲ್ಲಿ.
NOC ಕೊಟ್ಟಿದ್ದೀವಿ.
ಹೌದು.
ಹಿಂದೇನೋ ನೋಟ್ಸ್ ಮಾಡಿದೀವಿ. ಕರೆಕ್ಟ್ ನಾನು ರೆವೆನ್ಯೂ ಮಾಡಿಸಿದ್ದೆ. ನಮಗೆ ಬರೆಯೋಕೆ ಅನುಕೂಲ ಆಗುತ್ತೆ. ಯು ಆರ್ ನಾಟ್ ದೇರ್ ನೌ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್, ಓ ಮಹೇಶ್ ಅವರು ಅಪೀಲ್ ಹಾಕಿದ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಅಲ್ಲಿ, ಅದಕ್ಕೆ ನಾನು ಪೇಪರ್ ವಾಪಸ್ ಕೇಳಿದ್ರು ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯುವರ್ ನೇಮ್ ಇಸ್ ಶೋನ್ ಹಿಯರ್.
ಇಲ್ಲ, ನನ್ನ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ.
32. ಅಂತ ನೋಡಿಸ್ತೇನೆ. ವಿಜಯ್ ಕುಮಾರ್, ಜನಾರ್ದನ್ ರೆಡ್ಡಿ 32.2 ನಲ್ಲಿ ತೋರಿಸಿದಾರ ಫಾರ್ R3. ಈಗ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತಗೊಳಕ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾ? ಅಗೇನ್ ಇಟ್ ಮ್ಯಾಟರ್ ಬಿ ಅರ್ಜೆಂಟ್.
ಇಲ್ಲ, 8 ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸುಮ್ಮನೆ.
ಅಲ್ಲ, ಯಾಕೆ ನೀವು ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ವಕಾಲತ್ ನೋ ವೈ ಶುಡ್
ಕನೆಕ್ಟೆಡ್ ಕೇಸಸ್ ಒಬ್ರು ಕೊಟ್ಟಾಗ ಮತ್ತೆ ಅವರು ಅಲ್ಲಿ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಸುಮ್ಮನೆ.
ಅದು ನಿಮ್ಮ ಮಧ್ಯದ್ದು.
ಅದಕ್ಕೋಸ್ಕರ ನಂದು ವಾಪಸ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು ಸಮಯ. 3 ಕೇಸ್ 4 ಕೇಸು
ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಹೋಗೋದಿಲ್ಲ. ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ ದ ಮ್ಯಾಟರ್ ನೌ.
ಪೇಪರ್ಸ್ ಏನಿಲ್ಲ, ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಲಾಂಗ್ ಬೇಕು.
Anyway, in other matters, Mr. O Mahesh is appearing. He will continue.
Hello, only one matter in 1399 of 2007.
We are getting some sound from your.
ಅದೇನೋ mostly fan sound ಏನೋ ಇರಬೇಕದು. Fan sound.
ಸಮಸ್ಯೆನೇ ನಮಗೆ. What is that? ಕರ್ರ sound.
Fan sound ಇರಬೇಕೇನೋ.
ಯಾವಾಗಲೂ ಬರ್ತಾನೆ ಇರ್ತದೆ.
I'll go to some other.
ನಮ್ಮ sound ಬರ್ಬೇಕಲ್ಲ.
Fan ಅಲ್ಲ.
You switch off your fan, Mr. Mahesh.
Yeah,
Fan ಅಂತ switch off ಮಾಡ್ಕೊಳ್ಳಿ. Fan switch off ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಲ್ಯಾಪ್ಟಾಪ್ ಹೋಗ್ತೀನಿ, then they won't be. I'll go to laptop.
Yes.
But in MFA, 1399 of 2000.
ಯಾರಿಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ತೀರಾ ಇದ್ರಲ್ಲಿ ಕ್ಲೈಮೆಂಟ್ಸ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಗೋಪಾಲ್ ಕೃಷ್ಣ ನೀವು ಶುರು ಮಾಡ್ತೀರಾ ಮಾಡಿ
ಕ್ಲೈಮೇಟ್ಸ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ
ನೀವು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಷ್ಟೇ ಇರೋದು ಅಪೀಲ್ ಎಲ್ಲ ಅವ್ರದೇನೆ ಇರೋದು
ನಂದು 3 ಅಪೀಲ್ ಇದೆ.
ಒಂದು ವಿಜಯ್ ನಿಮ್ದೊಂದು ಅಪೀಲ್ ಇದೆ ಅಲ್ಲ 32.4
ಹೌದು, ಅದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಫಾರ್ ಎನಾನ್ಸ್ಮೆಂಟ್.
ಆಯ್ತು ವಿಜಯ್ ಕುಮಾರ್
ಅಲ್ಲ
ಮಹೇಶ್ ಯು ಕ್ಯಾನ್ ಸ್ಟಾರ್ಟ್.
ಅಲ್ಲ shall we commence at my lord 2:30 my lord?
ನಿಮ್ದಲ್ರಿ ಅವ್ರು ಮಾಡ್ತಾರೆ ಮಹೇಶ್.
ಅಲ್ಲ ಆಗ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ, ಮಾಡ್ಲಿ ಮಾಡ್ಲಿ. ಅಲ್ಲ ಈ ಪಾರ್ಟ್ ಇದಾಗೋದು ಬೇಡ ಅಂತ ಕಂಟಿನ್ಯೂಸ್ 2:30 ಇಂದ ಆಗ್ಬೋದಾ ಅಂತ ಅಷ್ಟೇ, ಏನೇನಿಲ್ಲ.
ಅವಾಗ
If you take it.
5 ನಿಮಿಷ ನಾವು ಟೈಮ್. What should we do for 5 minutes?
Please madam. Then I only start. I will only commence.
For different tribunals ಅಲ್ವಾ?
ಹೌದು, ಒಂದು ಟ್ರಿಬ್ಯುನಲ್ MFA 8710
ಟೇಬಲ್ ಮಾಡಿಸಿ. MFA 8710 of 2015
and
by APSRTC and MFA 7869 National Insurance Company.
ಹೌದು.
ಮಹೇಶ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ.
MSc 1389 of 2014.
ಮ್ಯೂಟ್.
MFA 8710.
ಇಮಿಡಿಯೇಟ್ ಇದು ಲ್ಯಾಪ್ಟಾಪ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಬಿಡಿ ಹಂಗೇನೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದ್ ಹೋಗಿದೆ, ಇದ್ರಲ್ಲಿ ನೋಟ್ಸ್ ಮಾಡಿದೀವಿ ನಾವು.
ಹೌದು
1399 MFA ಅದು MEC 157 ಇದೆಲ್ಲ ಬೇರೆ ಬೇರೆ ಕಡೆ ಆಗಿರೋಲ್ಲ. MFA 1400
ಒಂದು ಸಿಟಿ ಕೋರ್ಟ್, ಒಂದು ರೂರಲ್ ಕೋರ್ಟ್.
158 ಒಂದು ಅಡಿಷನಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಂಡ್ ಸೆಷನ್ ಜಡ್ಜ್ ಬೆಂಗಳೂರು ರೂರಲ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ಒಂದು ಮಾತ್ರ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್.
21st ACMM ಒಂದು.
ಹೌದು.
MACT ಸ್ಮಾಲ್ ಕಾಸ್ ಕೋರ್ಟ್.
MEC 1389 of 14.
Yes, ಶುರು ಮಾಡಿ. ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡ್ತೀರಾ?
ಪ್ಲೀಸ್ my lord in MFA 8710 2015.
Yes, MFA
8710
yes
8710 2015. My lord, this appeal is filed by the APSRTC challenging negligence and quantum of compensation awarded by the tribunal. My lord, there was an accident between 3 vehicles.
2 vehicles.
One vehicle is the Maruti van where the deceased and other persons were traveling, and another vehicle is a Scorpio car which was going ahead of the Maruti van, and the APSRTC bus which alleged to have come from opposite direction. My lord, the accident has taken place on 8/2/2014 around 11 PM. My lord, the deceased and other persons were traveling in a Maruti van. After finishing the marriage function, they are coming from Kadapa towards Bangalore.
Yes.
When they came near Alambagiri cross, my lord, at that time, one Scorpio car was going ahead of the Maruti van. At the first instance, the Maruti van dashed against the hind portion of the Scorpio which was going ahead. Thereby, it was toppled to the other side of the road. The Scorpio which hit by the Maruti van did not stop and went away during night time. The police are not able to trace it, and the Maruti van, after hitting the Scorpio van, rolled on the other side of the road. At that time, the APSRTC bus was coming from opposite direction, that is from Bangalore towards Kadapa. After observing the Maruti van rolling to the other side of the road, wrong side of the road, he stopped the bus at the distance of 50 feet because that Maruti van has blocked the road of the APSRTC. Thereby, my lord, the inmates of the Maruti van have sustained injury, and some of them sustained injury, and another person is died. The accident, my lord, has taken place on 11 PM on 8/2/2014 during midnight, and the complaint was given on the next day by the person who was not at the place of accident. And he got the information over phone. I don't know how he got the information, and he gave the complaint on the next day. Because the Scorpio van was spread away from the place of accident, and Maruti van has sustained damages and rolled on the other side of the road. Malad, the police, Malad, in collusion with the owner of the Maruti van and this thing, they have filed a false criminal case only against the driver of the APSRC bus because it is a heavy vehicle and also it is a government vehicle. Malad, there was no contact or impact between the bus and the Maruti van. It is total negligence on the part of the driver of the Maruti van. He hit against the Scorpio car which was going ahead of it. Malad, we have kindly see exhibit P2, the spot sketch and major, Malad. The accident has taken place according to them. As per the report, it is on the other side of the road. Exhibit P2, Mahajan and sketch. It is not the correct side of the Maruti van.
Yes.
The Maruti van is coming from Kadapa towards Bangalore, Vaskote.
No, it is showing.
Our bus never gone against the other side of the vehicle and now not even dashed. Your Lordship got the
Yes.
sketch and major.
Accident spot is shown on the other side.
Our bus is on the extreme left side of the road. It is on its correct side of the road.
Which place? Which side to which side?
From Bangalore towards Kadapa. Bangalore towards Kadapa.
Yes, they were coming from Kadapa to Bangalore.
They are coming from Kadapa towards Vaskote, Bangalore.
Bangalore.
They are on the totally on the wrong side of the road. Even in the claim petition also, even in the police records or even in the evidence, there is no allegation that our bus has gone to the wrong side of the road and dashed.
That is not correct.
My lord, kindly see exhibit P11, the photographs, my lord.
The sketch. It's with
Exhibit P11, the photographs.
spot measure. P11.
11. ನೈಟ್ ಅಲ್ಲಿ ಫಾಸ್ಟ್ ಆಗಿ ಬರ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ ಮುಂದೆ ಹೋಗ್ತಿದ್ದಂತ ಗಾಡಿ ಹೊಡೆದು ರೋಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ ರೈಟ್ ಸೈಡ್ಗೆ. Toppled and rolled on the other side of the road.
Yes. Yes.
One Ashok is the complainant.
All right, now we'll continue in the afternoon.
Please, my lord. Please, my lord.
At least. Just 34. Where your name is shown? C.R. Ravishankar. ಹರಣಿಶ್ ಅವ್ರು ಇಬ್ಬರದು ವಕಾಲತ್ತಿದೆ ಅದ್ರಲ್ಲಿ ಬಟ್ 34 ನಲ್ಲಿ ಶ್ರೀ ಆರ್ ರವಿಶಂಕರ್ ಲಾಯರ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ the respondent number 5 has subsequently entrusted the matter to Srimati Harini Shivananda Lagar Council. Therefore, only her name may be shown in the. ಅಲ್ಲ ಇವ್ರ ನೇಮ್ ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಂತೆ ಹರಿಣಿ ಶಿವಾನಂದ ಅವ್ರದಾ ಅಲ್ಲ ನೀವೇನೋ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ವಕಾಲತ್ ಯಾರ್ದು ಅಯ್ಯೋ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ಅಂತ ಬರ್ಕೊಳ್ತೀವಿ ಅಷ್ಟೇ ಯಾಕೆ ಅದಕ್ಕೆ ಮತ್ತೊಂದು ಹೆಸರು ಕೊಡೋದು ಇವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ರೆಡಿ ಇದೀರ ತಾನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳ್ಬಿಡೋದು ಅದನ್ನ ನಾವು ಆಮೇಲೆ ಮಾಡ್ತೀವಿ ನಾವು ಈಗ ಹಿಯರ್ ಮಾಡೋದ್ ಬಿಟ್ವಿ ಆಫ್ಟರ್ನೂನ್
Court officer? Court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ ಏನೋ ಇದೆಯಾ?
ಎರಡಿದೆ ಸರ್ ಪಾಸ್.
ನಮಗ್ ಮುಂಚೆನಾ? ಅದಾದ್ಮೇಲೆ ಇದು ತಗೊಳ್ತಾರಲ್ಲ?
ಏನ್ ಸರ್?
ಅದಾದ್ಮೇಲೆ ಇದು ತಗೊಳ್ತಾರಾ ಇಲ್ಲ ಫಸ್ಟ್?
ಅದಾದ್ಮೇಲೆ ನಿಮ್ದು.
ಹಾ ಸರಿ.
Visitation ಆಗ್ಬೋದಲ್ಲ ಅಂತ. ಹಾ.
ಮೆನ್ಷನ್ ಮಾಡ್ತಿದ್ದವ್ರು ಹೇಳಿ.
ಅಲ್ಲ, ಸೀಲ್ ನಂಬರ್ 36 ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ.
36
1
ಏನಾಗ್ಬೇಕು?
36 1
36 there are many connected
ಅಲ್ಲ, 36 1 ಇಲ್ಲ, 36 1 and 2 they are connected even though because of common accident and different cases. And in 36
which matter you are mentioning?
36 1
36.1 huh?
yes, lower court records are not received and
ಇವಾಗ ಹಿಯರಿಂಗ್ ಶುರು ಮಾಡಿದ್ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Connected matter.
connected
First matter.
Other matters we have received. This is to come from which place?
Chikkamangaluru. Chikkamangaluru.
ಚಿಕ್ಕಮಗಳೂರು. ಇವತ್ತು ಅವ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗೋ ಅಷ್ಟೊತ್ತಿಗೆ we can direct the registry to secure it. ಅಥವಾ ಅದನ್ನ ಒಂದೇ ಆಮೇಲೆ ಡೀಲಿಂಗ್ ಮಾಡೋಣ.
ಆಗಲ್ಲ, await notice ಅಂತ ಎರಡು ಇದೆ ಅಲ್ಲಿ.
await TCRs.
ಅಲ್ಲ, await notice ಮತ್ತೆ ನಾನು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ನಲ್ಲಿ awaiting service of notice to R1 ಅಂತೀನಿ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಪೆಂಡಿಂಗ್. You want these to be delinked from the other case?
ಡಿಲೀಟ್ ಮಾಡಿದ್ರು ಆಗ್ಬೋದು ಬಿಕಾಸ್ ಕಾಮನ್ ಆಕ್ಸಿಡೆಂಟ್ ಇಸ್
ಅವ್ರು ನಾವು ಹೇಳಿದ್ವಲ್ಲ, ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಕೇಳ್ತಾ ಇದ್ರು we can direct them to take notice ಅಂತ. ಇದೆ ಮಾತಲ್ವಾ? ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಅವಾಗ ಅಟ್ಲೀಸ್ಟ್ we can direct them to take notice. ಹಾ, ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಮೆನ್ಷನ್ ಮಾಡಿದಾಗ ನಾವು ಹೇಳಿದ್ವಿ ಅದನ್ನ. ಕರೆಕ್ಟ್ ಕೊಡಿದೀನಿ ಫೈಲ್ ಕೊಡಿ. 36. See, the appellant in MFA 36.1 is the respondent in your cross objection. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ತಗೊಳಕಾದ್ರೂ ಆರ್ಡರ್ ಮಾಡಿ
ಆಗ್ಬೋದು, ಆರ್ಡರ್ ತಾವು ಮಾಡಿಲ್ಲ. ಐ ಸರ್ವ್ ಅಂದೆ.
ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರು ಅವಾಗ ಅದನ್ನೇ ಹೇಳಿದ್ವಿ ನಾವು. 36.1 ಇದು ಕೊಡಿ.
Order is already passed, my lords. Is the previous order. B. Pradeep, Darnesh, running counsel.
So this was not taken up, no, till now.
No.
ತಗೊಂಡಿಲ್ಲ. ಹಾ, ವಕಾಲತ್ ಫಾರ್ ಸಂತೋಷ್ ಹೋಗಿ ಆ ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅವರು. ಅಪೆಲೆಂಟ್ ವಕಾಲತ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ರು. ಕರೆಕ್ಟ್ ಹೋಗಿ ಅವ್ರ ಜೂನಿಯರ್ ಕೇಳಿದ್ರಲ್ವಾ?
Last time also they had not filed wakalat, my lords. Your lordship was pleased to vacate the interim order on the last occasion because wakalat.
ಇವತ್ತು ಯಾರೋ ಬೆಳಿಗ್ಗೆ ಬಂದು ಮತ್ತೆ ಟೈಮ್ ಕೇಳಿದ್ರು. You were not there?
Morning they were not there.
ಹೇಳಿರ್ತಾನೆ ಅವಾಗ ನಾವು ಅಟ್ಲೀಸ್ಟ್ ನೋಟಿಸ್ ತಗೊಳಕ್ ಹೇಳ್ತೀವಿ 36.1 ಅಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ವಿ. 36 ನಲ್ಲಿ ಒಬ್ಬರೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರೋದಾ? 36.1 ನಲ್ಲಿ
36.1 ಅಲ್ಲಿ 2 ಜನ.
there is only one respondent? No.
No, 2 respondents are.
2, 3 are there. Shankar Narayan, but you have taken for R1.
Yes, ma'am.
2 and 3 notice ಹೋಗ್ಬೇಕು.
2 ಗೆ 3 ಇಲ್ಲ.
3 ಇದಾರಲ್ಲ ಯಾರೋ ಮಂಜುನಾಥ್ ನಾಯ್ಡು ಅಂತ ಹೇಳಿ.
36.1 ನಲ್ಲಿ only two respondents, Mila. One is so insurance,
21
Bajaj Alliance
ಓ,
insurance.
ಇದು ಯಾವ್ದೋ ಬೇರೆ MFP 722 ಕೊಟ್ಟಿದ್ದೀರಿ ನಮ್ ಕೈ. ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ 2192 ನಲ್ಲಿ ಒಬ್ಬರಿಗೆ ಮಾತ್ರ ನೋಟಿಸ್ ತಗೊಂಡು. ಅಲ್ಲ ಅದ್ರಲ್ಲಿ 36 ನಲ್ಲಿ ಎಲ್ಲರದು ಮುಗಿದೋಗಿದೆ ಸರ್ವಿಸ್. ನರೇನಪ್ಪ ಬಜಾಜ್ ಅಲೈನ್ಸ್ ಈಗ R1 ಗೆ ಮಾತ್ರ ತಗೊಂಡಿದ್ದಾರೆ, ಇವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಬಜಾಜ್ ಅಲೈನ್ಸ್ ಬೇರೆ ಕೇಸಲ್ಲಿ ಯಾರಾದ್ರೂ ರಿಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾರಾ?
Bajaj in the first case.
ಪ್ರದೀಪ್ ಇದ್ದಾರೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
The first case also says common insurance company, Mila, Bajaj.
ಅದಕ್ಕೆ ಯಾರು ತಗೊಂಡಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್?
First matter.
ಪ್ರದೀಪ್ ತಗೊಂಡಿದಾರಲ್ಲ R5. R5 is ಬಜಾಜ್ ಅಲೈನ್ಸ್ ಇದ್ರಲ್ಲಿ ತಗೊಂಡು 36.1 ನಲ್ಲಿ ಶ್ರೀ ಬಿ ಪ್ರದೀಪ್ learned standing counsel for respondent number 2 is requested to accept notice for respondent number 2. He shall file the wakalat in the registry within 2 weeks. His name shall be shown in the cause list for the said respondent. Appellant's counsel shall serve the copies on him. Registry shall secure the TCRs and telephonic requisition. 36.1 ಅದ್ ಮುಗೀತೀಗ. ಇನ್ನೊಂದು ಕುಡಿಯೋದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಅದರಲ್ಲಿ await ಅಂತ ಇದೆ. ಅದರಲ್ಲಿ await for R1 notice ಅಂತ ಇದೆ. That
ಅಲ್ಲೇ
R1 is the appellant in the other case.
ಅದಕ್ಕೆ ಯಾರು ಸಂತೋಷ್ ಹೋಗಿ ಹಾಕ್ತಿರಪ್ತೀನಿ ಅಲ್ಲೇ ಗೌಡ. ಕರೆಕ್ಟ್ ಸಂತೋಷ್. ಬಟ್ ಅವ್ರು ಇದ್ರಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ರೆ ಸರಿ ಇಲ್ಲ.
R1 and
ಶ್ರೀ ಸಂತೋಷ್ ಗೋಗಿ learned counsel who represents the present first respondent in the other cases is requested to accept notice for the first respondent. Shri B. Pradeep, learned standing counsel for respondent is directed to accept the notice for the said respondent. The names of the other counsel shall be shown in the cause list accordingly. And they shall file the wakalat in the registry within 2 weeks. ಇನ್ನೊಬ್ರು ಇದಾರಲ್ಲ 2 ಅಂತ ಅವ್ರಿಗೆ
one and two same appellants in the other matters. 1 and 2. Response 1 and 2 are the appellants in the.
ಓಪನ್ ಲೇಸರ್ಸ್.
How's open is also appellant in the other matter.
ಅದರ್ಸ್
2192 they are appellant number 2.
2 ಅಂತ ಮಾಡಿ. ಸೊ ಒನ್ ಸ್ಟೇಜ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತಾ ಇದರಲ್ಲಿ? ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಹೇಳಿದ್ರೆ ಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕು. 2 weeks ಆದ್ಮೇಲೆ
23/1.
Much obliged.
20.
47.
47. You appear for?
I'm for the petitioner advocation.
Non-filing of the wakalat for auto or hakila. Sir, the copy. Copy sir, what is it?
ಮಾಡ್ತಾರಂತೆ ಅವ್ರಿಗೆ.
At request of as requested by the appellant's counsel, list after 2 weeks.
At serial number 33. This case, maybe have it on next week, Milad. Pradeep is not in.
Whatever. Agboda? As requested by response counsel, list. Is it 2016 list or?
Next week.
16/1.
16.
Much.
Pastor matters. Bill number 17.
Oh,
PP.
Third case in the.
Yes.
We called and inquired, there is no such rule or law.
Lords, in fact, earlier, if I remember rightly, my lords, earlier, the office used to file, my lords, combined, my lords, appeals. But however, my lords, there was an order passed by this court, if I remember rightly, I am not able to get the order, my lords, because it is unreported. Thereafter, only, my lords, we started, my lords, office started filing, my lords, separate appeals.
I called and asked the this pending branch people, is there any order, any rule like that?
That, my lords, because, my lords, since I handled, my lords, I was there in the office, my lords, of around 10 years. But But however, my lords, my submission is, my lords, two different, yes, my lords.
One matter goes before the single judge and one matter comes here.
Then it has to be
There is
connected,
likelihood of conflicting order, that is one thing.
yes, my lords.
Against one judgment, one appeal is contemplated. Whether that is acquittal, conviction, or acquittal for one offense and conviction for one offense and minor offense or inadequacy of the sentence, only one appeal lies. How two appeals
My lords,
lies?
the grounds of my lords appeal will differ, my lords, with regard to acquittal as well as my lords.
Yeah, that appeal also.
And two different prayers, my lords, in common or single appeal. My lords, right now, my lords,
Accept that.
because my lords, when two separate,
And ಇವಾಗ ನಾನು ಕರೆಸಿ ವಿಚಾರ ಮಾಡಿದೆ ಇಲ್ಲೇನೆ ಸೆಕ್ಷನ್ ಅವರು ನನಗೆ ಬ್ರಾಂಚ್ ಅವ್ರು ಹೇಳೋದು ಇದು 417 ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ ಅಲ್ಲ ಇದು ಸಿಂಗಲ್ ಜಡ್ಜಿಗೆ ಹೋಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಈಗ 376 ಕನ್ವಿಕ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂತ 417 ಮಾಡಿದಕ್ಕೆ ಅವ್ರು ಅಪೀಲ್ ಬಂದಿರ್ತಾರೆ ಇಫ್ ಎಟ್ ಆಲ್ ದಟ್ ಇಸ್ ಟು ಬಿ ರಿವರ್ಸ್ ದೆನ್ ಅದನ್ನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಬರ್ಬೇಕಾಗುತ್ತೆ ಅದು ಸಿಮಿಲರ್ಲಿ inadequacy of sentence. Yeah, they are on the part of even
And-
section 211, all charges have to be tried together.
and we don't have any objection with regard to my lords filing of my lords single appeal.
You
But
can mention both the provisions. If one is under section 372 against acquittal, one is 378, ಇದ್ರೆ ಎರಡನ್ನು ಬರೀಬಹುದು ಅದರಲ್ಲಿ.
when two different provisions have been set out, my lords, for different purpose, and my lords, that makes difference, my lords.
ನಲ್ಲಿ ಮ್ಯಾಂಡಮಸ್ ಪ್ರೈವೇಟರಿ ಅಥವಾ ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ನಲ್ಲಿ ಈ ತರ
ಅಲ್ಲ,
ಹೇಳ್ತೀರಾ ಇಲ್ವೋ?
that is, my lords, similar, we can't file, my lords.
Any wisdom in that?
482 and 4, my lords, 401, 397, we can't file, my lords, 482 inherent powers and 397.
397 ಗೆ ಏನ್ ಬರುತ್ತೆ? 397 ಗೆ ಬರುತ್ತೆ.
Identical is, my lords.
And they do not arise out of same order.
That is right, my lords, identical is the situation, my lords, because two different.
No, if you insist that we should permit you to appeal, then show us the law, we'll accept that.
And my lords, it requires some more research, my lords, I don't have, my lords.
ಎಷ್ಟು ದಿವಸ ತಗೊಳ್ತಾ ಇದ್ದೀರಾ?
I have not taken much, though I have taken time, my lords. In fact, I asked my officers also, my lords, to verify, my lords, what is the. And I remember, my lords, we used to file earlier, my lords, two appeals, single appeal, my lords.
No, it is duplication of work for you, for the court, and register. And when there is likelihood of some inconsistency, conflicting orders for a chance irutte.
That is, my lords, registry has to club both the appeals together, and then it has to.
Exercise ಅವ್ರು ಯಾಕೆ ಮಾಡಬೇಕು? If only one appeal is filed, that is enough.
The grounds and everything, my lords.
We are not, we checked, there is no such rule, there is no such provision. ಇನ್ನು ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಲಾ ಇದೆ ಅಂತ ನೀವು ಹೇಳೋದಾದ್ರೆ you have to show us.
That I am, in fact, I tried to, my lords, that is the reason I made submission on the previous.
17.1 ನಲ್ಲಿ learned SPP seeks time to submit how two appeals against the same judgment and order could be maintained as a final chance list on later. Like, yeah, 2021.
23-1. Pastoral matter, seal number 30. Hitesh Gowda BJ.
Serial number 30. What is the outcome? Whether any visitation was facilitated?
Through video call, there were some disturbances. ಅದೇ ಆ ಥರ ಈ ಥರ ಮಾಡಿ ಕೊನೆಗೆ ಏನೋ ಮಾಡಿದ್ದಾರೆ, ಮಾತಾಡಿದ್ದಾರೆ. ಆ ಮಗು ಓಡಾಡ್ತಾ ಇತ್ತಂತೆ. We can't help. And the child was repeatedly telling, I want to come back. That's all these people have said, whatever it is. Some few minutes they have spoken, father and mother, grandparents.
When they speak, they should not speak these issues.
They first asked, did you come to mediation center? Then they asked, did you go to Mumbai? Do you want to come back home? These are the three questions they asked.
I know. Yeah. Good if they reconcile. Otherwise, we'll hear on the merits.
ಅದೇ I would request, my lords, this is in a way going too much. So I would rather request with all humility at my command that let the matter be heard and finally decided so that they will know that what they can do with the child and what cannot be done with the child. Both will know. That's where I request, my lords. Records may kindly be called for. And in between, visitation may kindly be proceeded. And this
Call for the records and then
visitation, interim visitation, ಅಲ್ಲಿವರೆಗೂ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
ಸ್ಟೇನೇ ಇಲ್ವಲ್ಲ ನಿಮ್ಗೀಗ. There is no stay. As it is, they have not challenged that cross objection has not come.
ಅವ್ರು ನಾವು ಕೇಳಿದ್ರು ಕೊಡ್ತಾ ಇಲ್ಲ. ಮತ್ತೆ ಅದಕ್ಕೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಳಕ್ ಬದಲು ತಾವು
Enforcement ಹಾಕೊಳ್ಳಿ ಹಾಗಿದ್ರೆ. Please do it.
ಅದಕ್ಕೆ ತಾವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದಿದ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ಮಗುನ ಫಿಸಿಕಲ್ ಆಗಿ ನೋಡ್ಬೋದು ಅಂತ. They said they have no objection. So if
but no objection, then your prayer does not survive. They say they have no objection.
ಅಲ್ಲ
Do you on any particular day facilitate this video call visit?
Video call visit we
ಅಲ್ಲ
can consider.
physical
Because if they come, they are not allowing the child even to go for counseling for school. That is the problem. He's saying that let the child go to school when he wants. That is the thing taken by the stand
Visitation.
taken by the grandfather.
Visitation 3 hours
So
visitation.
now that will hinder the process of him going to school.
Brother was
Sunday.
asking, there was an order. Without executing the order, he have taken the child. That is also, there is some fault on the part of your client also.
I have filed one detail on the against their IA2 where an affidavit is filed how the child was taken. I have not accepted the contention that they
Without the process of the law.
process of the law it was taken. Yes, my lord. Yes, my lord.
And how the parents also ಈಗ 68 years ಅಂತ ಬರ್ದಿದ್ದೀರಿ. ನಮ್ಮ ಫಿಲಾಸಫಿ ಪ್ರಕಾರ ವಾನಪ್ರಸ್ಥಾಶ್ರಮ ಬಿಟ್ಬಿಡ್ಬೇಕು ಅಷ್ಟೊತ್ತಿಗೆ. ನಮ್ಮ ಮಕ್ಕಳನ್ನೇ ಬಿಡ್ಬೇಕು ನಾವು, ಬೇರೆಯವರಲ್ಲ. ಅದು ಫಾರ್ ದ್ಯಾಟ್ ಲಾಟ್ ಆಫ್ culture and
They are highly educated, they are not allowing the child to go even to school.
not in that ಅಂತ ಅನ್ಸುತ್ತೆ. ಅವ್ರು ಇಲ್ಲಿದಾರಲ್ಲ, ಏನಂತಾರೆ ಅವ್ರ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್?
They are in fact they are very highly educated and they can understand. Alla, they can understand the situation also.
We are not
No.
degrees.
We were only they were telling my lords, assuming for a while the child is I mean
And
in
how
a way
the sister also can insist that she is also one of the party ಅಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ತುಂಬಾ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಬೆಳೆದಿದೆ ಮಗು ಬಗ್ಗೆ.
ಈಗ yourself, myself, we have some attachment to the children of our siblings ಅಂದ್ರೆ we cannot claim that as of right.
ಈಗ ಒಂದು
At the most it hurts. Let it pain.
ಆರ್ಡರ್ ತಾವು ಮಾಡುವಾಗ
ತಡ್ಕೋಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ಯಾರನ್ನು ಬಿಟ್ಕೊಡೋದು ಬೇಡ ಅನ್ನೋ ತರ ಒಂದು ಹೋಮ್ ಸ್ಟ್ರಕ್ಚರ್ನ ಮಾಡಕ್ಕಾಗತ್ತಾ ಅಂತ ನಾನು ನೋಡಿದೆ ಅಷ್ಟೇ. ಅಂದ್ರೆ ಪೇರೆಂಟ್ಸ್ದು ಏನಿರುತ್ತೋ ಅದು ನಾವು ಯಾವತ್ತೂ ವಿ ಕಾಂಟ್ ಕಾಂಪ್ರಮೈಸ್ ಆನ್ ದಟ್. ಹಾಗೆ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸು ಸಿಸ್ಟರ್ ಇದೊಂದು ಒಬ್ಬರ ಮೇಲೆ ಒಬ್ರದ್ದು ಅಲಿಗೇಷನ್ ಬದಲಾಗಿ ಇಫ್ ಆಲ್ ದೀಸ್ 6 people ಟುಗೆದರ್ ಬ್ರಿಂಗ್ ಎ ವೆರಿ ಗುಡ್ ಲೈಫ್ ಫಾರ್ ದಿ ಚಿಲ್ಡ್ರನ್, ದಟ್ ವುಡ್ ಬಿ ವೆರಿ ಗುಡ್.
ಇದೆಲ್ಲ ಸಿಸ್ಟಮ್ ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದಾದ್ರು ಬೆಟರ್ ಕೌನ್ಸಿಲಿಂಗ್ ಆತರ ಮಾಡೋವಂಥದ್ದು ಇವ್ರಿಗೆ ಆಲ್ ದೀಸ್ ನಾಟ್ ಚೈಲ್ಡ್ ಫಾರ್ ದೀಸ್ ಪೀಪಲ್ ಯಾವ್ದಾದ್ರು ಅಂತಲ್ಲಿ ಕಳಿಸ್ಬೋದಾ ಅಂತ ವಿ ಆರ್ ಆಲ್ಸೋ ಥಿಂಕಿಂಗ್. ಇಮಿಡಿಯೇಟ್ಲಿ
ಇಟ್ಸ್ ಅ ವೆರಿ ಕಂಟಿನ್ಯೂಷಿಯಸ್ ಮ್ಯಾಟರ್ ಅಂಡ್ ಮೈ ಓನ್ಲಿ ಕನ್ಸರ್ನ್ ಇಸ್ ಚೈಲ್ಡ್ಗೆ ಈ ತರ ಡಿಫರೆನ್ಸಸ್ ಬರ್ಬೋದು.
ಈ ತರ ಇವ್ರಿಗೆ ಅಂದ್ರೆ ಬೆಟರ್ ಕೌನ್ಸಿಲಿಂಗ್ ನಾಟ್ ಇನ್ ದಿಸ್ ನಮ್ಮ
I may have to consult.
ಇದ್ರದಲ್ಲ.
ಗೊತ್ತಾಯ್ತು. I may have to consult Dr. Sheshadri and get back to your lordships. Dr. Sheshadri is considered as an authority on this.
ನಾವ್ ಹಿಂದೆ
child-
ಕಳಿಸಿದ್ವಿ, didn't accept.
ಅಲ್ಲ ಈಗ ಅವ್ರು ತಗೊಳ್ತಾ ಇಲ್ಲ, ಯಾವ್ದು ತಗೋತಾ ಇಲ್ಲ, ಬಟ್ ಹೇಳ್ತಾರೆ, ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ಯಾರ ಹತ್ರ ನಾವು
ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಮಾಡೋಣ ಅಷ್ಟೊತ್ತಿಗೆ. ವಿಲ್ ಆಲ್ಸೋ ಮೆಮರೈಸ್ ಯಾವ್ದು ಮಾಡಿ ಯಾರ್ಗಾರ ಪೇರೆಂಟ್ಸ್ ಅಂತ. We too don't want, because they are so closely related, parents, children, ಅವರು ಅವರವರಲ್ಲಿ more than that grandchild.
ಇದು ಆರ್ಡರ್ ತಗೊಂಡ್ರೆ ಏನ್ ಪ್ರಯೋಜನ ಆಗೋಲ್ಲ.
These two should be first reconciled, parents and daughter. ಅದಾದ್ಮೇಲೆ ಉಳಿದಿದ್ದಾಗುತ್ತೆ.
ವೆರಿ ಟ್ರೂ.
ಎಸ್, ನೀವು ಮಾಡಿ ಇಬ್ರು, both of you try for that. Madam.
Yes, madam. Yes, we have tried and we have always told the welcome them, but they never allowed us inside the house. That is the problem. We have tried our level best to reconcile, and it's noted in the judgment also. They never allowed it during visitation.
ನೀವು ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಕರೆದು ಏನಾದ್ರು ನೀವಿಬ್ರು ಸೇರಿ ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಕರೆದು ಜಾಯಿಂಟ್ ಆಗಿ ಕೂಡಿಸಿ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಆಮೇಲೆ ವಕಾಲತ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡು ಹೋಗ್ತಾರೆ ಅಂತಂದ್ರೆ
ಎಂತ ಇಲ್ಲ ಅಯ್ಯೋ ವಿ ಆರ್ ನಾಟ್ ಇದೆಲ್ಲ ಚೈಲ್ಡ್ ಕಸ್ಟಡಿ
ನೀವ್
ಮ್ಯಾಟರ್ಸ್ ದಿಸ್ ಆರ್ ಆಲ್ ಪ್ರೋ ಬೋನೋ ಇದಾವೆ.
ಯಾವಾಗೂ ಒಂದ್ ಏನೋ ಅಡ್ವೈಸ್ ಮಾಡಕ್ ಹೋದ್ರೆ ಏನೋ ದೇ ಆರ್ ವರ್ಕಿಂಗ್ ಅಗೇನ್ಸ್ಟ್ ಅವರ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಮತ್ತೆ NOC ಕೊಡ್ತಾರೆ ಕೇಳ್ತಾರೆ ಅಂತ ಪರಿಸ್ಥಿತಿ.
ತಗೊಂಡ್ ಹೋದ್ರು ಚಿಂತೆ ಇಲ್ಲ ಈ ತರದ ವಿಷಯಗಳಲ್ಲಿ ನಾವು ವಿ ಶುಡ್ ನಾಟ್ ವರಿ. ವಿ ವಿಲ್ ಟ್ರೈ ಮೆಲೋಡ್ಸ್ ವಿತ್ ಇನ್ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ಬೋದು ತಾವು, ಇಲ್ದಿದ್ರೆ ಇನ್ ಬಿಟ್ವೀನ್ ವಿಡಿಯೋದಾದ್ರೂ ಇದ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
ಕಂಪ್ಲೈ ವಿತ್ 1 week.
You have to go for.
ಅಲ್ಲ ಇವಾಗ ಒಂದು ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಆಯ್ತು ಅನ್ನೋದೊಂದು ಬರ್ಬೇಕಲ್ಲ. shall be complied within 1 week ಆಯ್ತಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಬರ್ಕೊಳ್ಳಿ. At the intervention of the court, a video call visitation was facilitated between the child and the
Grandparents.
appellants.
Appellants.
Appellants' grandparents. Both counsel ನಿಮ್ಗೆ ರಿಕ್ವೆಸ್ಟ್ ಕೊಟ್ಕೊಂಡಿದೀವಿ ಅಂತ ಹೇಳೋದು.
ಅಲ್ಲ ಇನ್ನೊಂದೇನು ಅಂದ್ರೆ ನಮ್ಗೆ ಬೇಕಾಗುತ್ತೆ, ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ
The court finds that there is a possibility of there is a possibility of possibility. The court finds it fit to explore another possibility of settlement. Okay. Sari, our daughter, where she stays?
In Bangalore, Hebbal.
ಅದೆಲ್ಲ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಅಲ್ಲ, ಇವರು ನೀನ್ ಬಾ ಅಂತಾರೆ, ಮಗು ಅಪ್ಸೆಟ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿ. ಅದಕ್ಕೆ ಅವರು ಒಂದ್ ಯಾವ್ದಾರ ಒಂದು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಒಂದು ಇದನ್ನೋ ಅಂತಲ್ಲಿ ಮಾಡ್ಬೇಕು. ನಾವು ಹಿಂದೆ ಒಂದ್ಸರಿ ಇದು ಕಳ್ಸಿ.
ವಿಸಿಟೇಷನ್ ನಮ್ಗೆ ಬ್ಯಾಂಗ್ಳೂರ್ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಲ್ಲಿ 10 to 1 ಆದ್ರೂ ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ.
ಬೇಕಂದ್ರೆ ಬೆಂಗಳೂರು ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಲ್ಲಿ
ಅವ್ರು ಹೇಗಿದ್ರು ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಇದಾರಲ್ಲ, ಮಗು ಇದೆ. ಒನ್ಸ್ ಅ ವೀಕ್ ಈಗ ಸದ್ಯಕ್ಕೆ ಈ ತಾವು ತಮ್ಮ ಮುಂದೆ ಬರೋವರ್ಗಾದ್ರೂ ಒಂದು ದಿನ ಆದ್ರೂ ಲೆಟ್ ದಮ್ ಸ್ಪೆಂಡ್ 10 to 1. ಲಾಸ್ಟ್ ಆರ್ಡರ್ನ ತಾವು ಮಾಡಿ ನೋಡಿದ್ರು ಸಾಕು ಸ್ವಾಮಿ. ದೆರ್ ವಾಸ್ ಅನ್ ಆರ್ಡರ್ 10 to 1 ವಿತೌಟ್ ಪೇರೆಂಟ್ಸ್ ಬೀಯಿಂಗ್ ದೇರ್.
No, my lord. Without parents, we cannot allow the grandparents to, because they will.
When they meet, they should not say, "Are you comfortable? You want to come back?"
ಅಲ್ಲ ಅದಲ್ಲ ವಿ ವಿಲ್ ಅಂಡ್ ವಿತೌಟ್ ದಿ ಪೇರೆಂಟ್ ಅನ್ನೋದು ಯಾತಕ್ಕೆ ಅಂತಂದ್ರೆ ಚೈಲ್ಡ್ ಈ ಕಡೆಗೆ ಬರೋದಕ್ಕೆ ಹೆದರ್ಕೊಳುತ್ತೆ ಅಂತ ಅನ್ನೋದಕ್ಕೆ.
The absence of the child, they want to meet the parent, they want to meet the child.
Supervised ಇರ್ಲಿ.
How the child is connected to them only through that daughter.
True. For few hours. ಇಲ್ಲ ಬೇಡ, ತಾವು ಅದನ್ನು ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ವಿತ್ ದರ್ ಪ್ರೆಸೆನ್ಸ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ. ಅಲ್ಲ ಯಾಕೆಂತಂದ್ರೆ ಟ್ಯೂಟರಿಂಗ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಅವ್ರದ್ದು.
ಟ್ಯೂಟರ್ ಮಾಡಿದ್ದಾರೆ ಎಷ್ಟು ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
That's there, of course. 10 to 1 ಒಂದು.
You provide one visitation on any Saturdays or
at their house they can visit. To their house they can visit. To their house they can visit.
The house of the. See, the relationship between the parties is not good, so they will not come to your house. Even if they come, there will be some issues. Come to the Bangalore Mediation Center and meet there.
Tomorrow 10 to 1. Between 10 and 1.
No, tomorrow he's got school counseling. Only on Saturdays it's possible.
Saturday is a holiday. This Saturday, second Saturday.
Then next Saturday.
Their dates.
No, he's going. He wants to go to school. Ma'am, please understand. He's not been going to school for last 10 years. He has not been sent. He's already 10 years of age.
Madam, after school hours, what is the school hours?
School hours is 4 o'clock.
Thereafter they can meet.
5 to 8.
Saturday will not be the working day for them.
Saturday will not be a working day for the school.
18th ಬರುತ್ತೆ. Next Saturday ಅಂದ್ರೆ ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಏನ್ ಬರ್ತಾರೆ. ಅವಾಗ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ವರ್ಕಿಂಗ್ ಅವರ್ಸ್ ಇರೋದಿಲ್ವಲ್ಲ ಅವಾಗ.
Saturday, second Saturday half day work ಮಾಡ್ತೀವಿ ನಾವು ಜನರಲಿ, ಮಾರ್ನಿಂಗ್ಸ್ ಮಾತ್ರ.
ಹಾಫ್ ಡೇ ಮಾಡಬಹುದು. ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ ಹಾಫ್ ಡೇ ವರ್ಕ್ ಮಾಡ್ತೀರಾ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಲ್ಲಿ?
Second and fourth Saturday half day ಹೋಗ್ತೀವಿ. Second Saturday ಬೇಕಾದ್ರೆ ಕನ್ಫರ್ಮ್
It's a holiday, general holiday.
It's a holiday. It's a holiday. Only third Saturday it is.
18th ಮಾಡ್ಲಿ ಬಿಡಿ. 18th and 25th ಎರಡು ಮಾಡಿ. ಅದೇ ಅದು ವರ್ಕಿಂಗ್ ಡೇ.
ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ ಜಗದೀಶ್ ಫೋನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ ವಿ ವರ್ಕ್.
ಅದು ಬೇರೆ ಬಿಡ್ತಾರೆ. ಕಾಲ್ ಫಾರ್ TCR till next hearing date. respondents shall bring the child to the till the next hearing date. Till next hearing date. Till next hearing date, some visitation facility has to be provided. Therefore, the respondents shall bring the child to Bangalore Mediation Center at yes to 2 p.m. 3 p.m.
Yes.
3 p.m.
3 p.m.
On 18th and 25th of January 2025. The appellant's grandparents shall interact with the child.
And
The
aunt,
Bangalore
my lords,
Mediation
and
Center-
aunt. And aunt. Grandparents and aunt.
ಆಂಟಿಗೆ ಆಸ್ ಆಫ್ ರೈಟ್ ಹೇಗ್ ಬರುತ್ತೆ ಹೇಳಿ
ಅಲ್ಲ ಅವರು ಸಾಕಿದ್ದಾರೆ ಮಗು ಚಿಕ್ಕ ಮಗುವಿಂದ.
ಹೇಳೋದು ಈಗ ಒಂದೊಂದು ಸ್ಟೆಪ್
ಅವರು ಅಪೆಲೆಂಟ್ಸ್ ನಲ್ಲಿ ಇದ್ದಾರೆ ಅದಕ್ಕೆ ಕೇಳಿದ್ರು.
ಅಪೆಲೆಂಟ್ಸ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ, ನಮಗೇನು ಬರೋದಕ್ಕೆ ತೊಂದರೆ ಇಲ್ಲ. ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್ ಸೆಂಟಿಮೆಂಟ್ಸ್. ಆದ್ರೆ ಇದು ಕೊಟ್ಟಿದ್ದಾರಿಗೆ ಅವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರ?
ಅಪೆಲೆಂಟ್ಸ್ ಮತ್ತೆ ಆಕೆನೂ ಇದ್ದಾರೆ
ಅಲ್ಲ,
ಅದರಲ್ಲಿ.
ವಿಸಿಟೇಷನ್ ರೈಟ್ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಆರ್ಡರ್ ಅಲ್ಲಿ?
ಆಲ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಆಫ್ಟರ್ ದ ಕಸ್ಟಡಿ ಇಸ್ ಗಿವನ್ ಅಂತ 159 ಅಲ್ಲಿ, ಬಿಕಾಸ್ ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ಕಸ್ಟಡಿ, ವಿ ಕಾಂಟ್ ಇವನ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ದಿಸ್. ದಟ್ಸ್ ಪ್ರಾಬ್ಲಮ್. ಪೇಜ್ 159 my lords.
ಅದೇ ನೋಡಿ. In a petition filed in WC number so and so to declare the petitioners is hereby dismissed. However, liberty given to the petitioners in G and WC 9 of
ನಾವು 3 ಜನನೂ ಇದೀವಿ.
4 ಜನ ಇದ್ದೀರಾ?
ಹೌದು.
Appellants ಅಂತ ಮಾಡಿ. They are also appellants ಅಲ್ವಾ? So are permitted to interact with the child till 5 p.m. After 5 p.m. Respondent shall pick up the child. List on date. Communicate the copy of this order to the Bangalore Mediation Center. List on after 29/1.
Grateful mercy.
I may be permitted to file my
Records may kindly
objections.
be called for mercy. LCR.
Yes, call.
Objections to I number 2, my lords. I may be
File it in the register. If there is any objection, they will verify. For number 30. ಇವ್ರಿಗೆ ಮಾಡಿಸೋದು.
For final hearings, number 32, D. Vijay Kumar, N. Gopal Krishna, O. Mahesh.
My lord, I am for the appellant.
I appear for the appellant amendment.
My lord, you ask me kindly take exhibit P2, my lord. Mahajaran sketch.
Yes. Yes, yes.
Please, my lord.
Yes, got it. Yes, proceed.
Please, my lord, you ask me kindly see exhibit P2, the sketch. It is on the next page.
Yes.
My lord, the bus is going from Bangalore towards Kadapa.
Yes, next ಇದನ್ನ submission ಮಾಡಿದ್ರಿ ನೀವು ಮುಂದಿನ ಪಾಯಿಂಟ್ ಹೋಗಿ.
I'll explain how the sketch is, my lord. Well, the car is coming from Kadapa towards Bangalore.
Yes.
My lord, kindly see the place of the bus and also the car. The car is on the extreme right side of the road. That is wrong side of the road.
Yes.
Complaint was given by somebody else who was not at the place of
So,
accident.
this sketch is drawn at the time of spot mahazar. By that time, both the vehicles were brought and kept on the roadside.
No, it is not nobody's case. It is nobody's case.
Mahazar ನೋಡಿ
It
ಏನ್
is-
ಹೇಳ್ತಾರೆ ಅಂತ.
My lord, your last may kindly see, if the vehicle, my lord, if our bus went on the wrong side,
Spot of the accident is shown in the middle of the road.
almost on the middle of the road, but actually it dashed against the ongoing car. Thereafter, it rolled on the other side. My lord, if our bus has dashed against the car, my lord, car should have gone on the right side of their our bus. It cannot come to the left side.
Yes.
And even if the police authority, if the vehicle is, both the vehicles on the other side, they would have kept the vehicle on that side only. They will not bring it to this side.
Yes.
Your lordship got my point. ಬಸ್ಸು ಈ ಕಡೆಯಿಂದ ಹೋಗಿ ಹಂಗ್ ಹೊಡೆದ್ರೆ ಬಸ್ಸು ಕಾರ್ನ ಆ ಕಡೆಗೆ ತಗೊಂಡು ಹೋಗ್ಬೇಕಿತ್ತು. It will not bring this side.
Yes.
And my lord, our bus is on the front and their car is on back. That means it rolled on the other side. Our bus has no way in connection with this. Otherwise, as per Exhibit P, my lord, the IME report, it is at Exhibit P. Exhibit P3, my lord, if our bus dashes against the car, well, only front portion of the car should be damaged.
Yes.
Here, my lord,
Right bumper has been shown to be damaged.
yes.
Yes.
Here, my lord, to what extent the damage is caused to the car, because it is rolled on the other side, to the right side of the road.
Yes.
Therefore, my lord, our bus never dashed the car either from right side or it has gone to the wrong side of the road. Nobody's case that our bus has gone to the wrong side of the road. Therefore, my lord, merely because the Scorpio car was hit by the car, Maruti van, went away, because this is a government vehicle, they have falsely implicated. My lord, your last may kindly appreciate one more point here. It is the usual fact that wherever the government vehicles or heavy vehicles are involved, even though there is no negligence in their part, still, my lord, they have filed the charge sheet against the other vehicle, our vehicle. Here, my lord, the car has got a valid insurance policy. There is no dispute with regard to the liability. My lord, as usual, my lord, simply they file charge sheet against our vehicle and they take complaint against our vehicle, and even the tribunal also, as usual, in many cases, fix the entire liability on us. My lord, your last may kindly see, interestingly, in the claim petition of all the cases, no one has mentioned who was driving the car at the time of accident.
It is
Why they
mentioned.
have not disclosed? Why they have not disclosed about the driver of the car? What happened to him?
Yes. Next.
And my lord, we have examined the driver of the bus. In his evidence, he has clearly stated that's what how our contention has taken also, and nothing is elicited in his cross-examination. Merely because the police have filed a case against you, so and so, the entire negligence is fixed on our vehicle. Therefore, my lord, it is only the negligence of the driver of the car, and the insurance company is also a party. There is no dispute with regard to the liability. Therefore, insurance company is liable to pay the compensation. It is not the APSRC bus.
Yes. That's all.
Evidence PW.
Then, my lord,
Eyewitness.
You can please take your seat or mugili kutkoli. Yes.
my lord, the witnesses, my lord, they are all interesting eyewitnesses. No, they have not examined any independent eyewitnesses. They have not examined the investigating officer, why their car is on the other side of the road.
Yes.
Even in the major also, nothing is available. Therefore, my lord, there cannot be any negligence. And my lord, one court, my lord, fixes 50% negligence because they have stated head-on collision. In other two cases, my lord, without considering this aspect also, fix 100% negligence on the APSRC.
Yes.
Therefore, my lord, the APSRC bus is not at all negligent and responsible for the accident. And liability, entire liability should be fixed on the national insurance company, who is the insurer of the car. There should not be any discrimination, my lord, regarding heavy vehicle and a small vehicle. Then, my lord, regarding quantum of compensation, my lord, in MFA 8710, there is no appeal by the claimant, and it is our appeal.
Yes.
My lord, here my lord, the deceased is aged about 58 years. He is a police constable. This is also one of the fact where, my lord, the police have got influence that one of the police official is died in the accident. Therefore, my lord, the negligence is fixed on the APSRTC bus. My lord, he is aged about 58 years. My lord, he was earning a sum of rupees 20,000 rupees per month. My lord, the split multiplier should have been applied, then it was prevailing. Because he was having only 2 years of service. My lord, the claimants are, my lord, wife and the 3 major married daughters who are not depending upon the income of the deceased and they are residing elsewhere. No one has examined before the tribunal to show that they are totally depending upon income of the deceased father and what is their status about their self and also their husband. My lord, without appreciating as this aspect, my lord, simply merely because there are 4 claimants, tribunal has fixed deducted 1/4 towards personal expenses instead of 50% as per Manovargan decision. Because his wife is only the claimant, dependent. Other 3 dependents cannot be considered as their dependents. They are married major daughter. Even they have not laid any evidence that in what way they are depending upon the income of the deceased. Therefore, my tribunal has committed great error in not deducting 50% and deducting only 1/3 towards personal expenses and awarding huge compensation, my lord. My lord, total compensation, my lord, tribunal has awarded is rupees, my lord,
25 lakhs 6,000.
25 lakh 6,350, out of which our liability is only 50%.
8% interest.
And with 8% interest. My lord, here, my lord, the tribunal should have deducted 50%. And my lord, regarding conventional head, my lord, tribunal, my lord, awarded almost like 3 lakh and add towards the conventional head. There is no justification for awarding this type of award. Therefore, my lord, the compensation should be drastically reduced by taking 50% dependency, deduction towards 50%.
Yes, that's all.
Please, my lord. Then, my lord, in another case, my lord, in MFA 1399/2017, my lord, it is a case of injury, my lord. Devraju, it is a different judgment.
MVC 157.
My lord, they are also occupants of the car. But no one has stated who was driving the car at the time of accident. My lord, tribunal has awarded, my lord, 3,15,000 rupees, 3,15,700 for the injury with 8% interest. My lord, regarding medical expenses, my lord, exhibit P10 is the bills. The total amount is rupees 45,395. But the claimants have paid only 14,530. And as per the bill, my lord, exhibit P10, they have not paid rupees 31,170. When they have not paid the amount to the hospital authority, there is no receipt for that. They are not entitled for any compensation under that rate. Without considering this aspect, tribunal has awarded rupees 45,000 towards medical expenses. And my lord, absolutely there is no evidence regarding future medical expenses. Still, it is awarded with interest. Then, my lord, PW3, Dr. Krishna Prasad, my lord, he has not treated the claimant. He gives evidence in almost all the cases. And my lord, he has given false evidence stating that 38% disability to the upper limb and 12% to the whole body. My lord, first of all, there cannot be 38% disability to the limb. Even if it is there 38%, my lord, when compared to the whole body in respect of upper limb, 1/4 to be taken as a disability to the whole body. That means, my lord, 9% should have been taken. He has given evidence as 12% and tribunal has considered it, and my lord awarded rupees 1,61,300. Therefore, my lord, that is also on the higher side. Then, my lord, I'll come to MFA 1,400 of 2017, Chandrasekhar. Here also, my lord, regarding future loss of income, my lord, 10,36,000 is awarded, amenity 75,000, food nourishment 15,000, future medical expenses 40,000, my lord. Absolutely, there is no evidence, no document. And as on this day, they have not produced any further documents also. Pain and suffering is awarded towards 1 lakh, my lord. This is also on the higher side. Interest is awarded in all the 3 cases, my lord, 8%. That's also on the higher side.
That's all. Yes, Mahesh ಅವ್ರದ್ದೇನಿತ್ತು?
But my appeal, my lord, is MFA 7869 of 2015 against MEC 1389 of 2014.
And also, my lord, sorry, when the photos also produce photographs, your Rashmi kindly see how the accident has taken place and also vehicles on the other side of the.
Yes, ಹೇಳಿ ಮಹೇಶ್.
Please, my lord.
Lord, it's in respect of death of my lord, one
ವೆಂಕಟಾಚಲಪತಿ. Yes.
Venkatesha, Reserve Police Officer, my lord, traveling in the Maruti van. Now, my lord, I would like to invite your lordship attention to the claim petitions, my lord, 2 claim petitions in MEC 1389
Yes.
and 158 of 2014. My learned friend was canvassing that nothing has been mentioned about who was driving the Maruti van in which, my lord, the victims were traveling. Your Honor, kindly have, my lord, the claim petition in MEC 1389 of 2014.
Yes, yes, please. Given by R. Ramesh.
Yes, driven by R. Ramesh. And in also, my lord, 158 of 2014 in column number 22, it is specifically mentioned driven by R. Ramesh. Therefore, the first contention of the other side does not hold water. Now, my lord, I'll take your lordship through the, my lord, the evidence of the driver who was examined on behalf of the, my lord, the APSRTC RW1. In the cross-examination, ಪ್ರಶ್ನ ಕೈಲಿಸಿ ಪಾಟಿ ಸವಾಲು 3ನೇ ಎದುರುದಾರರ ಪರ ವಕೀಲರಿಂದ ನಾನು ಭಾಷಾ ಎನ್ನುವ ಬಗ್ಗೆ ಇಲಾಖೆ ಅಡಿ ಕಾರ್ಡ್ ಇರುತ್ತದೆ, ID ಕಾರ್ಡ್ ಇರುತ್ತದೆ. ನನ್ನ ಇಲಾಖೆಯ ನಂಬರ್ ಸೋನ್ಸೋ ದಿನ ಸದರಿ ಅಪಘಾತವು ರಾತ್ರಿ 11ರಿಂದ 11:30 ಗಂಟೆಗೆ ಆಗಿದ್ದು, ಅಪಘಾತದ ಸ್ಥಳದ ರಸ್ತೆ ಅಗಲ 24 ಅಡಿ ಅಗಲ, ಅದು ಡಬಲ್ ರಸ್ತೆ ಡಿವೈಡರ್ ಇದೆ. ಮಾರುತಿ ವ್ಯಾನ್ ನನ್ನ ಮುಂದುಗಡೆಯಿಂದ ಬರುತ್ತಿತ್ತು. ಮಾರುತಿ ವ್ಯಾನ್ ಮುಂದುಗಡೆ ಸ್ಕಾರ್ಪಿಯೋ ಹೋಗುತ್ತಿದ್ದು, ಸ್ಕಾರ್ಪಿಯೋ ವಾಹನ ಸಡನ್ ಆಗಿ ಬ್ರೇಕ್ ಹಾಕಿದ್ದಕ್ಕೆ ಮಾರುತಿ ವ್ಯಾನ್ ಸ್ಕಾರ್ಪಿಯೋಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದು ಎಡಗಡೆಯಿಂದ ಬರುತ್ತಿದ್ದ ಬಸ್ಸಿಗೆ ಡಿಕ್ಕಿ ಕೊಟ್ಟಿದ್ದು ಇರುತ್ತದೆ. ನಾನು ಫಿರ್ಯಾದು ಕೊಡಲು ಹೋಗಿದ್ದೆ, ಆದರೆ ತೆಗೆದುಕೊಳ್ಳಲಿಲ್ಲ. This is the evidence of the driver of. Then more particularly, evidence by the claimant themselves. Last paragraph, ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯ ಸಂಗತಿ ಓದಿ ಕೇಳಿ ಗೊತ್ತಾಗಿದೆ. ನನಗೆ ಸ್ಕಾರ್ಪಿಯೋ ಕಾರು ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ. ಅಪಘಾತವಾದ ದಿವಸವೇ ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ತಿಳಿಸಿದ್ದೇನೆ. ಅಂದರೆ ದಿನಾಂಕ, ವಾರ ನೆನಪಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿ ಕೊಡಲು ಹೋಗಿದ್ದ ಫಿರ್ಯಾದಿಯ ನನ್ನ ವಿಷಯಗಳು ನೆನಪಿಲ್ಲ. ನನ್ನ ವಾಹನ ಎಷ್ಟು ಮಾಡಿದ್ದು ಅಪಘಾತ ಸ್ಥಳದಲ್ಲಿಯೇ ಇದ್ದು ನನ್ನ ವಾಹನ ಮತ್ತು ಮಾರುತಿ ವ್ಯಾನ್ ಫೋಟೋಗಳನ್ನು ತೆಗೆದಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ನನಗೆ ತೋರಿಸಿದ ಫೋಟೋಗಳು ನೋಡಿದೆವು. ಅವು ಅಪಘಾತ ಸ್ಥಳದ ಫೋಟೋಗಳು ಇರುತ್ತದೆ. ಅವುಗಳು ನಿಶಾನೆ P11 ಎಂದು ಗುರುತಿಸಿ ನನ್ನ ವಾಹನ ಬಲಭಾಗದಲ್ಲಿ ಹಾನಿಯಾಗಿದೆ ಅಂತ ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಕಾರು ಮತ್ತು ಬಸ್ಸಿನ ಮಧ್ಯೆ ಡಿಕ್ಕಿಯಾಗಿದೆ. This is the evidence of RW1 who was examined on behalf of the APSRTC, said to be the driver of APSRTC. Now, I will invite your lordship attention to the sketch which my learned friend was referring to. There, my lord, the place of impact is shown very clearly, my lord, in the middle of the road. The driver, my lord, has admitted it's a 2-lane, but not with a divider, but with a dividing line. That's all. It is almost in the middle of the, my lord, the theory put forth by the other side, my lord, that Scorpio, and that is also evidence of the driver of the bus. Scorpio van was going in front of the Maruti van. Suddenly brake was put. There was no need for him to put brake, my lord, even if that theory were to be accepted. Because the bus which was coming from the opposite direction was negligently being driven. And if the Maruti van has gone and dashed against the hind portion of the Scorpio, then, my lord, Maruti car would have been toppled. The heavy mass and the velocity of the vehicle which was coming from the opposite direction, my lord, and hit the, my lord, the right side of the Maruti van, that made, my lord, to topple it. And the vehicles were, my lord, are removed on the left side. That is not the case, my lord, that the accident was on the other side. But it was clearly, my lord, in the middle of the road. Then, my lord, IMA report exhibit P3 may kindly be looked into. AP, that's the first one, my lord. Front bumper damage at right side. Front right side headlamp damage. My lord, this shows, my lord, that it has dashed the, my lord, Maruti van. Then, my lord, you must kindly turn to, my lord, the sketch. That also, my lord, and then photos, my lord, exhibit P11. P11 may kindly be looked into, my lord. Where, my lord, it has been clearly mentioned with a circle. The bus, my lord, is almost, my lord, crossed the center dividing line. Van, my lord, all on the left side of the dividing line. This has been accepted by the, my lord, the driver who was examined as RW1, which I read out to your lordship earlier. Then, my lord, the next photos also, my lord, have been shown, which clearly establish, my lord, that the bus driver has gone to the, my lord, crossed the middle lane and dashed against the Maruti van. If really, my lord, if the Maruti van has dashed against a Scorpio, as the theory put up by the APSRTC, it would have stopped. It was not stopped. That means, my lord, the theory put forth, my lord, by the driver is, my lord, is improper just to escape his skin, my lord. Then, my lord, charge sheet, my lord, may kindly be looked into, my lord. P3. Though driver was examined as RW1, my lord, he has not stated whether what was the result of the, my lord, this charge sheet. Pardon?
Charge sheet is exhibited.
Charge P3, my lord.
P3 is something else. P3 is IME report.
P5A, sorry, my lord, P5A. There are two cases, it has been, my lord.
Now in this 1389.
Yes.
Charge sheet ಎಷ್ಟು ಅಂತ ಮಾರ್ಕ್ ಆಗಿದೆ ಅಲ್ವಾ?
P5A, my lord.
A ಅಂತ ಕಾಣ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ ಯಾವುದು?
ಅಲ್ಲ, ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಫ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ಅಲ್ಲಿ ink page 41 of my appeal, typed page 15 of the judgment, the lordship will get it. Charge sheet exhibit PA, small a. In my appeal, my lord.
It is also marked at exhibit R3.
In another matter, my lord, it is R3.
Finding it,
5A, 5A. ಅಲ್ಲ, ಎರಡು ಕೇಸ್ ಇದೆ. ಒಂದಲ್ಲಿ
ಇದು 1389.
in my appeal, my lord, it is marked as
Yes, what do you want to show?
Connected case R4.
a minute.
ಆಯ್ತು, ನಮಗೆ ಸಿಕ್ಕಿದೆ ಅದು ಯಾವ್ದಾದ್ರೂ ಇರ್ಲಿ ಹೇಳಿ, ಏನು what you want to show us from that?
My lord, I would like to invite your lordship attention to, my lord, column 17 of the charge sheet.
Yes.
Therefore, kindly see, ದಿನಾಂಕ 2/8/2016 ರಾತ್ರಿ 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಚಿಂತಾಮಣಿ ಗ್ರಾಮಾಂತರ ಪೊಲೀಸ್ ಠಾಣೆ ಸರಹದ್ದು ಕಡಪ ಬೆಂಗಳೂರು ರಸ್ತೆ ಅಲಂಬಿಗಿರಿ ಕ್ರಾಸ್ ಬಳಿ ಈ ಪ್ರಪತ್ರ ಅಂಕಣದ 12ರಲ್ಲಿ ಕಂಡ ಆರೋಪಿ 1 ಅವರು APSRTC AP 29Z1418 ಬಸ್ ಅನ್ನು ಬೆಂಗಳೂರು ಕಡೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ಎದುರುಗಡೆ ಬರುತ್ತಿದ್ದ KA 53M 6023 ಮಾರುತಿ ವ್ಯಾನಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಸಿ ಅಪಘಾತ ಉಂಟು ಮಾಡಿದ್ದು. ಇದರ ಪರಿಣಾಮ ಮಾರುತಿ ವ್ಯಾನಿನಲ್ಲಿದ್ದ ವೆಂಕಟಾಚಲಪತಿ ಅವರಿಗೆ ತಲೆಗೆ ತೀವ್ರವಾದ ಪೆಟ್ಟಾಗಿ ಸ್ಥಳದಲ್ಲೇ ತೀರಿಕೊಂಡಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ 2 ಇವರಿಗೆ ತಲೆಗೆ, ಬೆನ್ನಿಗೆ, ಸೊಂಟಕ್ಕೆ ತೀವ್ರ ಸ್ವರೂಪದ ಗಾಯಗಳಾಗಿದ್ದು, ಸಾಕ್ಷಿ 3 ಇವರಿಗೆ ಬಲವಾಗಿ ಸೋಣಿಸು. This is also the recital in column number 17 of the charge sheet, which has not been disputed. Yeah. Therefore, my lord, my respectful permission, my appeal, my lord, by the insurer of the Maruti van on issue of, my lord, negligence and the reasoning of the tribunal to hold, my lord, the driver of the, my lord, the Maruti van was also negligent to an extent of 50%, requires to be, my lord, set aside.
Yes.
Yes. Then my lord, coming to the quantum of
Yes.
my lord in the revenue reserve police and would have been retired my lord in 2 years. And the claimants my lord is the wife and 3 daughters married. And they cannot be my lord construed as the dependents on the income of the deceased except the wife. Therefore, my lord, the deduction of my lord 1/4 is not correct. It should have been 1/2. And the multiplier, my lord, also should have been split. Since he would have retired within 2.5 years.
Yes.
Yes.
In what way they were dependent financially? Therefore, my lord, the loss of dependency assessed by the tribunal to an extent of my lord 21,87,000 requires to be my lord reduced. Apart from my lord the liability and 1 lakh my lord love and affection, 25,000 burial and obsequies, 10,000 transport, 3,350 lost to the estate again my lord. That is also not called for and not proved. Consortium my lord 75,000. So totally my lord 25,06,350. 8% interest is also not warranted. Therefore, my lord, the holding of the terminal that the driver of the Maruti van was contributed to the cause of the accident to the 50% has to be, my lord, set aside. And the APSRTC alone, my lord, has to be solely made liable.
Yes. And then. Yes.
For climate, it doesn't matter whoever pays, whether APSRT pays or insurance company pays. So far as quantum got to the MFA, MFA 8710 of 2015, that should be deceased by a police constable, reserve police.
1389.
Deceased was a police constable, reserve police, age 58 years. His retirement was doing 2 years and drawing salary of 27,000 per month. Claimants of the wife and 3 daughters who were was married. And their contention, my lord, that split terminal table ought to have been applied since he had only 2 years of service. That condition, Honorable Supreme Court, later Supreme Court judgment that held that is not applicable.
PW2 is employer. Huh? Who is PW2? Devraj.
PW2 eyewitness.
Devraj and
Devraj eyewitness.
eyewitness. Employer and
Employer. Government.
Salary certificate for this. Salary certificate is exhibit P8. Salary slip is P9.
Okay. Salary slip exhibit P8, salary certificate. Exhibit P9, salary slip.
But PW2 is not a eyewitness. He is one of the claimant.
Eyewitness himself sustained injuries. He was in the Maruti van.
P9 salary slip.
Exhibit P9, salary slip, and exhibit P, salary certificate.
Yes. P9. So his gross salary was
27,000.
Adrally stitch basic 21,600. Idenu gottagadu DA matra tagobekku 4600 cut ಮಾಡಿಬಿಡಿ ಅಲ್ಲ ಅಲ್ಲಿ ಮೇಲೆ ಓವರ್ ಟೈಮ್ allowance ಅಂತ ಏನಾದ್ರು ಬ್ರೇಕಪ್ಸ್ ಏನಿದೆ 3240 2160 ಅವೆಲ್ಲ ಅದೇನು ಅಲ್ಲಿ ಮೊದಲು ಪಿನ್ ಮಾಡಿರ್ತಾರೆ ನಿಮ್ಮ ಹತ್ರ ಸ್ಯಾಲ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಇದೆಯಾ ಸ್ಯಾಲ್ರಿ ಸ್ಲಿಪ್ ಆದ್ರೆ ಏನೇನಿತ್ತು ಅದರಲ್ಲಿ 21,600 ವಾಸ್ ದ ಬೇಸಿಕ್
Please.
ಏನು 3,240 2,160 ಅಂತ ಡಿಸ್ಕಷನ್ ಅಲ್ಲಿ ಹೇಳಿದಾರ
Discussion line ಇಟ್ಟಿಲ್ಲ.
That is
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಹೇಳಿದಾರೆ
P
20,250
That is loss of dependence.
ಅಲ್ಲ
Lord, exhibit 8 and 9, my lord.
That is one, after deducting 3/4, 20,000
ಅಲ್ಲ ಎಂಟೈರ್ ಸ್ಯಾಲ್ರಿ ತಗೊಂಡ್ರ ಅದು ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಹೇಗೆ ತಗೊಂಡ್ರ ಸ್ಯಾಲ್ರಿ ಸ್ಲಿಪ್ 27,000 ಪರ್ ಮಂತ್ ಅಂತ ಮಾಡಿದ್ರು
ಮಾಡಿದ್ರು
27,000 ತಗೊಂಡಿದ್ರು.
But that entire 27,000 was salary.
Exhibit
ಯಾವ್ದಾದ್ರು allowance
Exhibit P8 and 9, my lord. P8 and 9 mechanic.
ಮತ್ತೆ ಆಮೇಲೆ DA ತಗೋಬೇಕು ಬಿಕಾಸ್ HR ಏನು ತಗೋಬೇಕು ಯೂನಿಫಾರ್ಮ್ ಅಲವನ್ಸ್ ಮೆಡಿಕಲ್ ಅಲವನ್ಸ್ ಎಲ್ಲರೂ ತಗೋಬೇಕು ಇದು DA is 3,240 HR ಏನು ತಗೋಬೇಕು ಇದು ಯೂನಿಫಾರ್ಮ್ ಅಲವನ್ಸ್ ಮೆಡಿಕಲ್ ಅಲವನ್ಸ್ ಅದು ಬರೋದಿಲ್ಲ ಇದು ಎಷ್ಟು ನೋಡಿ 21,600 ಪ್ಲಸ್ 3,240 21,600 plus 3,240 plus 2,160 27,000 ಕರೆಕ್ಟ್ ಬರೀ 201 27,000 ಅಲ್ಲಿ ಇದು 27,000 12 ಮಾಡಿದ್ರೆ ಟ್ಯಾಕ್ಸಬಲ್ ಆಗುತ್ತೆ ಅದು 27,000 ಅದರಲ್ಲಿ ಇದನ್ನ ಡಿಡಕ್ಟ್ ಮಾಡುತ್ತಲ್ಲ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ ಮತ್ತೆ ಇದೆಲ್ಲ
200 rupees professional tax.
200 ಪರ್ ಮಂತ್ ತೆಗಿತಾರೆ
ಅಲ್ಲ
2,400 ಆಗುತ್ತೆ ಪರ್ ಇಯರ್
ಹೌದು ಅಲ್ಲ per month per year 2,400 200 per year 2,400
ಇದರಲ್ಲಿ 200 ಕಳಿಬೇಕು
Income tax is not deducted.
26,800 into 12 ಮಾಡಿದ್ರೆ ಟ್ಯಾಕ್ಸಬಲ್ ಲಿಮಿಟ್ ಬರುತ್ತಾ ನೋಡ್ಬೇಕು ಇದು ಯಾವ ಇಯರ್ ಇದ್ದು 27,000 into 12 ಮಾಡಿದ್ರೆ ದಟ್ ಈಸ್ ದ ಬೆಸ್ಟ್ 3,24,000 ಅವಾಗ ಟ್ಯಾಕ್ಸಬಲ್ ಲಿಮಿಟ್ ಎಷ್ಟಿತ್ತು
ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಡಿಡಕ್ಷನ್ ಹೋಗುತ್ತೆ 1,50,000.
ಇದು 2014
14.
2 lakhs ವರ್ಗುನು ಎಕ್ಸಂಪ್ಟ್ ಇದು ಅಬೌಟ್ 2 lakhs ಅಪ್ ಟು 5 lakhs 10%.
ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಡಿಡಕ್ಷನ್ ಹೋಗುತ್ತೆ 1,50,000 is not after standard deduction 2 lakhs. So it is within taxable limits.
ಡಿಡಕ್ಷನ್ 2 lakhs ಹೋಗುತ್ತೆ ಇದರಲ್ಲಿ ನಾಟ್ 1,50,000 2 lakhs ಇದೆ
2 lakhs ಇದೆ ಅದರ ಮೇಲೆ
ಅದು ಉಳಿದಿದ್ರ ಮೇಲೆ
ಅದ್ರ ಮೇಲೆ
ಈಗ 24,000 ಬಂತಲ್ಲ ಅದರಲ್ಲಿ ಮೈನಸ್ 2 lakhs ಮಾಡಬೇಕು
ಅಲ್ಲೇ ಡೈರೆಕ್ಟ್ ಮಾಡಿರೋರು
ಇದರಲ್ಲೇ ಇದನ್ನ ಪ್ರೊಫೆಷನಲ್ ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡಿಬಿಡಿ
ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಅಲ್ಲೂ ಮಾಡಿರೋರು ಅದು ಮಾಡಿಲ್ಲ
2004 ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಅಲ್ಲಿ IT ಡಿಡಕ್ಷನ್ ಇಲ್ಲ
ಅದಕ್ಕೆ ಸೊ he was not done tax.
ಇಲ್ರಿ ಅದು ನಾವು ಬೇಕಂದ್ರೆ ಕೊನೆಗೆನೆ ಕಟ್ಕೋಬಹುದು ಸ್ಯಾಲರಿ ಅಲ್ಲೇ ಡಿಡಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇರೋದಿಲ್ಲ
But salary certificate is exhibit P8.
3,21,000.
Otherwise, they have to produce the income tax returns.
2 lakhs ಹೋದ್ರೆ ಎಷ್ಟು ಉಳಿತು 1,21,600 ಅದ್ರ ಮೇಲೆ 10%
5% ಬರುತ್ತೆ
5% ಇಲ್ಲ
ಹೌದು
ನೋಡಿ
ಅವಾಗ ಇಲ್ಲ 5% ಅಲ್ಲಿ
ಫೈನಾನ್ಸ್ ಆಕ್ಟ್ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತಾ ಇದೀವಿ ಅಬೌಟ್ 2 lakhs 10% ಅಂತ ಅಬೌಟ್ 2 lakhs ಅಪ್ ಟು 5 lakhs 10%. ಇದೆ 1,21,000.
ಸೊ
10% ಮಾಡ್ಬೇಕು ಅವಾಗ ಎಷ್ಟು 12,160 ಬರುತ್ತೆ ಅಲ್ವಾ 16 ಅದನ್ನ ಮೈನಸ್ ಮಾಡಿ 1,21,600 ಅಲ್ಲಿ 1,09,400. ಇದ್ರೊಳಗೆ ಈಗ ನಾವು ಡಿಡಕ್ಷನ್ 144 ಕೊಡ್ಬೇಕಾ 2 ಕೊಡ್ಬೇಕಾ ಅದೆಲ್ಲ ನೋಡ್ಕೋಬೇಕಾಗುತ್ತೆ. ದಿಸ್ ಈಸ್ ಆನ್ಯುವಲ್ ಇನ್ಕಮ್. ಇದರಲ್ಲಿ ಮ್ಯಾರಿಡ್ ಅಲ್ವಾ, ಹಾಗಾಗಿ ಇವನ್ ಇಫ್ ಓನ್ಲಿ ಒನ್ ಡಿಪೆಂಡೆಂಟ್ ಥರ್ಡ್ ಎನರ್ಜಿ ಸರಳ 250 1/3. The daughters were examined now.
Daughters are partial.
Has to be deducted or one.
Daughters are lifelong, they are partially dependent the parents.
They have not come into the witness box to say that we are dependent on our father.
Even without go saying that daughters always there.
Yeah,
ಗಂಡು ಮಕ್ಕಳು ಯಾರಿಲ್ಲ ಅವರಿಗೆ, ಓನ್ಲಿ ಡಾಟರ್ಸ್.
ಗಂಡು ಮಕ್ಕಳು ಇಲ್ಲ. See, under the Motor Vehicles Act, they should be dependents of the deceased.
Partial dependence will be there, my lord.
Partial dependence ಹೆಂಗ್ ಬರುತ್ತೆ? ಬರೀ ಎಮೋಷನಲ್ ಡಿಪೆಂಡೆನ್ಸ್.
ಅಲ್ಲ, ಮನೆಗೆ ಬಂದು ಅವ್ರಿಗೆ ಏನೋ ಕೊಡ್ಬೇಕಲ್ಲ, ಅದೆಲ್ಲ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇರ್ಲೇಬೇಕು.
ಯಾವ
ಹೆಣ್ಮಕ್ಳು ಮನೆಗೆ ಬಂದು
ಸರಿ
ವೈಫ್ ಇಸ್
ಅದಕ್ಕೆ ಅಲ್ಲ ಇಲ್ಲಿ ಏನ್ ಮಾಡಿ ಆ ಸರಳ ಅವ್ರ ಮಕ್ಕಳು ಮ್ಯಾರಿಡ್ ಇತ್ತು ಇದ್ರೆ
ಅವ್ರ ಮನೆ ಮಾಡಕ್ ಬಂದಿದ್ದು ಹೇಳ್ತಾರೆ.
ಮನೆಗೆ ಬಂದ ಕೊಡೋ
ಇದು 2/3 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ. ಇದು 1,09,440 ಇದು ಮಿಸ್ಟೇಕ್ ಮಾಡಬಾರ್ದು ಅಂತ 2/3 ಮಾಡಿದ್ದೀನಿ. 22,960. ಅಪ್ಲಿಕಬಲ್ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಎಷ್ಟು? 58 years. 58 years.
58 years. Our contention was, Lordship kindly see that Supreme Court,
9 multiplier.
9 multiplier, that is correct. Split multiplier cannot be applied ಅಂತ.
640. Loss of dependency. ಆಮೇಲೆ ಇದು ಕೊಡಬೇಕು ಕನ್ಸೋರ್ಷಿಯಮ್. ಈವನ್ ಫಾರ್ ಡಾಟರ್ಸ್ ಕನ್ಸೋರ್ಷಿಯಮ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಗಿವನ್ ಈವನ್ ಇಫ್ ದೇ ಆರ್ ಮ್ಯಾರಿಡ್.
And wife is there, it should be at least 1/3. If wife is there, only for bachelors 50%, not for the.
ಅಲ್ಲ ಎಷ್ಟು 1 2 3 4
4.
ಹಾ ಎಷ್ಟು 44 into 4 1,76,000 ಆಗುತ್ತಾ? 1,76,000 ಕನ್ಸೋರ್ಷಿಯಮ್ ಅದೇ 33,000 ಆಗುತ್ತೆ. 33,000 ಇದು ಮಾಡಿ
8,65,640.
8,65,640. 640 ಅವಾರ್ಡ್ ಆಗಿರೋದು ಎಷ್ಟಿದೆ ಇದರಲ್ಲಿ? ಕಡಿಮೆ ಆಗುತ್ತಲ್ರಿ ಹಾಗಾದ್ರೆ 25,06,000.
For year.
ಓ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಬರೋದಿಲ್ಲ 58 ಬರೋದಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
10% ಬರುತ್ತೆ, 15%. Less than 60 years and 10 government employee.
Sorry, we made a mistake.
15% ಬರುತ್ತೆ.
50 to 60 years 10% ಬರುತ್ತೆ, not 15%.
My lord, there is no appeal by the claimants.
Government employees. Government
Here
15%.
My lord, there is no appeal by the claimants.
ಎಷ್ಟು? ಸಾರಿ, we made a mistake. ಇದಕ್ಕೆ 72,000 ಎಷ್ಟು ಮಾಡಿದ್ವಲ್ಲ 70. ಅದಕ್ಕೆ ನಾವು ಒಂದು 15% ಇಲ್ಲೇ ಸೇರಿಸ್ಕೊಂಡ್ರೆ ನಡೆಯುತ್ತಲ್ಲ, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಡೂಯಿಂಗ್ ಆಲ್ ದಿಸ್ ಎಕ್ಸರ್ಸೈಸ್. 72,960 50%. ಇಲ್ಲ ಅಲ್ಲ, ಆಕ್ಚುಲಿ ಇಲ್ಲೇ ಸೇರಿಸ್ಬೇಕಾಯ್ತು. 3,24,000ಗೆ 3,24,000 15% ಎಷ್ಟಾಗುತ್ತೆ ಹೇಳಿ? ಸಾರಿ, ವಿ ಹ್ಯಾವ್ ಟು ಡೂ ಆಲ್ ದಿಸ್. ಇಲ್ಲ ಹಂಗೆ ಮಾಡಿದ್ರೆ ಅದಕ್ಕೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಅಂದ್ರೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡಬಾರ್ದು. ಹಾಗಂದ್ರೆ 48,600 ಅವಾಗ 3,24,000 ಪ್ಲಸ್ 48,600 3,24,000 ಪ್ಲಸ್ ಸಾರಿ ಈ 27,000ಗೆ 40% ಎಷ್ಟಾಗುತ್ತೆ ಮಾಡಿ? 10,800 40%. ಎರಡು ಸೇರಿಸಿದ್ರೆ ಅದ್ ಹೆಂಗ್ 40% ಆಗೋದಿಲ್ಲ ಸರಿ 15%.
15%.
15%.
My lord, there is no appeal by the claimants, my lord.
How many times you will repeat that?
Allah, your lordship has not responded to it, that's why, my lord.
Yes. 4,050. Yes. When we are ಎಷ್ಟು? 31,050. ಆಯ್ತಾ? Into 12. 3,72,600. ಇದರಲ್ಲಿ ಮೈನಸ್ 2,400. ಹಾಗೆ ಮಾಡಿದ್ರೆ ನಡೀತೆ ಅದು ಮಾಡಿ ಎಷ್ಟು? 3,70,200. ಇದರಲ್ಲಿ ಅಪ್ ಟು 2 lakhs ಕಳಿಬೇಕು. ಅಂದ್ರೆ 1,70,200 ಟ್ಯಾಕ್ಸಸ್ ಫಿಲ್ ಆಗುತ್ತೆ. ಇದ್ರ ಮೇಲೆ 10% ಅಂದ್ರೆ 17,020 ಮೈನಸ್ 1,70,200 ಅಲ್ಲಿ 17,020 1,53,180. ಅದರದ್ದು 2/3 ತಗೊಳ್ಳಿ. 1,53,180 53,180 2/3 ಎಷ್ಟು? 120 ಇಂಟು ಮಲ್ಟಿಪ್ಲೈರ್ ಎಷ್ಟು ಹೇಳೋದಿಲ್ಲ 9. ಇದು ಇನ್ಕಮ್ ತಪ್ಪು ತಗೊಂಡು ಯಾಕಂದ್ರೆ ಇದನ್ನ ತಗೊಂಡ್ಬಿಟ್ಟಿಲ್ಲ ಇಲ್ಲ 17,020 ಇದ್ರಲ್ಲಲ್ಲ ಇದ್ರಲ್ಲಿ ಕಳಿಬೇಕಾಗಿತ್ತು 3,70,000 ಅಲ್ಲಿ. His income of 3,70,200. ಅದೇ ಹಾಗಾಗುತ್ತೆ. ಈಗ his net income was ಎಷ್ಟು? ಅದಕ್ಕೆ ಸ್ಲ್ಯಾಬ್ ತಗೊಳಕ್ ತಗೊಂಡು 3,70,200 ಅಲ್ಲಿ ನಾವು 17,025 ಟ್ಯಾಕ್ಸ್ 3,70,200 ಮೈನಸ್ 17,020 ಎಷ್ಟು? 3,53,180. ಅದರದ್ದು 2/3 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ? 453 ಮಾಡೋಣ. ಇಂಟು ಎಷ್ಟದ 9 ಮಲ್ಟಿಪ್ಲೈ 21,19,077. ದಟ್ ಇಸ್ ಕರೆಕ್ಟ್. ಸ್ವಲ್ಪ ಅದು ನಾವು ಇದು ಬಿಟ್ಬಿಟ್ಟಿದ್ವಿ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ವಿ. ಆಮೇಲೆ 1,76,000 and 33,000. 23,28,077. ಅಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ 8% ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಒಂದಿಷ್ಟು ಆಗೋದು 28,077. ಅವಾರ್ಡ್ ಮಾಡಿರೋದು 25 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ. 6,350 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಲ್ಲಿ ಕನ್ವೆನ್ಷನಲ್ ಹೆಡ್ ಮೇಲೆ ಕೊಡುವಾಗ ಅವರು ತಪ್ಪು ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ 25,06,350 ಅಲ್ಲ 8%. Sir, yes, this is our quantum in this case.
How much?
Plus 8% and
How much comes?
23,28,077.
Now coming to my last submission.
Cross objection ಯಾವ ಕೇಸ್?
MFA.
ಇದೇ ಮಿಸ್ ಇದೆ 13
ಇದು ಬೇರೆದ್ರು.
ಇದು ಬೇರೆ.
MFA 1,417.
Split multiply.
32.3.
MEC ಯಾವುದು?
MEC 158 of 2014.
Claimants. Yes, MEC.
MEC 158 of 2014. MFA.
Yes, 158.
MFA 1,400 of 2017. It is case of paraplegia, my lord. Paragraph 33 onwards of the judgment. Doctor assessed 95% disability.
33.
Paragraph 33 onwards. This tribunal considers the compensation. PW case is further report that he has sustained high left partial contusion with India, D12 burst fracture with paraplegia, bilateral pneumothorax, and that paragraph 34 again, ma'am. The petitioner has got examined on Dr. Krishna Prasad, orthopedic surgeon, Postmart Hospital, who has reported that open injury sustained burst fracture of D12 with complete paraplegia, cerebral edema, bilateral pneumothorax. Patient was inpatient in hospital from 10 to 2014 to 21 to 2014. D12 fracture has healed with 50% compression. The patient is completely paraplegic and totally wheelchair bound. He has no residual power in his both lower limbs. He has no control of bladder and bowel. He has a catheter and vapors. Patient has got difficulty in his day-to-day activities. One attendant is completely required for his movement and health. He has assessed 95% permanent visibility whole body. Patient has to need physiotherapy, daily dressing, nursing care and catheter and artificial and pet
No
scope.
rectal.
Whereas tribunal taken, admitted considering the evidence of certificate and doctor assessed 95% disability of the whole body. Tribunal has taken 65%. And future prospect not considered. And compensation granted to other rights also.
Considering the evidence of Chandrasekhar.
Chandrasekhar. And future attendance charges also not granted. Doctor evidence would clearly reveal that he requires a date attendant to for day-to-day.
What is the reason given for reducing that? Patient has suffered internal page 34.
34.
Both limbs are functioning person. Therefore, this tribunal assesses 60%.
Without any, just like that.
PW3 is not a neurosurgeon. He is orthopedic surgeon. Patient has suffered. His limbs are not functioning as per the normal. Therefore, this tribunal assesses 60%. 25 years.
25 years.
But, cross-examination of that witness, anything is elicited about his competency?
Please, ma'am.
Doctor PW3?
PW3.
Doctor is PW3.
PW3. Dr. Krishna treated hospital.
Records.
He is not a treated doctor and also not a neurosurgeon.
He is from the Postmart Hospital.
ನಿಮ್ದು ಆಗಿದೆ ಅಲ್ಲ ವಿಜಯ್ ಕುಮಾರ್ ಅದನ್ನ ಅವಾಗ್ಲೂ ಹೇಳಿದಿರಿ ನೀವು.
ಅಲ್ಲ ಈ ಇದ್ರ ಬಗ್ಗೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಬಗ್ಗೆ
ಹೇಳಿದಿರು.
ಕರೆಕ್ಟ್ ಅದನ್ನ ನೀವು ಹೇಳಿದಿರಿ. he is not a treated doctor. ಅವ್ರು ರೆಗ್ಯುಲರ್ಲಿ ಬರ್ತಾರೆ ಅಂತ ಹೇಳಿ.
ಹೌದೌದು.
You should not make some comments against others in their absence. ವಿಜಯ್ ಕುಮಾರ್ ಅವರು ದಿವಸ ಅಪಿಯರ್ ಆಗ್ತಾರೆ, ಅವ್ರು ಬರೀ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಪರವಾಗಿ ಮಾತಾಡ್ತಾರೆ ಅಂತ ನಾವೆಲ್ಲರೂ ಹೇಳಿದ್ರೆ ಬೇರೆ ಕಡೆ
ಡ್ಯೂಟಿ ಅದ್ ಮಾಡ್ಲೇಬೇಕಲ್ವಾ?
ಡ್ಯೂಟಿ ಅಲ್ಲ, ಕೋರ್ಟ್ ಆಫೀಸರ್. ಯು ಆರ್ ದ ಕೋರ್ಟ್
No, we are assisting the court, my lord. We are assisting the court.
Brushing the.
Doctor evidence ಅಲ್ಲೇ ಇದೆ.
ಈ ಕೇಸ್ ದಿಸ್ ಇಸ್ MEC 158 ಅಲ್ಲ, ಇದರಲ್ಲಿ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಹಾಕಿದ್ದೀರಾ ನೀವು?
ಹೌದು.
ಪೇಜ್ 25.
ಚಂದ್ರಶೇಖರ್.
Para 35 onwards. Para 35 onwards.
ನೀವು ಮಾಡುವಾಗ ನಾವೇನು ಮಾತಾಡಲಿಲ್ಲ. ಸುಮ್ಮನೆ ಇರಿ, ಯಾಕೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಿಲ್ಲ ಎಲ್ರಿಗೂ. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಯಾರಾದರೂ ಮಾಡಿದ್ರೆ ಇಂಟರ್ಫಿಯರ್ ಆದ್ರ?
PW2.
PW2. Accident.
PW2 or PW3?
PW3 ಮೈಲ.
PW3. ಡಾಕ್ಟರ್ ಕೃಷ್ಣ ಪ್ರಸಾದ್ ಏನ್ ಹೇಳ್ತಾರೆ?
And he was brought to Postmart Hospital.
orthopedic surgeon. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ದಾರೆ? ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಕ್ಸ್ಪರ್ಟ್. It is true that there is a mistake in my affidavit about date of admission and date of discharge of patient Devaraju. Devaraju was admitted. ಓದಿ ಅದನ್ನ. Cross exam, you have the copy?
Cross examination ಇಲ್ಲ.
ಬಿಡಿ. ಅಲ್ಲ ಅವ್ರೇನೋ ಅವ್ರ ಕಾಂಪಿಟೆನ್ಸ್ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಅದನ್ನೇನಾದ್ರೂ ಕೇಳಿದಾರ?
ಏನು ಕೇಳಿಲ್ಲ.
Cannot say what reason patient was not admitted in.
ಅದನ್ನ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ. Is taken treatment in same hospital.
All fracture of patient Devra's scapula bone and ribs are properly united at present.
ಅಲ್ಲ ಎರಡು ಕ್ಲಬ್ ಮಾಡಿದ್ದಾರೆ ಇನ್ನೊಬ್ರು ಇರ್ಬೇಕು. ಇನ್ನೊಬ್ರು
He is Chandrasekhar.
ಚಂದ್ರಶೇಖರ್ ದೇವರಾಜ್.
ಚಂದ್ರಶೇಖರ್ ಬಗ್ಗೆ ಕೇಳಿದ್ದೆ ಎಲ್ಲಿದೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್? ಇಲ್ಲಿ ಚಂದ್ರಶೇಖರ್ ಪ್ರೊಡ್ಯೂಸ್ ಎಕ್ಸ್ರೇ ಚೀಫ್ ಅವ್ರ ಬಗ್ಗೆ ಬೇರೆನೆ ಮಾಡಿದಾರ. ಇವರೆಲ್ಲ ಅವರೇ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಲ್ಲ. ಕರೆಕ್ಟ್. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅಬೌಟ್ ಚಂದ್ರಶೇಖರ್ ವಾಟ್ ಇಸ್ ಎಲಿಸಿಟೆಡ್ ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು. It is true to say that Dr. Bhushan Joseph is the neurosurgeon and Dr. Vishwajit is a chest surgeon who has treated Chandrasekhar. And in orthopedic sector, it is true that D12 burst fracture is united with compression. It is false to say that patient Chandrasekhar has not suffered 95% permanent disability on account of accidental injuries. Not produced approximate cost list of major medical expenses. Why did you not examine the treated doctors? Because he says
he was from the Mosmat hospital only, madam.
He has said that this patient was admitted there for only one day. He got discharged anta helidare. So he was treated in some other hospital, not in this hospital.
There
ಹಾಗೆ ಹೇಳಿದ್ದಾರೆ.
MVJ hospital, Hoskote and Nimans.
ನಿಮ್ಮನ್ಸ್ ಒಂದೇ ರೆಫರೆನ್ಸ್ ಅಷ್ಟೇ. ನಿಮ್ಮನ್ಸ್ ಅಲ್ಲಿ
Which is that document, your discharge summary of Chandrasekhar?
Discharge summary.
Exhibit P19. P19.
18 and 18, 19.
18 hospital 21. 10 to 2014 to 21 to 2014. No?
Or 20. He was inpatient for in their hospital for about. He was there 11 days. Date of admission 10 to 2014 and discharge 21.
He has spoken to this.
He was in the hospital from 10 to 14 to 21.
Course of treatment. Patient admitted on 23 with hand and chest injury. The sleep hospital was shifted to ICU and an emergency ventilator support in ICU. Stabilized. ICU insertion was done on 11th. 20 plus decompression and sedation was done on 20. Removal was done on 20. Once patient was stable, he was shifted to lab and discharged. JCS operated range is revealed except for 2 raw area height of previous abrasion. Patient has to do avoid daily dressing at the local hospital. The next local hospital. In history of patient is it? Traumatic paraplegia since 1 year, since 15 days, high grade fever is there, intermittent high grade fever associated with chills and swelling. hospital, MRI finding, impression. Job duration is 10 to 2014. Right part of body displaced into along with the traumatic paraplegia. Traumatic paraplegia ಅಂತ ಇದೆ ಅಲ್ಲ ಅದು 100% paraplegia ಅಂತ ಎಲ್ಲೂ ಕಾಣ್ತಿಲ್ವಲ್ಲ ಈ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ 100% paraplegia ಅಂತ ಎಲ್ಲ
95%
ಅಲ್ಲ ಇವ್ರು ಹೇಳ್ತಾರೆ he is not the
but he
doctor
has
who has treated our
no sensation over the, he was in the hospital for 11 days, in the Swasman hospital.
ಕರೆಕ್ಟ್ ಅದು ಟ್ರಾಮ್ಯಾಟಿಕ್ ಪ್ಯಾರಾಪ್ಲೇಸಿಯಾ ಅಂತ ಹೇಳ್ತಾರೆ ಅದು ಕಂಪ್ಲೀಟ್ ಅಂತ 100% ಅಂತ ಹೇಳಿಲ್ಲ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್
90 below waist no sensation and there is no control over the,
ಅಲ್ಲ ಅವರೇನೋ ಹೇಳಿದ್ರಲ್ಲ he was on catheter even after discharge ಬೆಡ್ ಸೋರ್ಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಬೇಕು ಅಂತ ಹೇಳಿ ಅದು ಎಲ್ಲಿದೆ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ
inpatient records.
But he is not the doctor who has treated him.
He is from the treated hospital only. All treated
Hospital.
Unit ಅಲ್ಲಿ ಇರ್ತಾರೆ ಒಬ್ರು ಇವ್ರು. So he is one of the members of the unit. So they send him to give evidence to the hospital.
ಎರಡು ಇಂಪಾರ್ಟೆಂಟ್ ಅದು ಎಕ್ಸಿಟ್ P18 and 19 discharge summary. ಯಾವ ಇಯರ್ ಇದೆ February 2014. Discharge summary ಒಳಗೆ ಎಲ್ಲ ಬರ್ದಿರ್ತಾರೆ ಅವರು ಇದು ಉಳಿದ ರೆಕಾರ್ಡ್ಸ್ ಏನಾರ ಇನ್ಪೇಷಂಟ್ ಸ್ಲಿಪ್ ಏನಾದ್ರು ಅವರು ಇವನ್ನ ಸೆಕ್ಯೂರ್ ಮಾಡಕ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅದ್ರ ರಿಪೋರ್ಟ್ಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ಸ್ ಅವೆಲ್ಲ ಇದ್ರಲ್ಲಿದೆ discharge summary ಅಲ್ಲಿ ಎಲ್ಲ ಇರುತ್ತೆ yes reduce ಮಾಡಕ್ so tribunal has taken
60%.
Yes.
And picture prospect not been granted, my lord. On a death, the evidence of that would reveal that it requires a lifelong attendant. The death compensation towards attendance has not been granted.
This case.
And compensation towards pain and suffering and amenities also inadequate. And loss of marriage prospects have not been granted.
Yes.
So overall, the compensation award is much on the lower side.
95% to 65% reduce ಮಾಡಿದೆ
60, tribunal has taken 60%.
60%. Future prospects ಸೇರಿಸಬೇಕಿತ್ತು ಅಂತ
ಸೇರಿಸಿಲ್ಲ.
Notional income case.
8,000 rupees tribunal.
Accident is in 2014. ಎಷ್ಟಿತ್ತು ಅವಾಗ
8,500.
Tribunal has taken 8,000.
Tribunal has taken 8,000. So it requires a lifelong attendant and marriage prospect not been granted.
Yes, loss of marriage prospects, amenities, attendance charges.
And parent suffering.
Yes.
In another case, that the compensation grant is just 3,15,000. I think that is just improper.
Oh, sir. We'll dictate it on some other day. We'll go through that medical evidence once again because it's very bulky.
Yes.
Hard. For further hearing, list on death case in ಒಂದು ಮಾಡ್ಕೊಂಡಿದೀವಿ ಇಂಜುರಿ ಕೇಸ್ ಇಂದ ನೋಡ್ತೀವಿ ಬಟ್ ಇದ್ರ ಮೇಲೆ ಫೈಲಿಂಗ್ ಮಾಡಿ ಇನ್ನೊಂದು ಇಲ್ಲಿ ಟೋಟಲ್ ಅದನ್ನ ಬರ್ಕೊಂಡು Date Monday Monday.
Please.
ಈ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅದ್ರಲ್ಲ ಅದು ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ಪ್ಲಿಟ್ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಅಪ್ಲೈ ಹಿಂದೆಲ್ಲ ನೋಟ್ಸ್
Dictating judgment. For dictating judgment.
ವಿಲ್ ಡಿಕ್ಟೇಟ್ ಏನಾರ ಡೌಟ್ ಇದ್ರೆ ಅಷ್ಟೇ ಕೇಳ್ತೀವಿ ನಾನು
Please.
ಬಿಕಾಸ್ ದಟ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ವಿ ಹ್ಯಾವ್ ಟು ಒನ್ಸ್ ಅಗೇನ್ ಚೆಕ್.
Right.
Till number 33 adjourned. Till number 34, O Mahesh, Rajaram S, Sandesh Shetty, C.R. Ravishankar.
Appeal for the appeal.
ಇದ್ರಲ್ಲೇನಲ್ವಾ ರವಿಶಂಕರ್ ಅವ್ರ ಹೆಸರು ತೆಗಿರಿ ಅದೇನೋ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ. ಹಾ ಎಸ್ ಒಂದ್ರಲ್ಲಿ ಓಕೆ ಎಸ್
Yes, ma'am.
ಕನೆಕ್ಟೆಡ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ ಡಿಲೇ ಇದೆ ಅಲ್ಲ ಅದಕ್ಕೆ ಏನ್ ಹೇಳ್ತೀರಾ?
ಡಿಲೇ ಇದೆ ಸರ್ 768 ದಿನ ಡಿಲೇ ಇದೆ ಸೋಮವಾರ.
No interest if he succeeds.
ಮೇಡಮ್ ತಗೋ 34.1 ಅಲ್ಲಿ in case of
ಡೆತ್ ಮೈ ಲಾರ್ಡ್.
death. Madam, both
Yes,
of you
ma'am.
have filed wakalat. What are the instructions? Harinish
No
madam,
doubt. ನಂಗೆ
yourself
ಗೊತ್ತಾಗ್ತಾ
and Ravi Shankar both have filed wakalat.
ಹೌದು ಅವ್ರೇನೋ ನೆನ್ನೆ ಹೋಗಿ ಪೇಪರ್ಸ್ ತಂದೆ ನಾನು ಫೋನ್ ಮಾಡಿ ಕೇಳಿದೆ ಅವ್ರನ್ನ ಪೇಪರ್ಸ್ ತಂದಿದ್ದೀನಿ ಆ ಥರ ಏನೋ ಹೇಳಿದ್ರು. ಇದರಲ್ಲಿ ಮೇನ್ ಅಪೀಲಲ್ಲಿ ನೀವು ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ ಅದ್ರಲ್ಲಿ ನಾನು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರು ನನಗೆ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ.
ಅಷ್ಟೇ ನಿಮ್ಮ ಕಂಪ್ನಿಯಿಂದ ನಿಮಗೇನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್
ಇಲ್ಲ
ಇಲ್ವಲ್ಲ?
ನಾವು ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ ಅಷ್ಟೇನೆ, ಬಟ್ ನಾನೇನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಅವರಿಂದ.
ಎಸ್ ಹೇಳಿ ಇಲ್ಲ ಇದರಲ್ಲಿ 34.1 ಅಲ್ಲ ಏನ್ ಹೇಳಿದ್ದಾರೆ ರೀಸನ್ ಅಂತ ನೋಡ್ತಾ ಇದ್ವಿ. ವೆದರ್ ದೇರ್ ಆರ್ ಎನಿ ಮೈನರ್ಸ್ ನೋ 18 years of there. ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವುದು? 5 ಕೊಟ್ಟಿದ್ದೀವಿ. But considering the reasons aside, I explain the delay of 786 days in filing the appeal in the cross objection is condoned with the condition that if the cross objectors succeed, they shall not be entitled to interest on the enhanced compensation for the delayed period of 786 days. I number 1 of 2022 is disposed of accordingly. Yes. Hey,
Yes, madam. But it's a case of death of one Muhammad Ashik, aged about 19 years, said to be a painter earning rupees 15,000 per month. Award is, my lord, for 8,05,000, 9% interest, holding the respondent 1 and 2 jointly and severally liable. Date of accident, my lord, is 15/11/2014 at 1:10 p.m. The vehicles involved, my lord, is a mini lorry bearing registration number KL 13 E 9193 and a motorcycle bearing registration 3. It's a case of, my lord, pleaded is that the deceased was riding the motorcycle bearing registration number KA 19EM 48.
ಅವಾಗಿಂದ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಬರ್ತಾ ಇದೆ. ಏನಾಗಿದೆ ನೋಡಿ ಅನ್ಸಕ್ ಲಾಗಿನ್ ಇನ್ನೊಂದ್ಸರಿ ಇದು ಮಾಡಿ
ಅವರೇ
ಅವರೇ
ಬರ್ತಾರೆ
ಅವ್ರದೇ
ಬಂದ್ರು ಸರ್ ಮೈಕ್
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ
ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ನಿಮ್ದು ಮೈಕ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು? Yes.
Yes, madam. My lord, the claimant's mother, my lord, aged 44 years, and second claimant is the sister, aged 18 years. But it is the case, my lord, that he was riding the motorcycle, and due to the rash and negligent act of the, my lord, the driver of the mini lorry, he sustained injuries and succumbed to the injuries. But before the tribunal, the first respondent is the owner of the lorry. No statement was filed by him. Second respondent is the, my lord, Sriram General Insurance Company, or the insurer of the lorry, and now the present appellant in MFA 1315 of 2018. Muhammad Sadiq, my lord, third respondent, is the owner of the motorcycle. And R4 is the, my lord, Oriental Insurance Company is the insurer of the motorcycle. Yes. The appellant, my lord, was the second respondent, Sriram General Insurance Company, contended, my lord, that the accident was due to the negligence of the, my lord, the motorcycle rider himself, and he had no driving license at all. In respect of this, my lord, FIR and complaint was filed by one Abu Bakr. And charge sheet, my lord, is filed against one Damodar as A1, and Muhammad Sadiq, the owner of the motorcycle, as the second accused, for having let the, my lord, his motorcycle to be used to Muhammad Ashik, who had no license. But this is the brief facts of the case. But at the time of the trial, my lord, now I invite your lordship attention to the grounds which are raised, my lord, specifically, or also will give an insight into the, my lord, the appeal filed by the claimant, insurer of the lorry. Ink page 5, my lord, of my appeal.
You have disputed the involvement of the vehicle.
Yes. But now they say, my lord, the rider was, my lord, somebody else. That's how, my lord, they tried to this thing. That's why, my lord, I'll read the grounds which are raised, by which your lordship will get the insight into the, my lord, the claim and the grounds of appeal on which the appeal is presented. Now, your lordship kindly turn to, my lord, ink page 5 of my appeal, ground number 5. 3 also, my lord, 3. The finding of the tribunal on issue of negligence is improper since it failed to consider that the claimant purposely avoided to place relevant material evidence respecting the manner as well as negligence of the deceased, who was stated to be riding a motorcycle with a pillion rider. Then 5, my lord. The tribunal ought to have seen that no independent positive material evidence was let in by the claimant except alleged pillion rider when charge sheet exhibit P4 cited many eyewitnesses to the alleged accident. Then, my lord, the tribunal ought to have seen that exhibit P1 FIR complaint was by one Mr. Abu Baker, admittedly not an eyewitness, and even otherwise admittedly his complaint was based on information of someone else. 7. This is important. No? The tribunal ought to have seen that there was no direct evidence as to who was riding the motorcycle, since mother of the deceased, who claimed that her son was riding the motorcycle at relevant time, gave a different version in the cross-examination that Mr. Altaf was riding the vehicle. And this Altaf, pillion rider of the motorcycle, examined as PW2, admitted that the police have not recorded his statement, though he was treated in Indiana hospital, and tribunal further ought to have seen that this hospital did not send any MLC to the jurisdictional police, which is in contravention of section 39 of the Criminal Procedure Code. Then 8, my lord, the tribunal exhibit R2 and correctness of which was not disputed by the other side, clearly established that it was a case of head-on collision between two vehicles, and the rider of the motorcycle had gone to the other side of the road and had head-on collision with the insured mini lorry, and this fact was further corroborated by the respective damages found on both the vehicles at the time of inspection and the R3, which was also not disputed. Then 9. This is important. No? Further, the tribunal grossly erred in ignoring true fact that the deceased was given otherwise stated to
We should have contributed even if we had no license. Yes. ಹೇಳಿ
ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸಾರಿ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅನ್ಮ್ಯೂಟ್
ಇಲ್ಲ ಸ್ಟಕ್ ಆಗಿದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ
ತಿರ್ಗಾ
ಹ್ಯಾಂಗ್ ಆಗಿದೆ ಅದು
ಓ ಮಹೇಶ್
ಒಂದ್ಸರಿ ಇಟ್ಕೊಂಡಿರೋದಿಲ್ಲ ಎಸ್ ಮಿಸ್ಟರ್ ಮಹೇಶ್
ಏನೋ ಇಂಟರ್ನೆಟ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರ್ಬೇಕು.
ಅವರು ವರ್ಚುವಲಿ ಮಾತ್ರ ಬರೋದು, ಸರಿಯಾಗಿ ಇಟ್ಕೊಂಡಿರ್ಬೇಕು ಅವರು.
unstable internet connection.
So it is not stable. I have to come to the court. Yes.
May I continue, my lord?
Yes, you continue, but without any interruption.
No, not by me, my lord, but by the internet, my lord, not by
You
me.
are vicariously liable for that. If your system is not working.
Yes, I'll be vicariously liable.
Hey.
Ground number 9, my lord. Further,
Just summarize why you want to read the appeal memo. Understand, you say that he was not holding the driving license.
That is my argument. That is my argument. That's why, my lord, I want to bring it.
Criminal has said that even if he was not holding the driving license, unless he contributes for the accident.
No, my lord, what has happened is they tried to, my lord, switch the rider. I'll read, my lord, 9.
Deposition ಓದಿ ನೀವು ಎರಡನ್ನೂ ಕೇಳಿದಿರಾ ಅವ್ರಿಗೆ.
ಅಲ್ಲಲ್ಲ 9
cross examination of you have taken in one line in the cross examination of PW1 that Altaf was riding. ಅದಕ್ಕೆ ಅವರು ಅಲ್ತಾಫನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ತಾಫನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ನೀವೇ ಹೇಳಿದಿರಿ ರೈಡಿಂಗ್ ಇನ್ ರ್ಯಾಶ್ ಅಂಡ್ ನೆಗ್ಲಿಜೆಂಟ್ ಮ್ಯಾನರ್ ಅಂತ.
Apart from that, my lord, ground number 9 may kindly be looked into. In the light of this, my lord, ground number 9.
So if you want to read the appeal memo grounds, then we'll permit you only to read the ground of the appeal memo. ಮತ್ತೆ further arguments ಇಲ್ಲ.
ಇಲ್ಲ ಅಷ್ಟೇ ಮಾಡ್ತೀನಿ ನಾನು, ಅದರಲ್ಲೇ ಬಂದ್ಬಿಡುತ್ತೆ ಎಲ್ಲ.
Yes.
Further, the traveler grossly erred in ignoring proved fact that the deceased was even otherwise stated to be rider of motorcycle, had no DL at all, and the owner of which third respondent was prosecuted by the jurisdictional police under section 5(1) of the Redwood section 180 in CC number 3318 of 2015 on the file of the second court JMFC Mangaluru, later pleaded guilty and paid fine. He has entrusted the motorcycle, my lord, to a person who had no DL. So, my lord, that has been proved, and therefore, my lord, there was an attempt to shift, my lord, substitute the driver. That is evident, my lord. Even, my lord, the evidence of PW2 may kindly be looked into at this juncture. PW2, my lord. Muhammad Altaf. Yes. I say I am working as so and so, my lord. Para 2. I say at the time of the accident, I was along with the deceased in the motorcycle bearing registration number KA 19EM 4903 as a pillion rider. Then, my lord, then, my lord, page,
Yes.
page 3, my lord, cross-examination.
Yes.
Typed page 3 of PW2. ನನಗೆ ಚಾಲನಾ ಹರಿದಾರಿ ಇಲ್ಲ. ಅಪಘಾತದಲ್ಲಿ ಮೃತಪಟ್ಟ ವ್ಯಕ್ತಿ ಆಶಿಕ್, ಆತನಿಗೆ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇತ್ತೋ ಇಲ್ಲವೋ ಗೊತ್ತಿಲ್ಲ. ಅಪಘಾತಕ್ಕೆ ಒಳಪಟ್ಟ ವಾಹನ ಸಾದಿಕ್ ಎಂಬುದರಾಗಿತ್ತು. ಅಪಘಾತವು 407 ವಾಹನ ಎದುರಿನಿಂದ ಬಂದು ಗುದ್ದಿ ಕಾರಣ ಆಗಿರುತ್ತದೆ. ಆಶಿಕ್ ಯಾವುದೇ ತಪ್ಪಿನಿಂದ ಅಪಘಾತ ಉಂಟಾಗಿರುವುದಿಲ್ಲ. ನಾನು ತೊಕ್ಕೊಟ್ಟುವಿನಿಂದ ಮಂಗಳೂರಿಗೆ ಬರುತ್ತಿದ್ದೆ. 407 ವಾಹನ ಮಂಗಳೂರಿಂದ ತೊಕ್ಕೊಟ್ಟು ಕಡೆಗೆ ಬರುತ್ತಿತ್ತು. ನಾನು ಸ್ಥಳ ಮಹಾಜರು ಸ್ಕೆಚ್ ನೋಡಿಲ್ಲ. ಪೊಲೀಸರು ಅಪರಾಧ ಪ್ರಕರಣದಲ್ಲಿ ಏನು ತನಿಖೆ ಮಾಡಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. ಅಪರಾಧ ಪ್ರಕರಣ ಯಾರ ಮೇಲೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. ಅಪಘಾತ 407 ವಾಹನ ಚಾಲಕನ ಅತಿ ವೇಗ ಮತ್ತು ಅಜಾಗರೂಕತೆ ಕಾರಣವಾಗಿರ್ತದೆ. ನಾನು ಪೇಂಟಿಂಗ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಈ ಬಗ್ಗೆ ದಾಖಲೆಗಳು ಇಲ್ಲ. ಪೊಲೀಸರು ವಾಹನದ ಮಾಲೀಕ ಸಾದಿಕ್ ಮೇಲೆ ಚಾಲನಾ ಹರಿದಾರಿ ಇಲ್ಲದ ವ್ಯಕ್ತಿಯ ವಾಹನ ಮಾಡಲು ನೀಡಿದ ಕಾರಣಕ್ಕಾಗಿ ದೋಷಾಪತ್ರ ಸಲ್ಲಿಸಿದ್ದಾರೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. This is the thing. Then exhibit P4. There, my lord, the owner of the motorcycle, my lord, Muhammad Sadiq, was the second respondent, the second accused, and pleaded. Yes, my lord. Yeah. Therefore, my lord, you must kindly see, they are not come before the court, my lord, before the tribunal with clean hand, and they have tried to, my lord, substitute the rider, because for his own negligence, having no driving license, my lord, the deceased, my lord, will not be entitled for compensation. Therefore, my lord, they try to, my lord, plead something else. And thereby, my lord, you must kindly see, the claim petition would not be maintainable. Even, my lord, the deceased was riding the motorcycle without a driving license, which, my lord, was accepted by the owner before the, my lord, magistrate court, and also admitted that the rider of the motorcycle had no driving license. If that is so, then, my lord, you must kindly see. And regarding that, my lord, and also, my lord, regarding the negligence, my lord, is also there is no evidence. The PW2 who has been examined, my lord, he himself, my lord, has not supported the claim. So under these circumstances, my lord, my respectful submission, because of that, my lord, there can't be any liability on the, my lord, appellant insurer, appellant insurer. And regarding quantum, my lord, he was,
Have you examined the driver of that 407 vehicle?
no, they will not be available, my lord, because you are kindly see.
RW 1 and 2. Both of them are officers of the insurance
Yes,
company.
my lord. My lord, Raghu Nayak is, my lord,
Insurance
he
company.
he is an officer of the, my lord, Oriental Insurance Company.
Abhinandan is Shriram General.
Abhinandan is the Sriram, that is the appellant.
Appellant's insurance company.
Yes. Therefore, my lord, you should kindly see. In such cases, my lord, the driver would not be available, and moreover, my lord, I would insist upon, my lord, the non-compliance of section 134C of the MA Act by the insured, and
Yes,
section.
you already read that in the appeal memo. No
Yes,
repetition. Yes.
yes, my lord. Therefore, my lord, the question of, my lord, examining the driver does not arise at all. And so far as the quantum is concerned, you would have to kindly see. He was said to be a painter, my lord, no evidence was let in. But the tribunal, my lord, has taken it as 6,000 per month and deducted, my lord, 2/3 instead of 1/2. Forgetting, my lord.
Of the year 2014.
Yes, 14.
8,500 is the notional income.
Notional, regarding notional income, my lord, there is a division bench of this court, my lord, judgment of division bench, that what has been pleaded has to be proved, can't be laid upon, my lord, the chart of the Lok Adalat.
Age, what was
Age,
the
age, my lord, is 19 years.
There is no issue on that.
Yes. Then, my lord, and one more fact, my lord, you would have got married in near future. If that is so, my lord, any alleged contribution to the maintenance, my lord, to the, my lord, the mother would be reduced. That is not considered. Pragmatically, probabilities has to be considered. That's the, my lord, the ruling of the Supreme Court. And this fact has not been considered. And 9% interest has been allowed. So on these grounds, my lord, appeal has been filed.
So now in this case, the entire negligence is attributed to that vehicle, other vehicle only, not your insured vehicle.
ಅಲ್ಲ ನಮ್ಮ ವೆಹಿಕಲ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ
Vehicle ಮೇಲೆ ಇಲ್ಲ.
R5
So we'll hear them only.
ಕ್ಲಿಯರ್ ಮಾಡಿ ಆಮೇಲೆ ಯಾವುದು ಅವ್ರು ಹೇಳೋ ರೀತಿ ಯಾಕೆಂದ್ರೆ ಒಂದೇ ವರ್ಡ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತೇಳಿ 407 ಬಂದು ಕಿಲ್ ಮಾಡಬೇಕು ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ 138 or 134
ಏನು ಇಲ್ದಲೇ ಮಾಡ್ಬೋದು ಎಲ್ಲರೂ
ಕರೆಕ್ಟು ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತೇಳಿ ಕಾಂಟ್ ಕಿಲ್ ದಿ ಪರ್ಸನ್ ಅಷ್ಟೇ.
Yes, sir.
In this regard, my lord, your lordship may take the turn to the issue number 2, my lord.
Then he was unmarried, alva?
Also married.
19 years.
Issue number 2 has been proved.
Loss of dependency and transport and burial. Excuse 32,000 for medical expense. Medical expense bill ಕೊಟ್ಟಿದ್ದಾರಾ?
Medical agency. ಇಲ್ಲ sir.
32,000 is awarded on the head of medical expense.
Also married. ಅಷ್ಟೇ ಸ್ವಾಮಿ.
Cases?
ಹೌದು. ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ 32,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಅಂತಾನೆ ಇದೆ ನೋಡಿ, ಎಕ್ಸಿಬಿಟ್ P5
P5 medical bills were created.
ಕೊಟ್ಟಿದ್ದಾರೆ.
32,000 ಕೊಟ್ಟಿದ್ದಾರೆ somewhere.
His accident was on 15/11/2014.
14 my lord. 8,500 no.
When he died?
On the day itself he has died my lord.
Date of death is too. Date of death is on the same day. He died on the same day.
16/11/14 my lord.
One day.
ಒಂದಿನ ತೀರೋಗಿದ್ದಾರೆ.
ಒಂದೇ ದಿನ.
ಇದೆ ಅದ್ರ ಮೇಲೆ document ಇದೆ. So that has to be taken as 8,500. Yes, anything you want to submit?
No my lord, the tribunal has fixed the responsibility properly on the insurance company itself my lord. It is the policy was in force and driver was having DL my lord. And tribunal has fixed the
Personal expenses deduction, no?
50%.
50%.
Please my lord, 8,500 should be divided by 2 my lord, because he is a bachelor my lord.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟಸ್ ಬೇಡವಾ?
Prospect ಸೇರಿಸ್ಬೇಕಲ್ಲ. ಎಷ್ಟು?
1,700.
40%.
ಎಷ್ಟು ಅಂತ
1,000.
40%? 3,400. 3,400. Equal to ಎಷ್ಟು ಆಯ್ತು? 11,900.
Divided by 2.
By 2.
5,950.
5,950.
Into
12
12,
into 18.
into 12 into 18 my lord.
5,85,200.
Please my lord,
85,200.
200 my lord.
44,000. ಮದರ್ಗೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕಾಗುತ್ತೆ? 44,000 and
And
33,000.
33,000.
Medical expenses
32,000.
32,000. ಎಷ್ಟು ಸೇರಿಸಿ ಎಷ್ಟು? 12,85,200. 44,000, 33,000.
1,85,200.
44,000, 33,000, 32,000.
13,94,200.
13,94,200.
6% interest. 9% awarded.
And tribunal has awarded
9%.
8,05,000.
Please my lord,
8,05,000.
8,05,000.
So minus ಮಾಡಿ ಎಷ್ಟಾಗುತ್ತೆ?
5,89,200.
5,89,200. 6% interest ಕೊಡ್ಬೇಕು.
6% round. Arini Shivanan may be deleted.
ಅವ್ರಿದ್ದಾರೆ ಅಲ್ಲಿ.
ಇದಾರೆ ಅಲ್ಲ ಹೇಳಿದ್ದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು, ಯಾಕಂದ್ರೆ
ಅವ್ರು ಹೇಳಿದ್ದು.
ವಕಾಲ್ ಕಟ್ಟಿದ್ದಾರೆ, that's why.
ನಾವು
Otherwise I don't want to.
ಡಿಲೀಟ್ ಮಾಡೋದು ಬೇಡ, ಇಬ್ಬರ ಹೆಸರು ತೋರಿಸ್ತೀವಿ.
ಅಲ್ಲ ಕಂಪನಿ ಅವ್ರು ಹೇಳಿದಾರೆ, ಅದಕ್ಕೆ ನನಗೇನಿಲ್ಲ ಲಕ್ಷಿ, ಬಟ್ ಅವ್ರು ಹೇಳಿದಕ್ಕೆ ಈವನ್ ಅರಣಿ ಶಿವಾನಂದ
ಹದಿನೈದು ಶಿವಾನಂದ್ ಅವ್ರು
ಗೊತ್ತು, ಅದಕ್ಕೆ ನಾನು ಬರಲ್ಲ ಅಂದಕ್ಕೆ ಹೇಳಿದ್ದು.
ಮಾತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. there is no instructions ಅಂತ ಹೇಳಿದ್ರು.
ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟರು, ಅದಕ್ಕೆ ಹೇಳಿದೆ.
ನಿಮ್ಗೆ ಕೊಟ್ರೆ ಅವ್ರಿಗೂ ಕೊಡ್ಬೇಕಲ್ಲ ರವಿಶಂಕರ್. ನಿಮಗೆ ಹೇಳಿದ್ರೆ ಕಂಪ್ನಿಯವ್ರು ಅವ್ರಿಗೂ ಹೇಳ್ಬೇಕಲ್ಲ, ವಿತ್ಡ್ರಾ ಮಾಡಿ ಅಂತ ಹೇಳಿ. ಲೆಟರ್ ಇಲ್ಲೇ ಎಲ್ಲಿದೆ? ಲೆಟರ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ? ಹೇಳಿಲ್ಲ. ಹೋಗ್ಲಿ ಬಿಡಿ, ಇದ್ರಿ ಏನಾಗುತ್ತೆ? ಅವನಿಗೆ ಲೈಸೆನ್ಸ್ ಇರಲಿಲ್ಲ ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಫೈಲ್ಡ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್. ನಮ್ಗೆ 5 o'clock ಅಲ್ಲ ಇರೋದು. modify ಮಾಡಿ ಫೈಲ್ ಹಾಕಿದ್ರು. ಅಲ್ಲ ಆ ಫೈಲಿಂಗ್ ಮತ್ತೆ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಬೇಕು ತಾನೆ, ಎಕ್ಸ್ಪೆಂಟ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ನೆಗ್ಲಿಜೆನ್ಸ್ ಆಫ್
But may mention my lord.
ಮುಗೀತು, ಈಗ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಅಲ್ಲಲ್ಲ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಜಡ್ಮೆಂಟ್ ಆಗಿದೆ ಅದನ್ನ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ.
ಏನು judgment?
ಅದೇ ರಿಗಾರ್ಡಿಂಗ್ my lord, the in
Total
that
income.
I'll give the particulars my lord. MFA
Passed by division bench or single bench?
single bench.
You are citing that judgment before us?
ಅಲ್ಲಲ್ಲ ಅದೇನಿದೆ
Single
ಅಲ್ಲೇನ
bench ಇದು.
though he had no license, then the this thing is
ಅವನಿಗೆ
that
ಆಗೋದೇ ಇಲ್ಲ. We don't even
ಅಲ್ಲಲ್ಲ
consider his age, cost of living at that time and prevailing wage rates ಅಂತ ಅಷ್ಟೇ ತಗೊಳ್ತೀವಿ.
I'm saying about the liability my lord. You have to
We are
kindly.
not saying in our judgment that we are relying on KSLS is this thing. So you citing that judgment does not arise. ಇದು ಯಾವ್ದು cross objection ಅನ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಪೇಡ್ ರಿಕವರಿ ಮಾಡಿದರೆ ಓನರ್ ಮೇಲೆ ಅದಕ್ಕೆ ಅದೇ ಎಷ್ಟು
And cross objections are partly allowed. The impugned judgment and award passed by the tribunal in MS number 267 of 2015. The tribunal number passed by the first edition senior civil judge and MACT Mangalore DK is modified as follows. The claimants are entitled to compensation of rupees 13,94,200 with interest thereon at 6% per annum from the date of the petition till its realization. Respondent number Shriram General Insurance. Respondent number 2, Shriram General Insurance Company Limited shall deposit the aforesaid compensation before the tribunal within 4 weeks from the date of the receipt of the copy of this judgment on adjusting the amount already deposited, if any. ಅದರಲ್ಲಿ ಇನ್ನೊಂದು the enhanced compensation of rupees 5,89,200 shall not carry interest for a period of how many days ಇವತ್ತು ಮಾಡಿದ್ವಲ್ಲ ಅದು
786.
786 days. 786 days. The amount in deposit ಇನ್ನೊಂದು 50% of the amount name of ಹೇಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನ್ಯಾಷನಲೈಸ್ ಎಲ್ಲ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಗಿವನ್ ಟು ದ ಮದರ್.
No, madam. 60% to mother, my lord. 40% to the sister, my lord.
ಈಗ ಡಾಕ್ಟರ್ ಮೇ ಬಿ ಮೇಜರ್ ಮದುವೆನೂ ಆಗಿರ್ಬೇಕು ಅವಾಗಲೇ 18 years ಆಗಿತ್ತು.
Please, madam.
ಎಲ್ಲ ತಾಯಿಗೆ ಹೋಗ್ಲಿ ಬಿಡಿ.
ಆಯ್ತು ಸರ್.
ಏನಂತ ಹೇಳ್ರಿ ಡೆಪಾಸಿಟ್ ಅದಾದ್ಮೇಲೆ ಮುಂದೆ claimant number 1 is entitled to the entire compensation amount. Out of this amount deposited, 50% shall be digitally released to claimant number 1.
Please, madam.
Furnishing required documents, and balance 50% shall be invested in FD for a period of 3 years.
3 years, sir.
3 years in any nationalized / scheduled bank of her choice. Registry shall transmit the amount in deposit if any, and the TCS to the tribunal forthwith.
Please, madam.
ಇಬ್ರು ಬೇರೆ ಬೇರೆದ್ರಲ್ಲಿದ್ದಾರಲ್ಲ ಅವ್ರು ಹಾಗೆ ತೋರಿಸ್ತಾರೆ. Reasons to follow ಅಂತ ಬರೀಬೇಕು. Yes, next. Madam. Operative portion ಬರಬೇಕು ಕೊನೆಗೆ reasons to follow. This next question.
Still number 37. Ali Shantappa Basappa. TV Kalpana.
ಏನಿದು? Your other side ಮಹೇಶ್ ಅವರ. ಮಹೇಶ್ ಅವ್ರದ್ದು ಇದು ಯಾವಾಗ್ಲೂ ಸರಿಯಾಗಿ ವರ್ಕ್ ಮಾಡ್ತಿರೋದಿಲ್ಲ. ಮಹೇಶ್ ಅವರೇ ನೀವು ನಾಳೆ ಇಲ್ಲಿಗೆ ಬನ್ನಿ ಕೋರ್ಟ್ಗೆ.
ಇಲ್ಲಿ
Either you have to change your system or you have to come physical mode.
I change the
Or you have to
system.
change your virtual mode.
Well,
They should work, function properly.
but ಇದು internet is not stable.
ಹಾರ್ಡ್ ಅಂತ ಬರ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ ನೋಡಿ.
ಅಲ್ಲ ಅದು ನನ್ನ ಪ್ರೀವಿಯಸ್ ಅಪೀಲ್ ಏನಾಯ್ತು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ಅದೇ ನೀವು ಇಲ್ಲಿ ಬಂದು ತಿಳ್ಕೋಬೇಕು because we have dictated it in the open court. Yes. Yes, 37. Ready ಇದೀರಾ?
I am for respondent, madam. I am for it.
ರೀಚ್ ಆಗೋದು. ರಿಪೀಟ್ ನಾಳೆ ರಿಪೀಟ್ ಮಾಡಿದ್ರು. Tomorrow. It will be repeated tomorrow 37.
Yes, please.
Still number 39. Gopal Krishnayan. This is Shivannegowda.
21 ಯಾರು ಗೋಪಾಲ್ ಕೃಷ್ಣ ಇದ್ರಲ್ಲ ಇಲ್ಲಿ. ಶಿವಣ್ಣಗೌಡರೇ ಇಲ್ವಾ? ಆಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ಇದೇನು 2021 ಇದೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ ಸರ್.
ಏನು ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಹೇಳಿದ್ರು ರೀಚ್ ಆಗ್ತದೆ.
ಇನ್ನು ವಕಾಲತ್ತು ಹಾಕಿಲ್ಲ ಅವ್ರು ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.
Still number 40. KT Gurudev Prasad. Ravishankar Samprati.
ಇಬ್ರು ಕಂಡಿಲ್ವಲ್ಲ ಇವತ್ತು. ನನ್ನ ಕೇಸ್ ಅರ್ಜೆಂಟ್.
41. Ashok N. Patil. G. Ravishankar.
ರವಿಶಂಕರ್ ಇದ್ದಾರೆ.
I am appearing for connected appeal, my lord. Two appeals are one by the insurance company and by the claimant, my lord.
ಅವ್ರು ಹಾಕಿಲ್ವಾ ವಕಾಲತ್ತು?
ಅವರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ನಮ್ಮದಲ್ಲ ಅಂತ ತೋರಿಸ್ತದೆ claimants appeal ಅಲ್ಲಿ.
ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಅಷ್ಟೇ ಬರ್ತೀನಿ. You inform him, Ashok Patil.
I will.
List on
29-1.
29.
Please.
42. Venkatesh P. Dalwai. Amicus Curie. N. Damodar.
Respondent wife in this matter, my lord.
You are for the respondent.
Yes, my lord. Wife.
You are party in person, Murali Krishna.
14% and Venkatesh
Venkatesh
Dalwai,
Dalwai,
amicus curiae ಆಗಿ appoint ಆಗಿದೆ.
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? No representation for the appellant urgent. ಏನಾದ್ರು ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
There is an urgency, my lord. He has sought for, our execution petition has been stayed.
ಸ್ಟೇ ಆಗಿದೆಯಾ? ಏನು interim alimony is granted?
Alimony of 50 lakhs has been granted. Against that itself,
That
the
is
appellate
stay?
been filed.
Unconditionally stay ಆಗಿದೆಯಾ?
I have given a condition, I mean, I given undertaking that we will not prosecute the execution petition based on that.
They have not deposited any amount, any
No,
part.
no, my lord.
Relationship is not disputed, no?
Relationship is not disputed. The only the contention they are stating that, my lord.
So far as alimony, what is their grievance? Appeal memo runs into
Asset and liability itself, last occasion,
740 pages.
on the last occasion, my lord, he contends that he doesn't have any income. On the last occasion, this honorable court has directed both the parties to file asset and liability. And asset and liability, we have filed it, my lord, on the basis of the asset and liability which has been filed by the appellant itself. Within the span of 8 months, there is a transaction of 25 lakhs, my lord, and he has deposited also FDs also out of the only one bank account. What he has submitted before this honorable court along with asset and liabilities, it shows that he has made the FD also 25 lakhs, my lord, within the span of 4 months, my lord. And other accounts where he has been doing the transaction, that details he has not furnished.
Petition was on the ground of cruelty.
But whereas,
Cruelty.
My lord?
Petition was on the ground of cruelty.
yes, my lord,
Petition was sought on
yes,
the
my lord. After the marriage, my lord, he has not paid any single money towards her maintenance. All along, she used, the wife used to get the money from her parent.
It's permanent alimony.
But regarding, so far coming into the 50 lakhs as the permanent alimony, since we did not have any proof regarding his income, my lord.
Okay. Now, even this is not deposited. And you are undertaking that you will not precipitate the matter.
Yes, my lord.
2022 ದಲ್ಲ ಅದೇನು? When did
ತಾವೊಂದು
it
ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ
Huh?
ಎನಿ ಡೇಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಇಫ್ ಫಿಕ್ಸಸ್.
list this matter ಅಂತ ಅಷ್ಟೇ ಆಗಿದೆ. ಹೋದ್ ಸರಿ ಬಂದಿದ್ರ ಹಿಂದೆ? Learned
How
amicus
Sami?
curiae.
Their contention is that
Why amicus curiae is appointed?
because the amicus curiae, he has filed a synopsis also. Their contention is that, my lord, because he voluntarily abandoned the
No, no.
proceedings, my lord, after
Civil case, why the amicus curiae was appointed?
a party in person bandre,
Legal service
the
authority.
party in person, my lord, the party in person is,
Legal service
your
authority.
lordship may kindly recollect that there was, before the chief justice, there was a petition which has been filed regarding that PIL, my lord, and the chief justice, he wanted to, the honorable chief justice, my lord, he wanted to see the party despite that it is being withdrawn. He is the very same party. He has filed nearly about 16 PCRs and 14 cases, my lord, against the party, my lord. And he claims to be that he, and after this petition also, he has filed another 2 petitions.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂಡರ್ಟೇಕಿಂಗ್? ಇಲ್ಲ ಅಂದ್ರೆ will permit you to execute that.
ಅಲ್ಲ ಅವ್ರು ಒಂದ್ಸರಿ ಇದ್ ಬಿಡ್ಲಿ ಅಂತ amicus curiae, let him also make a submission.
Amicus curiae is unwell ಇದೇನು 2022ರಿಂದ? He was appointed in 2022.
Yes, my lord, but because of various reasons, it has been adjourned, not because.
No representation for the appellant. As a final chance, list down. ಅದನ್ನು ಬರ್ಕೊಂಡು ಬನ್ನಿ. Now counsel for the response submits that the appellant has not even deposited the interim, permanent alimony awarded.
Yes, my lord.
As a final chance, list down.
23-1.
Majju.
Bill number 43, Giri Mallayya, Janardhan Reddy. Forty-three.
43 none appears. Total mood ಅಂತ ಇದೆ, ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ? No, the matter is moved. None appears. List.
Giri Mallayya.
Giri Mallayya is claimant. List after 2 weeks.
Cell number 44, Satish Shetty, C.R. Ravishankar.
None appears. List after 2 weeks.
45, Mahesh Shirematat, Aditya D.
For appellant, my lord, praise time, my lord. Final hearing.
You pray time, permanent element. You have filed application. As requested by the appellant's counsel, list after 2 weeks.
Lord, a date may be fixed, my lord. There's an interim stay granted by this court with regard to the decree, divorce decree. Please, my lord. And
And
thus,
it's 2022 matter, there are 2014 matters.
11 years after desertion, my lord, this is coming up on the earlier instance also, the earlier bench had heard this matter, my lord. The petitioner had filed a suit for, filed a petition seeking for restitution of conjugal rights, my lord. That was not honored. Based on that, he approached for divorce and the same was granted, my lord. Then later on, they filed this appeal and now the matter has been stayed by this honorable court. The
Husband had filed restitution.
husband has filed both the petitions, my lord. First, he filed the restitution. After the restitution order, when they did not comply with the restitution order, after almost 2.5 years, he filed the divorce petition, which came to be allowed by this court. The restitution order was, they were placed ex parte, my lord. However, in the divorce, they
Restitution is an ex parte decree.
that was an ex parte decree, my lord. However, in the divorce, they contested the matter. And after contesting the matter only, the trial court had order for divorce, my lord. Therefore, a date may be fixed, my lord, please.
As requested, list on 2 weeks and no urgent hearing.
29-1.
Please.
Cell number 46, Kempegoda CM, Venkatesh R. Bhagat.
That was admitted, that was moved by that. The visiting right, the father petition was dismissed. The child now is in the custody of the grandmother. 65 years.
Today we are seeing only these kinds of. She is 64 years.
That was moved for the giving interim, the visiting right. File an application.
ಅಯ್ಯೋ 1 of 2022 ನಲ್ಲಿ ಹಾಕಿದಿರಲ್ಲ, ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ.
Adenaito, the trial court was
Your petition is dismissed.
petition dismissed, my lord. The petition was filed, the child was at the age of 7 years, my lord. 7 months. The mother, the wife of the petitioner, the mother of the minor child, my lord,
She was committed suicide in the mother, her parents also due to she was suffering from the ailments. So she was
So
filed.
you are involved in a criminal case 376 ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಅವ್ರದ್ದು ಮುಂಚೆ ಇತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ ಅದೊಂದು.
Petitioner was in custody.
Prior to marriage ಇನ್ನೊಂದು ಕೇಸ್ ಇತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. That was the.
ನಿಮ್ಮ antecedent ಸರಿ ಇಲ್ಲ
ಅಂತ ಅದನ್ನೇ
ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ನಮ್ಮ ಸುಳ್ಳು ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ರು.
Involved in another CC case ಅಂತ ಯಾವ್ದೋ ಇನ್ನು Excise Act Karnataka.
Excise Act ಆಗಿರೋದು the respondent and their husband ಮೇಲೆ ಅವ್ರ ಮೇಲೆ
ಅವ್ರ excise ನಿಮ್ಮ 376 ಬ್ಯಾಲೆನ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಅವ್ರ ಮೇಲೆ ಇವ್ರ ಅಲಿಗೇಷನ್ ಇದು.
No representation for the appellant. ಅಲ್ಲ ನೀವೇ appellant, sorry, respondent. List on date. We'll consider today not possible.
29-1.
29.
Still number 48, P.N. Rajeshwara, Arun Govindraj.
I appear for the respondent in this case.
I appear for the appellant, my lords.
Yes, my lords, was admitted in 2023 November. Thereafter, my lords, several efforts were made by the coordinate bench of this honorable court to see if there is any amicable settlement possible. My lord, that has not happened. Moreover, my lords, no restitution of conjugal rights have been filed by the wife. The husband's petition for divorce was granted on the grounds of cruelty. They've hardly lived for a couple of months, my lords. 2017 matter. Please.
My lords, criminal proceedings are pending against the husband and the family members where they are evading notice.
Where are you, madam? We are not finding you.
My lords, my video is on. I don't know, some issue with my laptop. My video is on, but still I see that I'm not visible. I need to get it checked, my lords. I apologize, my lords.
As requested by the appellant's counsel, list on. We'll give a shorter date.
Shorter date.
One the other one by
25-1.
I can make one more.
Saturday are the sitting day.
24th.
20.
My lords, first week of Feb, my lords.
This year or next year?
My lords,
Next.
my lords, February, my lords.
17 matter have to come and argue.
Yes, my lords.
Matter was listed on a couple of occasions. It is not listed. It is taken up on the top of final year English.
Learned counsel, we have 2014 appeals in matrimonial cases. ಆಯ್ತು ನಿಮ್ದು 2017 ಮ್ಯಾಟರ್ ಅಂತ ಶಾರ್ಟರ್ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. Original case
24-1. Still number 50, D. Vijay Kumar, Jagdish H.T.
Much obliged, my lords.
Application for trial of amount.
You appear, sir? Yes.
I'm for the respondent. I an application for trial of amount.
ಏನ್ ವಿಜಯ್ ಕುಮಾರ್ ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ ಎಲ್ಲೂ?
Hearing on
ಯಾರಿಗಾರ ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳೋದಾದ್ರೆ ಅಪೇರ್ ಆಗ್ತಾರೆ ಅವ್ರು. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್. ಏನ್ ಇದ್ರಲ್ಲಿ ನಿಮ್ಗೆ ಯಾವ್ದು ಪೇಮೆಂಟ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಪೇಮೆಂಟ್ ಆಗಿಲ್ಲ. ಸೊ ಇಂಜುರಿ
ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ ಅವರು?
ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಸ್ ಕ್ವೆಶ್ಚನ್ ಬಟ್ ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್.
ಅಂದ್ರೆ ಏನ್ ಮಾಡಿರ್ತಾರೆ ಗೊತ್ತಾ, ಅವಾಗ ಬಂದಾಗ ಲಯಬಿಲಿಟಿ ಕ್ವೆಶ್ಚನ್ ಅಲ್ಲಿ ಇದೆ, ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಪ್ಯೂಟ್. ಇದು ಕೇಸ್ ಆಫ್ ಇಂಜುರಿ.
ಕೇಸ್ ಆಫ್ ಇಂಜುರಿ.
How much is awarded?
That is awarded by the Parental matter.
17 lakh.
17 lakh. 30,700.
30,700. ಈಗ ನಿಮ್ಗೆ nothing is released to you?
No madam. Nothing amount.
No representation for the appellant. Counsel for respondent submits that at least IA 2 of 2024 may be considered. For consideration of IA 2 of 2024 list on ಆಯ್ತು. INL ಬರೀತೀವಿ.
Please.
ಹಿಂದೆ ನಾವೇ ಏನಾದ್ರೂ ಆರ್ಡರ್ ಮಾಡಿದೀವಾ? Shall be taken along with the main matter.
Along with main ಅಂತ ಆಗಿಲ್ಲ ಅಲ್ಲ.
ಮಾಡಿದ್ವಾ ಹಿಂದೆ?
ಇಲ್ಲ ಇಲ್ಲ ಮಾಡಿಲ್ಲ. Posted for final hearing ಅಂತ
ಮಾಡಿಲ್ಲ list on.
Please.
15-1. Still number 51. Yes, Krishna Kishore.
Nobody has appeared in your matter. All served unrepresented respondents. Right, we'll see whether any of them are minors because response served unrepresented. ಆಲ್ ಬೋತ್ ಒಬ್ರು ಯಾರೋ 9 years ಅಂತ ಇದೆ ಅಲ್ಲ, ಮೈನರ್ ಇದ್ದಾರೆ. So if their guardian fails to appear, then you have to seek appointment of the court guardian ಅಲ್ವಾ? Narasimha minor represented by grandmother Jayamma. Respondent number 2 was representing him before the tribunal. Now she has not appeared here. No sir. Seek the appointment of the court guardian to her. Him. The record show that respondent number 1 is minor and he was represented through his grandmother, respondent number 2. Despite service of notice, she has not turned up to protect the interest of minor respondent number 1. Therefore, you file an application for appointment of appellant shall take steps for appointment of court guardian to respond number 1. List after 2 weeks. Yes.